Okay. Where's my phone? Good afternoon, everyone. Welcome to Economic Matters. Today is Thursday, February 26th. Welcome to our 1 o'clock bill hearing. Sorry for the slight tardiness. For those of you who may be new to Economic Matters, if you're coming before the committee to testify, please know that unless you're the bill sponsor or the legislator, those who will be testifying will only have 2 minutes. You will be timed. If by chance you are caught by the clock, please, we ask that you summarize quickly and succinctly. We are listening. We don't want people going through their script. It's actually kind of better if you just speak from the heart. It usually gets across a point better. With that said, I will let folks in here know that we have 113 witnesses for the day. So we would also ask that, I'm also asking my colleagues, ask the questions that they need to ask. Please direct them to whom you'd like to be asked to. And if we could not repeat one another, that would be helpful, and keep our deliberation brief. Also, for those who will be testifying, if you happen to be saying the same thing the one before you said, you could always say me too or ditto. That's always helpful. Also, if you did not sign up to testify or not on the witness list, unfortunately, you will not be able to testify. There's a fair process, a timely process, and it also is cumbersome on staff to keep adding people to the witness list. With that said, for those who have bill panels, if your panelists did not sign, please do not bring them up to the panel just because you want them to be on your panel. We respectfully request that. Also, we have a set of decorum here in the committee room, respectful of you and you of us. With that said, let's get started. The first bill is House Bill 993, my bill. So Delegate Queen will be presiding as we present. And if my panel could come up with me. Okay, thank you. Good afternoon, colleagues. I am here for the record, Chris Valderrama, to present House Bill 993, Real Property Short-Term Rentals. This is not a new bill. I brought this before this committee last year. Simply, this legislation seeks to allow tenants to offer their rental property as a short-term rental, and as may be done through Airbnb if they so chose. But only they would be able to do it if the municipality or county allows short-term rentals by the property owners. The bill further states that the property owner has the absolute, and I want to emphasize absolute, discretion to veto short-term rentals under this legislation, regardless of the plain language of a local ordinance or regulation. So similar legislation was passed by our counterparts across the way in Virginia 2 years ago, and it was signed into law and made effective July of 2024. So here in our state, Montgomery County also adopted this provision into their county code, which also became effective of July 2 years ago. And so in doing so, the county council recognized that rental units are disproportionately non-white and a prohibition against short-term rentals by lessees, I should say, cuts out approximately 35% of those Montgomery County households from the extra income that a short-term rental could earn. Their council also noted that such a restriction has a racial equity element. Finally, the council also recognized that many rental agreements prohibit sublets, which would be enforceable absent the landlord's assent to the short-term rental. So overall, to summarize the bill, and highlighted that House Bill 993, it does 3 points. The legislation does not limit a county or municipality from enacting short-term rental regulations. Number 2, it does nothing to overturn a lease's express sublet prohibition. Property owners will still have the ability to not allow short-term renting in their property. And 3, it allows local jurisdictions to limit tenant hosts to 1 short-term rental unit per jurisdiction. I want to add, and it was brought to my attention by the advocates here. So there is an organization called National Association of Real Estate Brokers that I believe was somewhat in opposition last year, but now they have a letter of support, which I can provide copies if you so choose. It was not able to be uploaded into our laptops in a timely manner, but their issue with it last year was the issue of disparate impact on communities of color. But they do have a written letter of support that if you would like, I can have it distributed or I'll distribute it myself. With that said, this legislation would provide an important source of income to our Maryland renters who Airbnb determined are, and with this said, 60% female, and who earn an average of $13,000 in additional income through short-term rentals. So as a woman and a woman of color, I would urge you to move favorably on House Bill 993. Thank you. I'll turn it over to my panel. Madam Chair.
Good afternoon, members of the committee. Jamie Gregory here representing Airbnb. And in the spirit of keeping things moving, the chairwoman's testimony was very complete. So I'm just going to highlight two things real quick. This does not prevent a local jurisdiction, as stated, from regulating short-term rentals, and it does allow local jurisdictions to limit a tenant to 1 unit per jurisdiction. So this really is just to benefit, economically benefit tenants.
Madam Chair, members of the committee, I'm Kathy Bircher with Airbnb. I actually don't have a prepared statement. I'm just here to answer any of your questions that you may have. We are very grateful to the patron for bringing this bill forward.
Person on your panel, Brianna January, or is that different? Okay, we'll let her come after. She'll come after. Okay, any questions? Okay.
Thank you. Thank you.
Thank you, Madam Chair. Esteemed Committee, Brianna January with Chamber of Progress and strong support of HB 993. And we thank the Chair for her tireless work around this issue. I'll just add a me too. Our written testimony does outline the impact to Hispanic and Black homeowners in particular. In essence, when you allow renters to offer their homes for short-term rental, it means that they can afford to stay in those homes. And by having renters afford to stay in their homes, the property owners can then also afford to pay for their mortgages and property management. So we see these issues as one of affordability and equity. With that, we urge you to pass the bill. Thank you.
Seeing no questions, thank you, Brianna. We do have a virtual favorable, Margaret Durkin.
Good afternoon, Chair Valderrama and members of the committee. My name is Margaret Durkin, and I'm with TechNet, a tech trade association. TechNet is happy to support House Bill 993. We submitted written remarks, and thank you for your work on this issue.
Thank you, Margaret. Seeing no questions, thank you very much. We'll now go to the opposition. Bruce Bariano. Bruce? Okay, Bruce is not here. We do have an informational witness, Brian Onlu from AOBA.
Good afternoon, Madam Chair, members of the committee. Brian Anley with the Apartment and Office Building Association. I was hoping to come in favorable on the chair's bill, but we couldn't reach a consensus on it. I will say that, as the chair noted, Montgomery County already allows this, as do other major cities, including San Francisco, Los Angeles, San Diego, Portland, on and on. And while I don't have data on exactly how many renters are doing this in Montgomery County, I did a quick internet search, various platforms, and found that there are a few hundred listings. I can also tell you that some of AOBA's largest members already are doing this or allowing their tenants to do it in other jurisdictions. And in the jurisdictions where they do this, a typical host can earn a couple $1,000s a year, depending, of course, on the market, how much the units are for, the activity, attractions in those markets. And so for these reasons, we happy to share that informational testimony. Thank you.
Thank you. No questions. Thank you very much. There are no more witnesses. That concludes the bill hearing on House Bill 993. I would move on to the second one. Chair just notified me, but she is wrapping up in her committee. So let me move on real quick to, let's see, is Delegate Corman here? Chair Corman? No. Okay. Is there any? Oh, let's see. We'll move on to Delegate Bhandari. Are you able to? With House Bill 850? Yes. Thank you.
Good afternoon, Madam Chair, Vice Chair, and members of our wonderful Economic Matters Committee. For the record, I'm Delegate Bhandari. I'm here as a sponsor of House Bill 850, Home Builders Open House Self-Representative Disclosure Requirement. HB 850 is a very simple consumer transparency bill. At its core, this bill is about one simple principle. Our state home buyers deserve to know who represents them before important decisions are made. It does not regulate prices, contracts, or compensation. It does not change who represents whom. It simply ensures that buyers are clearly informed at the very beginning of the process about the roles of sales representative they are speaking with. Today, when a licensed real estate agent hosts an open house, our state law already requires a clear posted sign stating that the agent represents the seller and that buyers have the right to their own representation. However, that same level of clarity does not exist when a consumer walks into a new home model or builder open house. In those settings, prospective buyers often have detailed conversation about pricing, incentives, upgrades, and financing before any paperwork is signed. Many buyers reasonably assume the sales representative is neutral or working in their interest, when in fact that representative works for and owes a duty of loyalty solely to the builder. HB 8050 closes that gap. The bill requires that when a builder holds a property open to the public, a clear notice be displayed, stating two straightforward facts: that the sales representative works for the home builder and owes loyalty to the builder, and the buyer has the right to obtain independent representation. The bill also ensured the notice is actually readable with simple fonts, minimum letter size, and unobstructed placement. So this is not buried in fine print or discovered after the fact. I want to emphasize what this bill does not do. It does not prohibit builder sales representative from assisting buyers. It does not require builder to contract with or compensate buyer agents, and it does not create new licensing requirement. It simply ensures informed consent and consistency across our state real estate marketplace. At its core, it is about making sure Maryland home buyers know who is sitting across the table from them before important decisions are made. With that, Madam Chair, I respectfully request a favorable report on House Bill 850, and we have a representative from a Realtor Association testifying on this bill.
Thank you, Madam Chair. Lisa May with Maryland Realtors. As the delegate mentioned, this bill is really about consumers not knowing what they don't know. And once upon a time, very similar concerns were raised about real estate licensees and open houses, and that led to the statement that is posted now currently that Delegate Bhandari mentioned. In our written testimony, you have a link to what that statement looks like for real estate licensees. I understand that there may be some amendments being worked out with the Builders Association. We are happy to take a look at those, but we are very supportive of the spirit and intent of this bill and hope that we can come together on a solution. Thank you.
Thank you. We'll start with Delegate Pippy.
Thank you, Madam Chair. Delegate and Realtors, good to see you. Lisa May. So I do have a question, and maybe you can help me with this. So as you probably know, in August of 2024, there was a National Association of Realtors settlement that impacts, I don't know, compensation, licensing, realtors. And so in looking at the testimony, the builders toward the bottom of it had some concerns related to an obligation to pay a commission. So if you could address that part and how those two things mesh.
Certainly, and thank you for that question. Yes, there was a national settlement, and it was nationwide with the National Association of Realtors and a lawsuit that was brought in the state of Missouri. One thing to remember with that settlement is that state laws varied. And Maryland already had laws on the books regarding compensation, disclosure, written agreements. So not a whole lot changed with that settlement here in Maryland. Really what changed was how compensation could be advertised within the multiple listing service. That was really the only change that happened. So really nothing legally changed as a result of that settlement here in the state.
So then just back to the builder's letter, I know you said there might be some amendments coming. What are the thoughts there on that piece?
I would just say from our standpoint, compensation is negotiable between all of the parties, both in amounts and who is responsible for paying that.
Okay. All right, thank you.
Seeing no further questions, thank you very much, Delegate Bhandari. That concludes the
Thank
bill
you.
hearing on House Bill 850. Colleagues will now jump back to our second bill on the docket, House Bill 774. Welcome Chairwoman Wilkins for House Bill 774, and bring up your panel. Is that Councilmember Crystal Oriata, Secretary Day, Cheryl Blackwell-Renter, Zafar Shah, Nina Themelis, Dr. Howell.
Thank you so much, Madam Chair. Greetings, Madam Vice Chair, and hello to all of my esteemed colleagues on this committee. Wonderful to see you. And Madam Chair, if it's okay, I wanted to flag that I think Councilmember Oriata may be virtual. I'll go ahead and jump in. Good afternoon again, colleagues. For the record, I am Delegate Janelle Wilkins, and I'm pleased to present Good Cause Eviction, House Bill 774. HB 774 is a statewide enabling bill. It authorizes Maryland's counties and the city of Baltimore to enact good cause policies that would require landlords to provide a justifiable reason for a lease non-renewal. The bill outlines 10 good causes, which include things like substantial breach of lease, the tenant having issues around disorderly conduct that disturbs the peace and quiet of renters, the landlord removing the property from the market, habitual late payment of rent, substantial repairs to the property, and other good causes. This bill passed the House in 2024, and we are working to ensure final passage this year with the support of this esteemed committee. At its foundation, good cause is about the right to stable, secure housing. Housing is not an ordinary transaction or business. It is a foundational aspect of health, education, employment, and safety. Losing housing destabilizes families, it disrupts children's schooling, and it increases the risk of homelessness. That impact expands beyond the individual tenant, and it impacts the entire community, as well as the government that often has to step up to provide services and help. A renter who is paying their rent and following the rules should have a stable and secure place to live. And when a landlord decides not to renew a person's lease, it should be for a reason. An eviction of any kind is debilitating to any of the families that we represent, and it's important that we have a standard in place for every type of displacement, including lease non-renewal. HB 774 applies to landlords of 6 or more units, and it also exempts owner-occupied units. Landlords already have to provide written notice to not renew a lease, and this bill ensures that a reason is provided. Good cause eviction is the law in cities and states across the country, colleagues. This is not a new concept that I'm bringing you. Colorado, statewide. New Hampshire, statewide. New Jersey, statewide. Oregon, statewide. California, Washington have mandated good cause eviction. Colorado's bill passed just in 2024. Many cities across the country, including Washington, D.C. and New York City, also have good cause eviction requirements. I urge your favorable report on House Bill 774.
Thank you, Madam Chair. I will just remind your panel, because I don't think any of you were in here when I went over my introduction. Except for the bill sponsor, the legislator, everyone gets 2 minutes. If you're caught by the clock, we respectfully ask that you summarize. Thank you.
Chair Valderrama, Vice Chair Charkoudian, esteemed members of House Economic Matters Committee, so great to be with you today. For the record, my name is Jake Day. I have the honor of serving as Secretary of Housing and Community Development for the state of Maryland, and I'm here to testify in support of House Bill 774. I want to thank Chair Wilkins for sponsoring this legislation and for her continued leadership and partnership on this issue. As noted, this bill would enable local jurisdictions to prohibit landlords from terminating a household's lease without good cause. There's been considerable discussion on this matter over the last few years. Just as the department strives to advance policies that increase housing supply and affordability, our agency is equally dedicated to protecting rights and shelter for renters, particularly vulnerable populations in our state. In 2024, Governor Moore signed the Renters' Rights and Stabilization Act into law. That act, wisely passed by this body, significantly reformed the rental landscape in Maryland, adjusting eviction filing fees, capping security deposits, and providing renters with a pathway to home ownership. It also created the Office of Tenant and Landlord Affairs, which has been staffed and populated since within the department to centralize resources and access to help resolve renter-related issues. This is the office that is charged to help with implementation of House Bill 774. And I assure you we are ready, willing, and able to support the implementation of this piece of legislation. The key concept behind the RRSA and this bill is stability. Stability for households, stability for communities, stability for Maryland families. House Bill 774 will keep renter households from losing safety, security, and stability for their home unless it's for an appropriate and stated reason. Even with capped fees, even in the best of circumstances, there will always be a cost for some kind of material hardship in securing new housing, not to mention the disruption that is caused to that household. I'm sure every member of this committee has had to move at least once or twice in their lives, and you know that that cost is real on all of us. And that's when you actively decided to move somewhere, not when it was thrust upon you. But think about the single mother on a month-to-month lease. She's been a model tenant, played by all the rules, and then she is asked to leave. She is told she has to leave. This is an immediate disruption on her life. I believe that this legislation ultimately sets clear rules, clear boundaries, and offers local government the flexibility and implementation that each would like to have for themselves. And for that reason, I urge a favorable report.
Madam Chair, members of the committee, Zuffer Shah from Maryland Legal Aid, we urge a favorable report on the good cause eviction bill. 30 to 40% of households in Maryland are renters, and they currently live under the rule of no cause eviction. And this is how, I want to tell you how no cause eviction works for landlords. They know it's unlawful to discriminate. They know they're not allowed to retaliate. They can evict for non-payment, but the tenant may pay to stay. They can evict for alleged lease violations, but then they actually have to prove those allegations. So how did they just make the unit vacant as easy as possible? Well, they just send a notice to vacate. They wait 60 days or until the end of the lease. The notice doesn't have to explain, and they won't have to explain anything before a court. This month in Frederick in District 3, a week after our client's lease ended, the landlord filed their case, a tenant holding over case. And 6 days later, our client was served for a trial date, which was held 3 days later, so 9 days in total. Our client wanted to argue that the landlord was retaliating, but in the hallway of the district court, the landlord showed our staff the documents making evident that there had been unauthorized visitors, complaints of smoking, and other violations. So we settled the case. Would it have been longer, costlier, any different if we had good cause eviction under law? No. It would have been the same process. Give notice, wait, pay the same filing fee, follow the same trial schedule. Even under good cause eviction, the rules of the proceeding would have favored landlords by prohibiting interrogatories, depositions, and requests for document production. Among hundreds of tenant holding over cases, our clients who had good cause eviction under federal regulations, compared to other clients who did not have those protections, for them, our rate of contesting cases at trial differed by single percentage points. We urge a favorable report.
Good afternoon, Chair Valderrama, Vice Chair Charcuti, and members of the committee. My name is Nina Themelis. I serve as Director of Government Relations for Mayor Scott in Baltimore City, here to testify in support of House Bill 774. This piece of legislation is particularly important for Baltimore City because over half of the residents in the city are renters. And housing stability and certainty is so important to make sure that people know where they're going to be able to lay their head at night, and that if they have to move, that they have enough time to do so, and that there are reasonable parameters for when those choices are made by landlords. In 2021, the City Council passed a bill that would have provided for good cause evictions. However, our law department was not able to sign off on the legislation because of the inability to enact local laws. So this bill will allow us to then move forward again and pass good cause eviction laws in Baltimore City. I think that the sponsor and other members of the panel have made all the additional points that I would like to make. So for those reasons, I would just urge a favorable report on House Bill 774. Thank you.
Good afternoon, everyone. First of all, I'd like to thank God for letting us all be in this setting today. My name is Cheryl Blackwell. I'm 59 years old, and I've been living in my home with my husband, who's bedridden. He's 77 years old. I have an autistic granddaughter who's 10 years old, and my son who has mental health problems. In the recent years, I've had 2 to 3 new property managements. I had a major roof leakage. I had hot water heater problems. And then I had, in the basement, it was cracks and holes where rodents was coming in through my house from outside. And with the leakage on my roof, on the second floor, it was causing it to cave in. I had major water coming in through my house from this water leakage. And then after that, the new property management, after I told them about these situations, I then received a notice that the new property manager was taking over. I communicated them about the issue of the property and the $4,900 I paid out of pocket to have my roof fixed and a hot water heater. And I received a notice that they wanted me to be out of my house in 60 days. I was confused about the conviction because what did I do to be put out of my home? I paid my rent on time. I kept my home clean. There was no nuisance caused, no reason to put me out. The truth was they were retaliating against me for wanting to have my home safe. It caused me to be stressed. It caused me to have, I was really stressed. And then, I'm sorry, I was incredibly stressed at the thought of having to move. My family has a fixed income. We live off my husband's Social Security and pension. The rent everywhere the rent everywhere I looked was unaffordable. Additionally, the thought of having to uproot my granddaughter from her school, my bedridden husband from his home was truly unthinkable. I knew that I had to fight for myself, my husband, and my granddaughter because I was being punished for exercising my right to live in a safe home. Unlike many other tenants, I was able to obtain legal representation with when the landlord filed the eviction case against me. My attorney helped to settle the case because of a technical issue with the landlord's case.
Ms. Blackwell, I thank you for sharing your story. If you would like, just tell the members exactly how you feel, and
Okay.
then we can get your point across.
Okay, I just feel like that the landlord should have a good cause for having us to, having a 60 to 90 day, to have you being evicted. Whether it's not paying the rent on time, being a nuisance, or whatever the case may be. So I think this good cause is very important for the people that's not doing anything wrong, paying their lease on time. And
Thank you. See,
Okay.
it got straight to the point. Thank you so
Okay.
much for sharing your testimony.
All right.
Great. Thank you for the opportunity to participate in today's hearing. My name is Catherine Howell. I'm an associate professor of urban planning at the University of Maryland, and I direct the National Center for Smart Growth at Maryland. In addition, I have more than 20 years of expertise in housing as both a researcher and a practitioner. And I think, look, good cause is a critical tool for the prevention of displacement and the acknowledgement that renters have a critical stake in their communities. Researchers from the University of Minnesota conducted the first analysis of the impact of good cause eviction protections on development. And the analysis finds no evidence that the introduction of good cause eviction protections in California, Oregon, and New Hampshire have resulted in a decline of new construction. Additionally, pre-existing research found that good cause protections can lead to a statistically significant decrease in evictions and a decrease in displacement overall. At the same time, economists have recently found that rent stabilization can directly reduce rent prices by 4 to 6% and does not reduce the supply of housing. In other words, rational rent stabilization along with good cause can create predictability for renter households, something that I'm sure we all want for our families. By knowing that if they follow the rules, they can stay in their homes, parents can engage more comfortably in their children's schools and their neighborhoods. More importantly, they can relax and plan for the future. I know that this moment has been challenging for developers trying to build due to widespread rising costs of development and operation of housing, including land, labor, materials, and insurance. But using tenants as a stand-in for conflates correlation with causation in the data. This piece of legislation is particularly important for our backyard at the National Center for Smart Growth. The Purple Line Corridor in Montgomery County and Prince George's County has historically held some of the most affordable, unsubsidized rental housing stock in an otherwise high-cost region. However, research has shown that residential rents within a half mile of the line are already rising at a disproportionately rapid rate, even before rail service begins. So this means that if you are put out in many of our communities, there is no replacement housing. So I request a favorable report. Thank you.
Thank you. And we have one more who is virtual, our Prince George's County Chair, Crystal Oriata. Hi there, Madam Chair. You may begin.
Hello. Thank you for having me here today. I'm Councilman Crystal Oriata. I have the pleasure of chairing the Prince George's County Council. Thank you to the chair and the vice chair, and especially thank you to the sponsor of this legislation who's been working for years to get this legislation passed. And I've been a supporter even before I took this office, because this legislation is about how we guarantee affordable housing. We can't continue to have the conversation just around development without legislation like this that ensures stability for our renters. We know across this country, and we're not immune to it here in Maryland, that sometimes we have people that are being evicted for no reason. And so this legislation is a perfect balance. One, it allows enabling legislation. So every jurisdiction like mine, we know what's best for our region. And it also allows a balance between the industry and the renters. We understand that people might not pay their rents on time and they might cause harm to that community. And this in no way takes the right away from those landlords to enact their right on their businesses. But we also know renters need stability. That we also know that sometimes it could be profits over people. And the reality is that as government, it's our job to stand in the gaps. And this legislation does that exactly. It still allows autonomy for industry, but protects our renters so that they can have stability. We have to imagine, a lot of us are homeowners, and imagine if we could do everything we're supposed to do, and there was no protection that would rip that home away from us. That's what's happening to renters. These are their homes. It doesn't matter if you're paying rent or if you're paying a mortgage. So I hope that we can stand with our renters today in a real way and give them the protection that they need and allow the local jurisdictions to stand up for them. So I hope that you can vote favorably on this legislation, and Prince George's County stands behind it. Thank you.
Thank you, Chair Oriata. We'll begin with questions, and we'll start with Delegate Pippi, then Adams, Andre Johnson, Ampry.
Thank you, Madam Chair. Delegate, good to see you. Secretary, good to see you. A couple technical questions. If there is a standard one-year lease, right? And if that lease period has expired and adequate notice was given that there was no intent to renew the lease, under this bill, if the tenant only, let's say, was late on 3 payments and the landlord, in writing notified them of those 3 late payments, would that be sufficient to end the lease under this bill?
So under the legislation, the way that it would work, and again, the point of this bill is to make sure we have a standard when we decide that someone loses the roof over their head. So in that instance, if a landlord decided not to renew the lease after the year, they have to give the sufficient notice that's already required, and they would have to provide a reason. One of the reasons outlined in the bill is late payment more than 4 or more times. So if you are saying that in this example, it's 3 times, this bill is making sure that, again, we have a great standard. So for example, if someone, it's hard times for everyone when it comes to payments right now. Someone's late once, if someone's a little late twice, we don't have that as a reason in this bill when it comes to not being able to stay in your home. So hopefully that
Sure. So just so I know, so it's clear to me. So in the event that there's a 1-year lease and the tenant, let's say, is late 3 times and the landlord notifies them of them being late 3 times, but not 4 times, in that case, the landlord would not be able to end the lease after the lease term expires with this bill. Is that correct?
So late is 1 day, and yes, in this bill, it was 4 times. We allow 4 times of someone to pay their rent a day late, a couple days late. Your rent might be due on the 1st, and in difficult times for everyone and how people might be getting paid, your 2 weeks or your monthly pay, we do allow 4 times of late rent in this bill. So in your example, it would not apply. Good cause would not have been met under this bill.
All right, so a second scenario is you have a landlord that owns some rental properties and has them rented out for a year. And the term is coming to an end, the year is coming to an end, and the landlord would like to renovate the properties. And it's approximately a 6-month renovation, cabinets, countertops, carpets, not a year, but just 6 months. So in that case, because the landlord is not taking the property out of the rental market, because once the properties are upgraded, he wants to re-rent them, would that qualify to end the lease under this bill?
Thank you, Delegate. We do have 10 very excellent reasons that are outlined in this bill. There's one that deals with renovations, and I think that it mentions that the renovations should be substantial and that they're about a year. If you're interested in making that a shorter time period for your example, but right now the legislation, one of the good causes is that we don't want someone to lose their home because there's minor repairs that are taking place. I'm doing a renovation right now, a minor one at my own home, and there are lots of renovations that take place. If I had a renter, we want to make sure that they're able to stay in their home, and so that's why we put a year. Every single one of these reasons has been carefully thought through over years. They reflect, colleagues, the reasons that are throughout the country. These reasons that we have for good cause are not reasons that we just made up ourselves in this bill. These reflect the places like Colorado, places like New York City that already have this, Washington, D.C., around what good causes are. So we can go example by example by example, and I have time and we can do that. But I want to outline that we have to make sure we have a standard. And that's what we're getting to. And if there are tweaks that you or this committee wants to make, the legislation is in your hands. But the purpose of this bill is to make sure that we have causes, and we have 10 strong causes in this bill.
Final questions. My final bat, final bite at the apple. Madam Chair, don't kill all my bills in your committee. So here's my final question, and it's an honest question. I'm going to ask it. Maybe I shouldn't, but I'm going to ask anyways. Do you not think that the owner of a property has the right at the end of a lease to just terminate a lease?
That is an excellent question.
I mean, is that not good cause on its own? Like, it's a lease. He or she owns the property, and they want to terminate the lease. It's up.
I think
do they not have the right to do that? Sorry.
I think, Delegate, that is a great question, and thank you for asking it. I think when we're talking about housing, we have to really ground ourselves in what we are referring to. We're talking about someone's access to their life, their health, their safety. Housing is not just any commodity that you and I are bargaining and trading. This is the roof over the heads of our constituents, where they live, where children live. So this legislation makes sure that we have a standard when someone decides that that family can no longer live in that home, that it's actually for a justifiable reason. And I would also add, Delegate, that we utilize laws all of the time to protect people when it comes to housing. We have standards around notice that has to be given. You can't just kick someone out of your home, even if they are a terrible renter and causing damage. You have to go to court to evict them. We have all kinds of standards right now when it comes to housing to protect our renters. And even in the 60s and 70s, we had to pass legislation to prevent discrimination, the Fair Housing Act, because landlords said, if this person is Black, or if this person is someone who I don't like, it's my property and I don't want them to live there. And we had to step in, legislatures before us, to say that's not right. So what I'm saying to you, Delegate, is that throughout the history of this state, currently in terms of legislation that's on the books, we step in when it comes to housing, because housing is that important. I think that in this example of good cause eviction, we have to make sure that we set a standard before our residents lose the roof over their heads and their lifelines.
Thank you for answering those questions. Thank you, Madam Chair.
Thank you, Madam Chair, and Chair and sponsor of the bill. Thank you for bringing the legislation. It raises an important conversation that I think we should be having in the state of Maryland. I'm not sure that this is prescriptive for what we're trying to intend, but nevertheless, I understand why you're bringing the bill. Mr. Secretary, I have a question for you. I believe that good cause eviction exists in all of our states in our country currently. It's on every HUD project, every federally or state-financed affordable housing project, in so much as if a developer develops a low-income housing project, they are instructed to use certain leases and languages that are by definition are good cause evictions. And I would just ask, would you agree with that general principle that, number one, are good cause leases already in place and have been for a very long time on affordable housing projects that are financed by the taxpayer?
Delegate, good to see you as well. I think the way I would answer that question is to say that there's a bifurcated landscape for protections and enforcement for those who live in housing that has been subsidized and financed by state and federal government, and those who don't. And so I think your characterization is accurate that, generally speaking, there are greater protections for those who live in housing that is financed and subsidized by my agency and by the federal government. And it was indeed one of the motivations behind the Renters' Rights and Stabilization Act, is that we simply can't offer the same protections, legal protections, code enforcement, property inspection, et cetera, to those renters who are not in subsidized housing as we can those who are.
Right. So the reason why I bring that up is to literally kind of say what you just said, which is that there are two different conversations that we're having. One is that good cause eviction has existed for a long time. By definitions, are probably according to this bill, but for projects that are federally or state financed. But we are taking that framework, and we're saying now we want to make this apply to privately financed projects by private developers who have no taxpayer connection. And so I'm not sure I have a question for you. Maybe it goes more to the sponsor, which is why is it that we see the need to apply this in the private sector on non-taxpayer financed projects?
I think that's a great point that you raise, and I think what's important in what you stated is that good cause does already exist for many affordable housing properties. This is something that is pretty standard. You have to give a reason, especially with the individuals who are most vulnerable, when you decide not to renew the lease or evict them for any in any instance. And so this is something that is very prevalent, and we want to make sure that all renters, again, this is an enabling bill, so if your county chooses to do so, but we want this to be available to all renters. And it is something that's already prevalent. We're not recreating the wheel. This is something that property owners in many facets know how to do because of what you just mentioned, and we want to expand it to all of our constituents.
I just make the observation because it's far more difficult to go through the exercise of a good cause eviction when necessary. And let me say, the gentleman next to me who's an attorney, I'm getting ready to ask some questions that relate to this. And I don't think I'm out of my depth because I'm a market participant and I have a general experience with these sort of things. So let me just get to my other point, which is to say that under the bill, the landlord shall plead specific facts in the complaint to prove the statements made under the subparagraph, which are these exemptions that you're allowing, by preponderance of the evidence. And so for the good of the order here, why are we choosing that legal standard? And what I think I understand it to be is that it's a 50% threshold. You're equally concluding something did happen or didn't happen, and you're having as a landlord to prove a case not beyond a reasonable doubt, but rather by a preponderance of the evidence. And my question is, why are we applying that standard in these non-federally or state taxpayer financed projects to private developers and small landlords?
Another great question, Delegate, and I will shortly turn to the attorney.
Did we just speak on here?
I'll shortly turn to the attorney to my left, but to your point, I want to make sure that colleagues understand and are grounded in the fact that currently to evict someone, you have to go to court and get that okay from our district court system. Under good cause, you're providing a reason in the notice. And so if this is a situation that goes to court, we make sure that that's brought up and that the tenant has the opportunity to defend themselves. So that's the premise of the legislation, which you are referring to. And in terms of preponderance of the evidence level, I will leave that to the good attorney to my left to explain.
Well, okay, before he answers, and I'm happy for him to answering it, how about if I just go to the fast forward and give you the follow-up to that, which is, I don't necessarily agree that landlords end leases just because a tenant doesn't pay timely. I don't think that's the thing that most landlords do. What I do think happens is that there is a safety scenario. You bring up illegal activity as one of the examples, or there are other major violations that are happening. For example, far over occupying the units, having drug trade. I'll just say that, you know, there are plenty of examples, but they're very hard to prove in a court of law. All right, and so when you take this standard of saying, I've got to protect my multifamily community from something very bad that's going on, how do you translate that? And the attorney on the other side of these things can certainly take my point. How do you, as the landlord, protect the interest of the community at large when you're putting this legal standard in front of something where the landlord has to do things that protect the interest of the community at large? I think you're making it difficult at best to conduct business in that setting. And now I grant you the opportunity to respond to that.
Thank you, Delegate Adams. Again, Zephyr Shaw, Maryland Legal Aid. The second question first. Sure. I think that this is the issue that we have in multiple policymaking arenas. Due process is difficult. People deserve a meaningful opportunity to be heard. They deserve to have their day in court and see the evidence against them and to provide their own evidence. And I can tell you that having done hundreds of these cases myself over many years. Currently, the standard of evidence is preponderance of evidence. It's a very easy hurdle to cross. This is not clear and convincing evidence, which is kind of the second highest level in a civil case. It's certainly not beyond a reasonable doubt. In fact, doing many legislative efforts with Maryland Multi-Housing Association, I can tell you that whenever we advocates have proposed clear and convincing evidence as the standard, they've asked the sponsors to amend to bring it back down to preponderance of evidence. So preponderance of evidence is really in here just for clarity. I think this came up in prior sessions where some delegates wanted that clarity in the bill. So it's really not to hurt landlords or make life more difficult. To your point about safety, I completely agree. Look, I have clients who are asking their landlord, please, can you get this other person out? They're bringing in traffic and other unwanted things that we don't desire in our building. But the process has to be fair. I think in the example I gave, we had a client, the information that we were provided even before trial made it clear that there were issues that we were not going to prevail on. I think that when this is the last point for you, Delegate Adams, for me. Sure. When tenants do have the reasons, they recognize that they probably are better off leaving within the 60 days than having a full-blown trial. We see that time and again. So I think there are efficiencies here that you might be overlooking because it's a little counterintuitive that when you provide the reasons, people don't want to contest them.
I mean, I do want to ask my last question. Thank you, Chair, for allowing me the last question here. The point I'm trying to make, if I'm making any point out of this, is that a non-renewal of lease can be a strategy to deal with a tenant for which you can't go to court and make a case of certain serious violations, and that by saying Maryland's going to pass a law that forces you to show up in court and make a case takes away, and you might not like the tool, and maybe some landlords are using these tools inappropriately. I can tell you most landlords are going to do the right thing by tenants. I know it's hard to hear, and I guarantee you have hundreds of examples where landlords don't do that. But what I think you're trying to say in this bill is you're trying to apply a standard to all the landlords where these very difficult scenarios, not the non-payment of rent. That is not a difficult thing to deal with. Somebody doesn't pay rent, you show up in court, you get a judgment. And so can you at least, to the attorney, resonate with the general principle that there are times where a thing has to happen in a community or in a house where a landlord has to protect the interests of their own property or for their friends that live in the multifamily space, that they will never be able to show up in a court of law and prove by preponderance of evidence that that thing has occurred. Therefore, they can't actually run their business. Can I at least get that from you, that you're somewhat at least resonating with the fact
I'm
that
halfway
that
there
exists?
with you, Delegate.
That's all I needed to hear.
Yeah.
Thank you very much.
Okay.
We'll continue with Delegate Johnson, Amprey, Bandari, Wyville, and then Rose.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. And this bill seems like it's a bill that is much needed, because I get tons of calls from constituents in my community that have sort of problems like the young lady was saying about retaliation and things of that nature. So I'm thankful for you bringing this bill to the forefront. I got a question, and I think it's for the gentleman from Legal Aid. Is it possible that you can put a little bit more meat, because I understand the bill conceptually,
okay,
but could you put a little bit more meat on the bones for me in reference to how it works in practice?
Yeah. I can. Thank you for the question. So the way this bill is laid out, again, it's enabling. So the first thing that has to happen is that after this bill passes in Annapolis, a county legislature will have to decide to enact these provisions. They're going to be having to meet the standards that you all set, the 10 reasons and other provisions of this bill. They don't get to change those at the county council level. When the county bill becomes effective, what landlords will have to do if they're covered by this bill, and small landlords are not covered by this bill, owner-occupied properties are not covered by this bill, they will provide a notice to tenants that they have currently that their property is now covered by good cause eviction. In leases, they will have to state, prospectively in new leases, they'll have to state that good cause applies to the property. When they do that, provide that notice, and essentially in this bill, every time they're stating under this bill that they are a small landlord, they would provide information to Department of Housing and Community Development establishing that they meet the rigorous elements of defining a small landlord in this bill. But let's say that you're not a small landlord. I'm a landlord, and I have more than 5 units in the state. You're my tenant. You are coming up on expiration of your term, and I want you out. What I'm going to do now is, just as I would under current law, I provide you the 60-day notice that at the expiration you will need to vacate. What's new is that I will need to provide one of the 10 enumerated reasons and explain how I meet that reason. So let's say it's because at the end of last session you had a big party at the property. I got a lot of complaints, so that's my stated reason, is that you had that party. Now, you've got that information. You go down to your preferred attorney and ask them, hey, what can I do? I can't move from this place. And your attorney's going to say, well, did you have the party? And you say, yeah, we had a party. Okay, so I think you're going to have to, your attorney's going to tell you that I think you might have to settle or just move out. But you know that you met with management after that party and you said, hey, I didn't mean that party to get out of hand and be disruptive, and it was months ago, it was almost a year ago. And you didn't give me notice that I was in substantial violation of my lease, so what's really going on? And they said, well, you know, we'll see you in court. Okay, now you're served process. You get your trial scheduled. You appear with your attorney, and the landlord appears with their attorney. And what the court's asking the plaintiff landlord to do is not just provide evidence that there's a lease, that the notice requirements under good cause were complied with, but that the landlord show evidence that you had the party, okay? And they'll show their case. We have ring footage. We have complaints from other neighbors, and they put on their case. And then your defense attorney, or maybe it's you pro se, will show that, well, you had the meeting, this date, here's the emails. And this is where a judge makes a decision. They're going to decide by preponderance of evidence whether the landlord has demonstrated good cause. They will make a legal finding whether that party and the time that elapsed and the meeting of minds and the apology and all those things meet the substantial requirement. And I'll point to the language in this bill which says it's substantial violation after having received notice to cure that violation within 14 days, which in your case you would have done. There might be in the back of your mind, you might be feeling like this was actually all because the landlord, me, didn't like the fact that you voted for good cause eviction, and he was just getting to you. But that's the kind of thing that would come up already in a retaliation defense, absent good cause in the first place. You won't have to get there to prove that kind of difficult argument because you already have the good cause protection.
Thank you very much.
Yeah.
There we go. Thank you, Madam Chair, and thank you, Madam Chair, for bringing this bill forward. I think the problem that we're trying to solve here is a real problem, and I think a lot of my time as a teacher and stable housing for students is really important if we were committed to figuring that out. So I thank you for bringing the bill. I do have some questions as a lawyer about the bill, and as a transactional lawyer and as someone who loves contract law in law school. I'm trying to understand here, and maybe you can give me some examples. Where else in contract law do we have contracts where you have to provide a good cause or reason as to why the services are no longer needed or terminated. Because I'm thinking about if I have 2 kids, they're in daycare. If there's a term that you sign up for, you know, on the last day, they don't have to tell me why there's no longer the services are being provided. It's just, you know, that's the contract. So can you give me examples where we see this in contract law so I can wrap my head more so around the concept? Because I look at a lease, and we call it a lease, but it ultimately is a contract. And in contract law, this is not the normal, you know, the normal way we do business. So if you can give me some examples or a reason as to why this would apply.
So I think this has been brought up and has been top of mind for many delegates over the past couple years that we've been advancing this bill. So it's an important question. I thank you for the question. In my written testimony on the last 2 pages, I've provided the committee 5 existing laws that apply in Maryland where one party has the right of renewal absent a good cause to terminate and to allow to expire. And it's really interesting what types of laws we have here. So, of course, one is the Affordable Care Act. And in health insurance, and we've outlined this in Legal Aid's written testimony, the health insurance issuer must renew or continue enforce coverage at the option of the plan sponsor or the individual as applicable, and may non-renew only for specified reasons such as fraud, violation of participation requirements, non-payment of premiums, etc. In Maryland, for property and casualty insurance, we have much the same type of provisions, including ways for the insured to have a right of protest, to actually appeal non-renewal of their property insurance coverage. That their filing of an appeal actually stays the non-renewal. But what was really interesting in our research is that franchises have these rights that we want residential tenants to have. So we've given you examples of auto dealer franchises, beer franchises, and gasoline station franchises whose agreements, which are contracts with, for instance, auto manufacturers or distributors, with the gas station franchisors, for instance, those contracts have to renew absent cause, and that cause has to be shown. And there's a rich law here on the rights of these franchises to sue even for damages, which is not something that's included in this bill. So this is a situation where I think it's been overlooked that protection from non-renewal serves important interests. I think in the past, those interests have been guided, at least in the franchisor context, by business interests. And, you know, respectfully, I think that we should apply some of that logic to this very important issue, which is housing and housing in a time of scarcity.
Thank you. I'll review that written testimony and definitely will follow up with any other questions that I might have. But thank you so much.
Thank you, Madam Chair. Dr. Howell, I want to first acknowledge and appreciate your research and the scholarship you have brought into this policy conversation. It's very helpful for this committee to engage the evidence directly. From an economic and empirical standpoint, how should the committee understand the strongest available quasi-experimental research and literature on good cause eviction policies and their impact on housing markets? Specifically, do we have credible cause and effect, the causal evidence regarding effects on new construction, overall housing supply, and investor behavior?
Sure. So I think it's, often very difficult to say this causes this, right? That's first off. But what they do find in the University of Minnesota study is that good cause did not impact housing supply. It did not impact development. It didn't slow things down. This wasn't the thing that you know, builders are looking at, you know, down the road, investors are looking at down the road. That wasn't something that was impacting. What is much more impactful are things like interest rates, the cost of land, zoning, whether, what your environment is for permitting, how long that takes. Those were much, much stronger, and those continue throughout the research. And you can look across studies and studies and studies that those are much stronger drivers of whether or not someone will develop in a jurisdiction.
Thank you.
Madam Chair, yeah, you had said this is the fourth time this bill's been introduced, so the prior three would have been in E&T. This is the first time we've heard it. Can you give me the reasons why E&T didn't advance the bill in prior legislative sessions?
It did pass. It passed in 2024.
It did pass?
Yes,
So,
it passed the House in 2024.
all right, so in the same posture as this?
Yes, very minor tweaks.
And then
but
it
in the same-
didn't pass the Senate?
Correct.
Okay, all right, thanks.
Thank you, Madam Chair. And hi to my former colleague. I had a question. So if a landlord dies and they fulfill, let's say, the current lease for a property, or maybe even say one or two properties, maybe three, small landlord, will the family be allowed to, after the person passes away, are they going to be allowed to pull the property off the market for whatever reasons the family deems is workable for them, the heirs to the estate and the property? Walk me through that scenario.
There are specific provisions about the death of a landlord in real property code. I apologize, I have to look those up about exactly Maryland's prescription for how to deal with tenants in that situation. Under this bill, one of the specific 10 enumerated grounds for good cause eviction does include pulling the property off the market. For instance, if it was being pulled off the market as well as being transferred to one of the living adult children of the landlord, that's also a grounds in the bill. Any family member may move into the property, and that would be good cause under the bill.
Okay, so the children of the deceased, they can decide what they're going to do with the property. They don't have to lease it. They don't have to, other than, let's say, fulfilling the end of that particular lease per contract, they can decide what to do freely with that property or that 1, 2, or 3 properties. Is that correct?
I believe, almost 100%, but not quite, that is correct. And I think that this is one of those specific situations that can be worked out in favorable, friendly amendments.
Okay, because I would hate to see that to then have to go to court and then that you're going to have that on top of the settlement of an estate. So that's my concern.
Delegate Rose, two things that I think are worth noting. One, with the adoption of the Renters' Rights and Stabilization Act 2024, there's also the requirement to offer the property for sale to the tenants. That occurs at the conclusion of any decision to sell the property for multifamily properties, but also this piece of legislation does not apply to small landlords.
Okay, but if the tenant cannot purchase the property?
For those properties that would apply under RRSA, it's an offer. It's an opportunity to purchase.
Okay.
The tenant need not choose. The tenant could make the choice not to purchase the property.
And I know you mentioned that you're going to get back to, will you get back to us with the additional information? Where in the bill were you referencing this particular scenario? Do you know if you could just give me I'm up to page 5, so.
Are you referring to the good cause that deals with recovering possession by giving it the property to a family member?
Yes.
It's my page 7, hopefully the same page.
Page 7?
Yeah.
Okay. As a follow-up, so one thing I wanted clarification on from one of the previous questions. So if this bill passes, am I clear that a county must adopt a local law? I'm going to clarify that.
No, if this bill passes, absolutely nothing happens right now in Maryland. Counties have to, it is an enabling bill, so a county would have to take it up and pass good cause eviction. This bill authorizes counties to do so. And so if it passes, no, it does not mandate any jurisdiction to do this. So everything that we've talked about in this hearing, if a county does not take this up, then for those residents and those landlords, it does not apply to them.
Okay, and just as one quick follow-up. And so if under this bill, a tenant decides to sue the landlord, who is paying for the legal fees of, if a landlord is being sued and the tenant's bringing the case, of course, who's paying for those legal fees?
Go ahead. I'll let the attorney cover that.
Well, importantly, this bill, when enacted at the local level, will only provide a defensive remedy. There's no affirmative remedy, meaning that it doesn't give a cause of action against the landlord.
So just to put a finer point on it, if a case ends up in the court, which once again, that is current law, this bill does not change that. To evict someone, you have to go to court, and the district court has to provide that writ in order to evict someone. In most instances, a lot of instances, renters do not have attorneys, but with legislation that we passed previously, we have help from groups like Maryland Legal Aid. But in terms of your question, this doesn't provide a right to sue the landlord. That's not what this bill does. It provides a standard so that when the landlord decides not to renew, that they have to provide a reason. There's no, I'm gonna get up and sue the landlord under this bill. So when you're talking about attorney fees, a tenant would have to either have their own attorney, or if there's funds for them to have support in terms of an attorney, or if Maryland Legal Aid or some of our other free pro bono services are available. And then landlords, oftentimes, not all of them, they usually bring their own attorneys to court if they are able to cover that. So this does not change in this bill in terms of attorneys and attorneys' fees. And there's no right to sue that's created in this bill.
All right, thank you for the answers.
Thank you.
Personal privilege to thank my district mate for her consistent work on behalf of tenants. I think that those of us who represent districts that have really significant multifamily and older buildings of multifamily maybe have a different perspective on how crucial this kind of legislation is than possibly if folks just haven't spent the kind of time that we have fielding heartbreaking stories after heartbreaking stories. So I really thank you for your consistent work on this and other issues for tenants. I also want to thank the Secretary for understanding that good housing policy really has to include addressing the permitting and the zoning and the streamlining and all of those things to get new housing on, and protecting people who are currently in the housing that we have, that when we're in a shortage, like after a hurricane, we don't allow price gouging, right? And so while we address the shortage issue, we also make sure that people can sort of afford to stay in and aren't turned out with no reason. And my question is for the professor whose name, I'm sorry, I've forgotten. Howell, is that right?
Yes.
So building on the my colleague over here who with me asks all the asking about what the empirical evidence shows. I appreciate what you've shared so far. The question I have is about if there's any studies that really get at costs, like societal costs that come with sort of rapid transition of families that can only stay in a place for a year or 2 years, and what the costs are to the state or to the local county associated with the impacts on schooling, the impacts on homelessness, the impacts on perhaps there's other sort of public costs that we experience that I'm not even thinking of. But those are the kinds of things I'm interested in and wondering what the research shows on that.
Sure, that's a great question, and I think it's worth sort of highlighting here that a non-renewal is an eviction, right? You still, if you say, well, I'm not leaving within those 60 days, and we know that a lot of tenants do, you are still forced out, and you still have to make a really quick choice about housing. And I think it's important to talk about, I mean, I know in the context that you and I work in the DC area, there's not a lot of choice, right? So it's not like you're gonna be evicted from one house and go to the next. You're going to be looking for housing, and if you find it, that's great, but more likely than not, you're not going to. And so, my previous research in Virginia, I was at Virginia Commonwealth University for 9 years working on eviction issues there and eviction data, and we looked at the public cost of eviction, right? And so that includes social services, that includes healthcare, that includes education and turnover, and the work that you have to do with McKinney-Vento, and it was more than $7,000 per evicted family. That was a public cost of eviction. And that's really, really important. This isn't something that just the family bears. It's actually something that we, as taxpayers, as a society, also pay for. And that's not even dealing with sort of the family's issues, right? Like with education disruption and the disruption to the classroom of having significant student turnover. I mean, we had places in Richmond that we were looking at where the eviction rates were very high, and as a result, you looked at the classroom turnover for the elementary schools in that neighborhood, and they were really, really significant. Absenteeism was high, and the upshot is that it's not just the kids that are being evicted, but the kids who are in the schools where there's significant turnover. That means teachers have to do the constant work of bringing in a new kid and making sure that they are up to date. That means the school counselors and all sort of ancillary services just around the schools, and that's not dealing with disruptions in jobs and how you get to your jobs. Often what people are doing is when they're being displaced, they're being displaced to somewhere that's further out, right? We all remember how we all drove till we qualified in the early 2000s, or at least I'm old enough to remember that. And that's partially because, right, housing is getting increasingly unaffordable within our metropolitan areas. So what that means, families are going to be more reliant on their cars, which are harder to maintain over longer distances. The costs are enormous, and the cost to the counties, to our local jurisdictions, are enormous.
Thank you. There are no further questions for your panel, Chairwoman. I'm sure you're excited to get back to your committee, unless you stay here with the rest of your panel.
I will stay as long as I can.
They're all your witnesses.
Yes, I'll be here as long as I can, Madam Chair. Thank you.
Yes, so I'll call your second panel, Councilmember Odette Ramos, Mayor Talisha Searcy, Dr. Kajipta, Scott Burton, Matt Hill, and Councilmember Shaw.
Wonderful. Thank you so much, Madam Chair, Valderrama, Vice Chair Charkoudian, and members of the committee. The last session was very informative, and I don't want to repeat what has already been discussed, but I do want to provide a little bit of context around good cause.
Could you tell us
so
who
my
you
name
are?
My name is Talisha Searcy. I'm the mayor of the city of Tacoma Park, Maryland. We have 18,000 residents. We border DC and Prince George's County, Montgomery County. We're in a little corner of Montgomery County. And we have 18,000 residents. 50% of our population are renters. And we have a large number of aging multifamily buildings. And while I appreciate all of the legal discussions, I think it is important to root the conversation in the on-the-ground experience that many jurisdictions have to face. When members of our community are having challenges with just communication challenges with their landlords, when they receive notices, they don't always understand what is in those notices. I see good cause as an education tool for landlords and for tenants. It enables local jurisdictions who want to adopt in to be able to apply clear standards, clearly communicate those requirements to tenants and to landlords so that everyone is starting from the same foundation of knowledge regarding what is acceptable and what is not. Our community includes a large number of LIHTC buildings or state affordable housing, non-subsidized housing, and also individuals who rent houses and just the one-offs. So good cause is critical to just aid in the implementation of support to landlords and to tenants. And I support HB, and the City of Tacoma Park supports HB 774. Thank you.
Good afternoon. My name is Dr. Sandhya Kajipeda, speaking on behalf of the Legal Defense Fund. Thank you for the opportunity to testify in support of good cause eviction legislation. As you all know, Maryland is experiencing an eviction crisis. Our analysis of eviction data shows that neighborhoods where Black renters live are being hit hardest by this eviction crisis. Good cause legislation represents a critical opportunity to promote housing security for all tenants, and particularly Black tenants. In 2025, Maryland landlords filed more than 130,000 eviction warrants of restitution, resulting in nearly 20,000 executed evictions. Most of eviction warrants were due to tenants not paying rent, but more than 1,800 were for holdover evictions, those initiated simply because the lease agreement had expired. The concerning reality is that many Maryland renters live in their homes at the whim of their landlords and can be evicted even if they are keeping up with rent payments and abiding by the terms of their lease. In our analysis, we found that Maryland zip codes with higher Black renter populations face higher rates of total evictions and holdover evictions. A 10 percentage point increase in the percent of Black renters in a zip code is associated with a 21% increase in the rate of total evictions and a 15% increase in the rate of holdover evictions. We observed the same pattern with eviction filings. These findings provide evidence that majority Black neighborhoods in Maryland face a disproportionate risk of eviction, including holdover evictions. Every eviction is destabilizing for families, for children, and for broader communities. Research shows that jurisdictions that enact good cause laws experience lower eviction filing rates and lower executed eviction rates. You have the opportunity to enable this protection in Maryland, and in so doing, prevent no-fault evictions, reduce the negative effects of housing insecurity, and also advance racial justice. Thank you.
Thank you, Madam Chair, Madam Vice Chair, and members of the committee. My name is Scott Bruton. I am the Director of the Department of Housing and Community Affairs in Montgomery County, Maryland. A little bit more about me that will help you in deciding if you want to ask me any questions. Prior to coming to Montgomery County, I worked for 12 years for nonprofits that worked on homelessness prevention and the range of affordable housing and home ownership. And so within that context, I have worked for a significant period of time in a jurisdiction that does have good cause eviction, and I have seen the benefits of it in the community. I cannot do a better job than the first panel or the previous panelists on my panel in describing the important social impacts that good cause eviction can have on communities. In Montgomery County, more than half of our residents are renters, and a disproportionate amount of our renters are folks from minority communities, Black, Latino, Hispanic. And so these communities, especially in low-income areas, are significantly impacted by displacement risks, and as other members of the other panels of the panel have discussed, risk of displacement makes it very difficult for folks to plan for their futures, to have stability for their children in school, stability for their jobs, stability for access to health care. Also, something that hasn't been mentioned, the businesses in our communities also want a stable workforce. If your workforce is at risk of being displaced from their homes, simply because a landlord decides they don't want to rent to that tenant any further, then that is going to destabilize their workforce. And so the family, the community, and the social impacts of tenant displacement are significantly important. And I ask on behalf of Montgomery County for a favorable report on HB 774.
Good afternoon, Madam Chair and members of the committee. My name is Isola Shaw, and I serve on the Rockville City Council. I am also a renter, which gives me firsthand experience with the challenges many Maryland residents face. Thank you for the chance to testify in support of HB 774. I also want to thank Delegate Wilkins for her continued leadership on this important bill. HB 774 is about making sure our housing system is fair and stable. This bill also enables the local level to make the best decisions for the constituents we serve. Many renters, especially those from marginalized backgrounds, are afraid to complain about unsafe or unfair conditions because they worry their landlord won't renew their lease if they speak up. This fear is common. Even as an elected official, I am not immune to this risk. Nearly half of Rockville's household are renters. Our city hears from residents all the time who feel their leases were ended without good reason. Right now, there is only so much our city can do to help them. Stronger tenant protections like those in HB 774 would make Maryland and Rockville a more stable, fair, and welcoming place to live. On behalf of the City of Rockville City Council and our residents, I respectfully urge the committee to give HB 774 a favorable report.
Thank you, Madam Chair, Madam Vice Chair. My name is Matt Hill. I'm an attorney at the Public Justice Center, which is a member of Renters United Maryland, which strongly supports this bill. I want to talk to you about two brief points. First, around retaliation law, and second, around the small landlord exemption. First, I know you're going to hear from the opposition that Maryland has an anti-retaliation law. This is true, but it's not enough, and let me tell you why. So Rebecca Clausen came and testified on this bill last year. She's a 30-year combat veteran of the armed services, mother to 3 teenage daughters, and a longtime resident of Anne Arundel County. She reported severe problems in the property to her landlord, to the county health department. The landlord responded by issuing her a 60-day notice to terminate her tenancy. Ms. Clausen retained one of the best tenant landlord attorneys in the state. If I was ever being evicted, this is who I would call. She lost at trial. She lost on appeal. It's extremely hard to prove why someone is doing something unless they have to put that reason in writing. And so Ms. Clausen, in her testimony last year, said, "I served my country honorably for 30 years, including combat service, yet the very laws and freedoms in Maryland that I stood up to defend have failed my family. My children and I have been forced to endure hazardous living conditions, retaliation, now eviction, because the laws allow landlords to hide. Now, because of this eviction record, landlords are declining our applications to rent another home. As a result, we will become one of the thousands of homeless families in Maryland." I've called Ms. Clausen numerous times trying to check in on her since then. I tried to call her to see if she wanted to come and testify today. I haven't been able to get a hold of her. I am concerned. I think last I heard she was living in a park with her dogs in Anne Arundel County. Secondly, the small landlord exemption. I just want to put some meat on the bone to make it very clear, because I think this also addresses what Delegate Rose was talking about. This only applies when you own 5 or fewer units. The law only applies, the good cause law, if it's passed by the local jurisdiction, only applies to landlords with 6 or more units. So if you have 5 or fewer, you are exempt. I'm happy to talk about that more if the committee wants. Thank you.
We also have Councilmember Odette Ramos. She has appeared.
Thank you, Madam Chair. Sorry to be late. Madam Vice Chair, members of the committee, my name is Odette Ramos. I'm the City Councilwoman for Baltimore City's 14th District. I want to let you know that our City Council passed unanimously a resolution supporting and urging your support of this bill. We do want to put these protections in our city with our renters, but we cannot do it without your help. We tried to do it during COVID because obviously there is There was an eviction crisis there is now, but could not because we did not have authority from the General Assembly. You've heard everybody's stories. I don't want to repeat additional stories, but just another jurisdiction asking your help so that we can help our tenants in our city. Thank you.
Thank you. Delegate Bandari.
Thank you, Madam Chair. If Matt Hill, could you come in response to my question? I know you were talking about the exemptions for small landlords. Could you clarify the scope of that exemptions and outline the disclosure requirements included in the legislation?
Thank you, Delegate. Yes, so if you own 5 or fewer units, you are exempt. Even if your local jurisdiction passes good cause eviction, you are exempt. The reason is that the idea, and this again is a compromise that was already made by the House of Delegates 2 years ago, to say, if you're not in the business of being a landlord, we're going to exempt you from this law. But if you're in the business, if you have 6 or more units, you're getting some substantial revenue from that business, then you should have to provide good cause if you're going to non-renew the lease. Now, the idea around disclosure, I think the opposition is also going to talk about having to disclose many things. I don't think that's entirely true because you only have to disclose, how many units essentially you own if you want a small landlord exemption. So larger landlords are not going to have to disclose all these units, but essentially the idea is trust but verify, right? We trust that you actually only have 5 or fewer units, but you should write down how many units do you have so that we can verify that indeed you are a small landlord. So I think that that's really critical. And the reason why that's critical is that a lot of times, and we see this in Baltimore City, you can have an owner that has 200 units. Every single one of those units has a different LLC. And so trying to figure out whether or not this person's a small landlord or not is virtually impossible unless there's some affirmative disclosure. And frankly, some of those owners are the worst landlords that we encounter.
Thank you.
Sorry, I just need to ask this one question. It'll be quick. Because people have asked me about what does a unit constitute. So a unit doesn't mean number of bedrooms, right? It means like I have apartment style with separate entry or kitchen and that kind of stuff. Can you give me quickly what a unit is, and that'll be it.
That's my understanding, Delegate. I'd have to go back and look to see if it's specified in the bill text or not. But yes, it's the idea of you have an independent bedroom, kitchen, living room facility. That's an apartment unit. And so it'd be 6 or more of those units that you would then fall under the law if the local jurisdiction even passes the bill.
Thank you. There are no further questions. Thank you very much for your testimony this afternoon. We have also Claudia Wilson Randall, Vanessa Pinto, Chris Perry, Angela Hicks, and Kristen Bonner.
Madam Chair, before we get started, Kristen Bonner of We Are CASA. We had a tenant that was supposed to testify on the first panel, but there's an issue with her registration. I just wanted to request if she could take my place on this panel. We believe that her testimony is very important for the delegates to hear. Yes.
Sure.
Good afternoon. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland. And I'm here today in strong support of House Bill 774. Thank you so much to the sponsor and to my advocate colleagues across the state for their steadfast work on this bill over the last 5 years. I just want to make 3 quick points that I think are really important to where we are right now. housing, we're at such a critical point for housing, and you're going to hear from our opponents that this sorts of law, passing this sorts of law will affect housing production. And I would just urge this panel, and I know housing is a new issue for this committee, that we really focus on what needs to be done for people, and that we are fair and we do right by the people in the throughout the state of Maryland. I know we can center markets. I know we can center taxes. I know we can center a lot of things in this state, but I hope we center people just a little bit. The people who get evicted in the state are overwhelmingly women and children, and they deserve fairness, and they deserve protection. They are also associated with some of our state's highest cost challenges in health and education. So where we have areas with high eviction rates, we also have schools that are failing. We will never have a successful school when 20% of the population or 40% of the population is moving because of evictions. And that is a threat to the investment that the General Assembly has made in the blueprint. I also would just say that this is a human rights issue. People deserve a fair shot and a fair reason for why they're being asked to leave. With that, I urge your favorable report for House Bill 774. Thank you so much.
Thank you. Good afternoon, Chair and members of the Economic Matters Committee. My name is Vanessa Pinto. I serve as the Empowerment and Leadership Development Program Director at CHEER, a community-based nonprofit serving in Long Branch, in Silver Spring. I'm also a member of the Long Branch Housing Action Team, a proud Long Branch resident and a renter. I am here in strong support of HR 774, Good Cause Eviction. I am honored to speak on behalf of many of my neighbors who cannot be here today, not because they do not care, because they are afraid of landlord retaliation, report housing code violations, speaking up because that could cost them their home, and in many cases afraid of because of their immigration status. In May 2025, the Long Branch Housing Action Team surveyed residents ahead of the meeting with District 20 elected officials. Of the 43 respondents, almost 82% say that they were afraid of eviction or non-renewal if they spoke up about the problems in their housing. Behind that statistic are real families. A landlord retaliated after a tenant organizer helped residents recover illegal rent increases in building listed of Montgomery County's trouble properties list. A mother has spent her own limited income for months trying to control the roach infestation because she's too afraid to report it. This is not about bad tenants. This is about families who want safe, stable housing and who are too afraid to ask for it. HR 774 would simply ensure that eviction is not used as a weapon against tenants who assert their basic rights. No one should have to choose between safe housing and keeping a roof over their children's heads. I respectfully urge you to vote in favor of HR 774. Give families the security to speak up. Give communities the stability they deserve, and send a clear message that in Maryland, safe housing is not a privilege, it is a right. Thank you.
Good afternoon, Chairman Valderram and Vice Chair Tarkoudian, committee members. My name is Chris Perry, and I am a senior citizen and an Air Force veteran. I'm speaking in favor of HB 774. My wife, Kathy, and I are long-term renters, and many of you will remember that I've spoken to General Assembly committees during the past sessions. Kathy and I rented our home for 17 years and hope to continue to do so for as long as we can provide our rents do not increase unreasonably beyond our fixed income and beyond, and provided our landlord does not decide to order us to vacate our home for no justifiable reason with just 60 days notice. Seniors like us increasingly depend on our homes to be stable. The idea that those of us who rent our homes should be seen as temporary residents who at any time should expect to move is not only unreasonable but hazardous to our health and damaging to the overall welfare and prosperity of the community we belong to. Kathy and I are renter activists. We believe in speaking up when building conditions need improvement, but we are in constant fear, like all renters, that to do so would mean eviction. We ask you to move this legislation on to the General Assembly so that that situation will be abated. You should agree that the people of each jurisdiction should have a right through their elected representatives to enact just cause protections to the degree that they see fit. As you can see today, the request for this authorization is statewide. We are not a local hotel, or we're not students living in a dormitory. We are permanent voting residents who have a stake in our communities and our homes. We ask you to favorably report HB 774. Thank you.
Hello. Hello, my name is Angela Hicks. I am a resident of Baltimore County, Maryland. I am with a program called Baltimore Regional Housing. I am happily living in where I'm at now, but once upon a time I lived in a Brutus Arm Apartments for 3 years with my son when he was smaller, before I received a notice that my lease was not being renewed. And I had 90 days to leave my home. At that time, I was using a voucher to help pay part of the rent. And upon receiving this notice, they terminated me. Okay, and the other renters also, they had a voucher. And we went and we spoke to the property manager, because it was a new property manager, and she didn't care what we had to say. She told us we still had to vacate. And at that time, our children were small. We had them in activities. They were doing great. So my mother had passed at that time, and I didn't know where to live in Baltimore City or how to find a housing. And I wound up moving into a neighborhood in Baltimore that wasn't an upright neighborhood. So my whole life had spiraled and it had changed. And also my son's life had spiraled and changed because of a Brutus Arm manager putting us out for no reason at all. I even went to her and asked her what was the reason. It was none. She just said that we had to vacate. So when I called down housing in Baltimore City and asked them, he said, well, if the landlord said you have to go, you have to go. I said, without a reason, you have to leave, which was unfair. So as I said before, I moved into a neighborhood that
You can summarize, Ms. Hicks. Go ahead.
I moved into a neighborhood that I knew nothing about, and our life had spiraled upside down. I became homeless, drug addicted, mental health problems. My son became, as I say, not prospering, and he was prospering. He wanted to be a police officer. He wanted to be a fireman. That's all he always talked about when he was little. So now I have to deal with his mental health issues also too. So I'm asking and I'm praying that y'all support HB 774 bill for the less fortunate people that don't have and not able to move into a neighborhood that's, suburban style and have all the functions. Because
you,
yes,
Ms.
they
Hicks.
were wrong.
Thank you for sharing your story, Ms. Hicks.
Good afternoon, Madam Chair, Madam Vice Chair, and delegates. Excuse me, I'm getting over a cold. Excuse me. I'm very happy to be here today to talk about this much-needed good cause legislation. My current lived experience reflects in stark form the need for HB 774. My name is Kathleen Harrington, 67-year-old resident of the Solaire Apartments in Bethesda, Maryland, since April 2025. I am here with much-needed support of rapid rehousing, a local emergency rental housing program that helps people who have been homeless or at risk of imminent homelessness to get housing with financial support. We are CASA. CASA has been one of my sponsors, sorry. Right before Christmas, on December 15th, 2025, out of the blue, I received a letter from Gallagher LLP, who represents my building and their parent company. The letter gave me notice of my lease termination on March 20, 2026, less than 4 weeks away, with no specific reason given. I promptly made an appointment to talk with the yet again new management, rotating management in this building, accompanied by my representative from Rapid Rehousing, a gentleman named Matt Burney. They refused, and Matt was there with me, to explain or even converse, citing legal constraints. No explanations, door closed. Currently, I face eviction in less than a month with no cause. I face imminent personal upheaval, even danger. I'm a model resident. My rent is paid every month on time. I share that payment with Rapid Rehousing. I pay, they pay, we do it together. And I have proof of all of this. Despite this, management has filed eviction cases against me twice. This is important, I'll try to be quick. And those eviction notices were completely dismissed by the court at great cost to me as well. I need and want to stay in my apartment. A 40-year resident of DC, I have come to enjoy and rely upon my little corner of Bethesda. Frankly, Solaire is poorly managed by an inexperienced cadre of so-called managers, bathroom floods, broken electric circuitry, and this is my last sentence. But their capriciousness is what I call it. Their capriciousness, as exemplified by what I have described to you here today, should not be tolerated by me or any other renter, nor by you gathered here who represent me, a new citizen of your state, and the citizen interest in the Maryland House of Delegates. Thank you.
Thank you. I don't see any questions, but I want to thank each and every one of you for taking time out of your busy schedule to come before us and share your personal experiences. Thank you very much.
Thank you.
The next favorables we have is Matthew Lozak, Emily Towie, Ruheiko Mashina, Tim Huang, and Maisha Allender Hardison. You may begin.
Right. Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the committee. My name is Matt Losak. I am the co-founder and executive director of the Renters Alliance and co-founder of Renters United Maryland. We were founded in 2010 and have been at this for a long time. I'm not going to repeat the substantial information that's been provided by our colleagues previously, but I will say that the stories that you are hearing are the tip of the iceberg. We are seeing abuse and retaliation take place all over where we work in Montgomery County and in Prince George's County and beyond. These are real cases. They're not complicated. They are retaliatory. We are seeing whole communities that have a chilling effect because they're afraid to speak up, to complain about issues in their buildings, to pursue their rights, or to form tenants associations so that they can act collectively to deal with issues in their building. Some years ago, we were working in the Long Branch area at an apartment community called Flower Branch, where The tenants were telling us repeatedly that they were complaining to the property staff about issues and were told by the property staff, if you continue to complain, we will evict you. So when they smelled gas, they did not say anything. And the building blew up and 7 members were killed, including 2 children. This is real. We urge you to consider the information that's been provided by expert colleagues' testimony, the real stories of tenants who are facing abuse, and by organizations like ours that have been dealing with this for decades. It is fair and balanced. It does not relinquish the rights of landlords to manage their properties, and it does not in any way impinge on the building of new properties, as evidence has shown. What it does do is create balance in the relationship between landlords and tenants, and is perfectly fair. We urge a favorable report, and we thank Delegate Janelle Wilkins for her leadership on this.
Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and committee members. My name is Emily Towie, and I'm a lifelong Montgomery County resident testifying in support of House Bill 774. I appreciate the opportunity to speak today on the importance of good cause eviction protections. I would also like to extend a big thank you to Chair Wilkins and Delegate Smith for recognizing that local jurisdictions should be allowed the choice to implement good cause eviction to help keep people in their homes. Securing safe and affordable housing is already a struggle in the state for many people. However, low-income students and new graduates are especially vulnerable to losing their homes without good cause protections. As a graduate from the University of Maryland College Park, I and many of my peers have experienced firsthand the difficulties of finding and retaining stable and quality housing. Now, as an incoming first-year law school student, I will soon have to repeat the process of finding a safe and quality apartment, and can only hope that my landlord decides to let me stay there between school years. Currently, landlords only need to provide 60 days notice that they will not be offering a renewal at the end of the lease, and do not have to provide a reason as to why. 60 days is simply not enough time to uproot one's life and start the burdensome and expensive rental process all over again somewhere new, especially knowing the same thing can happen time and time again. Between the renting expenses and the instability, all of my friends who, like me, are in their mid-20s with college degrees have reluctantly decided to live at home with their parents just to avoid the trouble. If my heat or an appliance in my apartment breaks, I should be able to call my landlord to request a repair without the legitimate fear that they will retaliate and decide to non-renew me at the end of my lease. If House Bill 774 were to be passed and allow jurisdictions to enact good cause protections, I would not have to worry that I could be lawfully ordered to vacate between school years. Instead, could solely focus on getting a higher education and preparing for my future, rather than having to advocate for myself to be steadily housed in the present. I urge the committee to enable local jurisdictions with the choice to protect their residents from unbased, unfair, and unjust non-renewals. I hope that everyone can agree that no one should be evicted from their home without a good reason, and I strongly urge a favorable report. Thank you for your time.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Rejeka Mashinya, and I'm a recently returned Peace Corps volunteer who hopes to make Baltimore City my long-term home. I stand before you today to testify in support of House Bill 774. During my Peace Corps service in Fiji as a community economic empowerment volunteer, I worked closely with communities where stability, trust, and long-term relationships were essential to the community's success. One of the biggest takeaways I learned is that people can only invest in their communities socially, economically, and emotionally when they feel secure about where they live. I hope to put down roots in Baltimore City, to build community relationships, engage neighborhood life, and strengthen my social network. However, that vision remains deeply uncertain when housing stability is not guaranteed for tenants in the city like me. Under current law, a tenant who has done everything right, paid rent on time, followed lease terms, been a good neighbor, can still face non-renewal or termination without a good reason. That instability makes it difficult to plan for the future or truly call my building a home. HB 774 addresses this issue in a thoughtful and balanced way. It does not impose a statewide mandate, but instead gives counties the authority to adopt local laws requiring good cause for lease non-renewal. Stable housing is not just about shelter, it is about dignity, continuity, and the ability to fully participate in community life. Housing is a basic need, and I strongly believe a right. Good cause law creates a balance between landlord rights and tenant protections, ensuring renters like myself who follow the rules aren't displaced without justification. HB 774 is necessary for stronger neighborhoods and more resilient communities. Thank you for your time and consideration.
Hello, my name is Maisha Allender, and I'm so honored to be here to tell my testimony. I currently live in Owings Mills in Baltimore County. I live with my daughter, who's my caregiver. I've been in this area for the past 7 years. I have 2 grandbabies who I often watch. I live around my doctor's appointments, specialists. It's just the area where I would prefer to be due to my disabilities. About 2 years ago, a pit bull attacked me in my neighborhood where pit bulls are not allowed. I have been in ICU twice. I had, a nurse has to come out 3 times a week to give me wound care. And because I filed a complaint, they gave me a 60-day notice to vacate. This is the 3rd time that they had to renew my voucher because I have not been able to find accessibility due to my disability. They gave me no reason why I should be evicted. So I am still trying to look for accessibility, and it is very challenging finding disability. I do have a voucher in Baltimore County where they pay majority of the rent, and I pay 40%, and it's just been a lot of trouble just finding accessibility home. The landlord is trying to could file for eviction any day. So, due to basic humanity for people with disabilities like myself, I support this bill. I'm just honored to be here, and I'm honored to tell my testimony.
Good afternoon, Chair Valderrama and Vice Chair Charkoudian, and members of the committee. Thank you for listening to my testimony. I'd also like to thank Delegate Wilkins and the co-sponsors for introducing this important legislation. I want to start by highlighting what happens after an eviction, right? Think about how the moving process is. Think about a senior citizen or families with children trying to pack out the boxes, move their boxes into a U-Haul, or doing multiple trips in their personal car. They might have to leave their furniture and important, items that they can't bring with them and then buy new ones. So that is just a cost that need not be incurred by good tenants. To put it in perspective, I imagine most people here are homeowners. Imagine if your bank said to you, we'll give you back your down payment, but you have to leave. How would that make you feel? This is what tenants are going through. Right, and for landlords, for them, this is just a business decision. This is not, it's not too much skin off their back. It's the power balance there is vast. Lastly, if you look at the members of the panel here, look at how many people are here, and it's not, we don't have big money behind us bringing us here. All we're asking is to have counties and local jurisdictions be able to have the right to self-determine. And if you just look at the numbers of people here, this is the democratic thing to do. And so for this reason, I urge a favorable report. Thank you.
Thank you. And just for the record, could you state your name?
Oh, sorry, Tim. My name is Tim Huang.
Great.
Yeah.
I kind of assumed, but I didn't want to publicly assume.
Oh,
yeah. Thank you guys for your testimony. I don't see any questions for your panel. Thank you very much for coming.
Thank you.
We'll move on to 2 more favorables in person. We have Dan Reed and Tanya Chestnut.
Good afternoon. My name is Dan Reed. I'm the Maryland Policy Director for Greater Washington. We support better housing, land use, and transportation policies across Greater Washington and beyond, and we strongly support this bill. As has been said many times today, Maryland is in a housing crisis. We did a poll last month that found 92% of Marylanders say home prices are a problem. They told us they're putting off starting families or saving for retirement or not paying for groceries or medical needs because of housing costs. As an organization, we believe more housing protection is desperately needed, as well as more tenant protections. They go together. They give people the choice to stay in their homes, as well as the choice to find a new home if they want or need. And both are very popular among voters. 75% of Marylanders, including 85% of Democrats and 61% of Republicans, support good cause eviction, which says, in short, that landlords need a reason why they're not renewing a tenant's lease. I've worn many hats in my life. I've been a tenant. I've been a property manager. I worked as a real estate agent representing tenants. I see all the different perspectives, but the one that matters most to me is as a resident of East Silver Spring, where I have seen my neighbors struggle to make ends meet over the past couple years, and most recently one around the corner from me got evicted on Christmas, and I got to watch their belongings sit in the ground in the snow and the rain for weeks and weeks. There's no reason why people should be treated like that. And I hope that you'll stand with tenants and give this bill a favorable report. Thank you.
Good evening, Chair, Vice Chair, and members of the committee. My name is Tania Chestnut. I serve as Progressive Maryland President of the Enclave Tenants Association in Silver Spring. I'm also on multiple committees of Housing Justice Montgomery. I am a renter. I am a landlord of 2 properties. I am here in strong support of Good Cause Bill HB 774. I'll let you know also, I am not here just for Enclave. I support all tenants of Montgomery County and PG County that I've been helping, but anybody else in the state of Maryland. Across this state, there are many tenants who are suffering because they are scared to speak up. As many people spoke before me, people are scared to speak up due to violations of their lease. They didn't do it. They speak out against repairs management didn't take care of. Also, about even forming certain organizations such as a tenant association. They don't want to do it. They're scared. There also was a tenant in my complex who could not speak English. Management gave them a piece of paper to do certain things in their apartment. They couldn't get it right because they couldn't understand the language. They didn't understand what they were supposed to do. They were served with papers to evict. Thank God we was able to step in and help this tenant. This is what we're up against. This is why this bill is so important. As a tenant leader, I've seen so many families, once again, hesitate, report things such as mold, broken heat, broken air conditions. This should not be. I want to make sure that you understand how important this bill is. Please, please, I urge you to support this bill. Thank you.
Thank you. I don't see any questions for your panel. Thank you very much for coming before and giving your testimony. We're going to move on to favorable virtuals. We have Chanel Adams.
Good afternoon. My name is Chanel Adams. I've lived in Baltimore County. I'm a single mother, and I also have a housing choice voucher, and I had one for 20 years.
Miss Adams, can you show your face on the camera, please?
Oh. It says the host didn't allow it. Oh, there it is. Ready?
Yes.
I lived in the same home for 17 years. I raised my daughter there. I paid my rent. I maintained my rental property, and I was stable. In 2023, new management took over my apartment complex. After that, everything changed. Utilities that were included are now separate from my rent payment. Maintenance issues I reported for years were never fixed. In April of 2025, my unit failed inspection for things like missing window screens and crumbling dry from the bathroom that were issues for me. Shortly after that, I received a non-renewal notice. After 17 years, I was simply told my lease would not be renewed. No real case, no meaningful explanation, just non-renewal. The decision took my life upside down. I have a 700 credit score. I have been denied for at least 7 times while trying to move. I was flagged for things that were closed, including I was flagged for things on my credit report that were closed, incorrect, or not true. I spent over $200 in non-refundable application fees. I was charged extra for a tenant holdover while still trying to find a place. For 17 years, I lived in the same house. In good standing eviction, it is a good matter of 10. Oh, I'm sorry, lost my spot. I'm sorry. The good case eviction matter because tenants like me shouldn't have to go through anything like this. I pay my rent on time, so I shouldn't have any issues or be evicted from my home. I am in support of this bill.
Thank you so much. I don't have any questions for you. Thank you for testifying before us. Next, we have Irene Kamani. Okay, Ms. Kamani's not present. We'll move on to Dawn Harkless.
Yes, good afternoon. My name is, and I'm a resident of Howard County. And during the pandemic, I was illegally evicted from my apartment. I had no late fees. My rent was paid on time. They simply said that they wanted to renovate my apartment and they were paying full price because my apartment was the only one that hadn't been renewed. But I had been there 5 years. And my daughter, I told the management that when my daughter graduates in June, I'll move out completely. I'll leave the complex. I didn't want to transfer to another place and then have to move again. She didn't want to hear that. So during the pandemic, as soon as the governor shut everything down, my dad went into the hospital and I had to go see about him. And when I came back, I couldn't get in my apartment. I still have the keys to my apartment. I still have the mailbox key to the apartment. They evicted me. I ended up sleeping in my car. My daughter had gotten accepted into Morgan. She had to do her first year, half of her year in the car until they took my car. I was suicidal. I wanted to hurt myself, hurt some other people. I've been in therapy. My daughter's in therapy. My aunt let me stay there. I owe her. I still owe her money. I'm in support of this bill because I know a lot of people that has been illegally evicted for no reason at all. I was a very good tenant. I had no police coming to my house, no drug use. My daughter didn't have no bunch of company coming in. I helped a lot of the young girls that came out, on Section 8 that didn't have cars. The kids couldn't get to school because they missed the bus. I would put them all in my car and I would take them to school. I was a help, not a hindrance. And the lady had no regards into what my life would go through if she put me out. She didn't care. She evicted me and my baby girl. But I am here to say that my daughter will be graduating in May. She didn't give up. I didn't give up. And I am very much in support of this bill because it's not right that people are being put on the streets, their kids being uprooted, and it sends them to the streets and make them do things that they normally wouldn't do if they had a stable home to live in.
Thank you, Ms. Harkless, for sharing your story, and we're glad that you stayed strong for you and your family. And congratulations on your daughter's graduation.
Thank you.
We have one more virtual, Mia Pevy. Okay, Ms. Pevy's not present. We'll now move on to favorable with amendments. Well, she already spoke, so now we'll move on to the opposition. We have Bill Castelli, Brian Anlou, and Bob Enton.
Thank you, Madam Chair, members of the committee. Bill Castelli on behalf of the Realtors with an unfavorable position on HB 774. And one of the essential things that makes a lease different than than ownership is just the nature that it is a limited term. Both parties agree to it. And as representative of the real estate industry here, there are, everything that happens with a real estate sale, everything that happens with a lease, this legislature, the industry put a lot of effort into including in those leases as well as home sales, the terms that both parties are going to agree to. So a lot of effort goes into making sure that both parties do that. And now we're saying that one of the essential terms of the lease really doesn't matter anymore. And I think that is just fundamentally different than the way leases have always worked. Both parties know what the start time of that lease is. Both parties know when the end time of that lease is. So fundamentally, we just don't agree with this bill. We don't believe it's an eviction. And I think in terms of some of the other specific provisions in the bill, there's one item in here talking about single-family exemptions, but really there will still be many single-family rental properties that are still caught up by the bill the way that single-family exemption works, because any property manager or landlord managing more than 6 would still be subject to the terms of the legislation. So for that reason, we would still be unfavorable to this legislation.
Okay. Thank you, Madam Chair, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association. I think this is the 9th year that, with all due respect to the sponsor, I've come in opposition to this bill on behalf of my client. I think that, there's two things. There's number one, there's a very fundamental issue here, which Mr. Castelli addressed, and that is you have an agreement between two parties, and the tenant has no obligation whatsoever to stay in the property, none. Likewise, the landlord has no obligation to continue to rent to the tenant. Under Maryland law, either party is free to walk away from the contract. Now, you heard a couple examples from the proponents, I guess, about doctors and maybe their insurance companies or auto insurers, franchisees, but I can't think of another single contract under Maryland law that allows one party to walk away from the contract, but not the other. And looking at, so that's a fundamental issue. Looking at the language in the bill and what landlords will now have to deal with, if you go to page 6 of the bill, and you look at the reasons, a tenant committing a substantial breach. What is a substantial breach? Routine disorderly conduct. What is routine? A tenant without reasonable cause. A tenant repeatedly committing, habitually failing. What landlord is going to be able to come in and make their case? What is the standard that they will be subject to? So for those reasons, Madam Chair, once again, with all due respect to the sponsor and the proponents that testified, the Maryland Multi-Housing Association continues to be against this legislation. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Brian Anlew with the Apartment and Office Building Association. I won't repeat the points my colleagues made, but I would simply point out that last year we came to the table with a possible compromise on this bill. The compromise would have allowed counties to enact good cause, but not vacancy control. Vacancy control limits how much landlords can increase the rent on a vacant unit. The issues are tied together because the tenant advocates claim that counties that do not have good cause need vacancy control, because otherwise there is a perverse incentive to not renew a lease in order for the unit to get back to market rents. Again, the tenant advocates tie these issues together, not us. I want to briefly touch on the impact that rent control is having on new development in Montgomery and Prince George's County. As we've presented to the committee previously, we've seen new development in both counties largely evaporate. And the new development that is happening, particularly in Montgomery County, is heavily government subsidized. The proponents of this bill would have you believe that landlord regulations do not impact new construction, but that's simply not true. In the fall, the Montgomery County Planning Department did a survey of developers with planning department approvals. That means they could go get a building permit and begin construction. Vacancy control was cited as the #2 reason why they are not moving forward with projects. Vacancy control institutes rent control for vacant units. It is not an affordability tool. The only way to make housing more affordable is to build more housing. We simply cannot afford to have both vacancy control and good cause at the local level. And for those reasons, I respectfully urge an unfavorable report.
Thank you. I just have a quick question before I take other questions. So it's been stated that this is not precedent. It's existing in other states. Has there been any conversations or negotiations with the bill sponsor or advocates in a way to make this work? I know you said, Brian, that you had some language that wasn't accepted, but for all three of you, has there been?
I'd have to check with my client. I mean, my client's very proactive here. They're testifying in the Senate on a bill today that, but I will certainly see whether there have been any discussions. I know there were discussions last year, and I don't think, my client is not opposed to trying to find a compromise, but, the question, the devil is, as always, is in the details. And we'll certainly be happy to sit down and see. But I think the point that Mr. Anelo raised is a key point. We're seeing rent control now in our largest jurisdictions in the state. So how is it that I, as a landlord, don't meet the requirements of good cause and the lease gets to continue? Let's say it's a 5-year lease, and the rent was fixed for 5 years. Now, it's 5 years later. I can't terminate the lease, and the tenant gets to stay, but I don't have the ability to increase the rent because there's rent control. So that's a key part of any compromise, and I think that was discussed last year, and there was an unwillingness on the part of the advocates for the bill to address that issue.
Okay, thank you. We'll go on to Delegate Adams, Vice Chair Charkoudian, and Delegate Ampry.
Thank you, Chair. So I meant to ask this of the other panel, but I'll just ask you, Bob. I don't know how long it would take to go through the exercise of going to court and figuring all this out, but what do you think happens with the rent that's due once a decision is rendered in the benefit of the tenant? So
if there's rent due, that's a separate issue. If the rent hasn't been paid, I mean, I think that that's if you have a tenant that's habitually late in paying the rent, if you have a tenant who the neighbors have complained about the tenant's conduct, one of the concerns is that the bill has language in it that talks about what happens if the tenant doesn't pay the rent, but it's like the other language that's in the bill. It's not finite enough. It doesn't deal with a tenant that's habitually late in paying the rent. Deals with the number of times that the landlord may have to go to court to try to evict the tenant for non-payment of rent. Right. So that's the concern with all of these standards in here. Once again, I think it's just a foreign concept, except in which I guess you heard 3 limited instances where at the end of a contract, people get to walk away. The other problem is, how do I, as a landlord, prove to the court that the tenant repeatedly committed violations, that the tenant continually disturb the neighbors, am I going to summons in my other tenants? I mean, what this is really about is you have a problem tenant, and rather than evict the tenant, go for an eviction, try to, demonstrate there was a breach of the lease, you say, you know what, the lease ends in 6 months. The lease ends in 8 months. I'm just going to wait it out and then, not renew the lease and try to rent to somebody else that's a better tenant. So why is that so evil?
Right. So, I mean, my last question to the opponents, I mean, leases are not that hard to understand, explain, and abide by. There's 3 different actions landlords can take, 3 different buckets that I'm aware of. One is there's a non-payment of rent, so you go to court and get a judgment. There is a breach of lease, which requires a burden to go to the courts and demonstrate the breach of lease. And then the last is the non-renewal of lease. These are the 3 fairly well understood, generally easy to explain, principles. And I believe, and you probably would agree with this, that the bill on some level is completely unnecessary, because what the bill is trying to do is apply the standards that any landlord currently has to apply to do a breach of lease. So a breach of lease action is those examples of serious violations for which a landlord needs to take action and isn't able to wait till the end of the lease term to take that action. And I would assume that you would agree with that the bill on some level just is repetitive in a legal sense. Would you agree with that?
Absolutely, Delegate. And, the thing is that the last thing that a landlord wants to do is to have the property turn over. Why is that? Because if you're going to rent to somebody else, particularly if it's an older property, one of the big issues you have to do is you have to comply with Maryland's lead paint law, which is one of the most rigorous lead paint laws in the country. And you have to then come in, you have to have the property inspected, you have to remove any chipping, flaking, peeling paint, you have to do all these things, and then you have to have someone come in and inspect it and give you a certificate that you've complied. Likewise, what are you going to do? You're not going to rent to somebody, let's say the tenant's been in there 5-10 years. Who knows? And now you're going to rent to somebody else. You're going to have to come in and fix that property up. We don't want to lose good tenants.
I wish that the sponsor of the bill would not call this good cause eviction. It's the non-renewal of a lease, okay, with additional terms and restrictions. But to create this premise that a tenant is only ever going to leave because the landlord's evicting them, and therefore we're going to pass a bill that allows for a good cause eviction, misses the good nature relationship between 2 parties that come together. This is basically a bill that prohibits the non-renewal of a lease. Just call it what it is. I mean, I'm not a fan of the phraseology because it presents the landlord in the wrong light on the subject. Don't you agree?
Well, I do, and let me just say that we have one of the most robust retaliatory eviction statutes in the country.
That's right.
Thank you, Madam Chair. I just wanted to correct the record. I think, Bob, that you said that you have to go to court. You have to have gone to court for the habitual failure to pay rent. It's actually, I'm reading this section, the bottom of page 6. It says a tenant habitually failing to pay rent when due if the tenant has been notified by the landlord in writing that the rent is more than 10 days late. So I just want to make sure we're on the same page. It's not that you have to have gone to court 4 times, that it was late. You just have to send them a letter.
You're correct. I apologize. I was trying to find that section and I couldn't find it.
No worries. We're all on the same page now.
Yeah.
I think the second thing, I'm trying to understand the case you're making about there's a lease. And this is not what the lease says, but the lease has all kinds of requirements in it that we set down by law because we believe people should live in a safe and healthy environment, that community is important, that school is important, that stability is important, right? So it's right now, the lease is not something that you just get to sort of make up yourself. It is something that is directed by law, right?
So we have.
So, sorry, I was asking Bill.
Yeah.
I was asking Bill.
We have
I was asking
91
Bill.
pages.
I'm sorry, I wasn't clear. I was asking Bill.
Oh, okay.
Yeah.
He's the one who said it.
Yeah, so I agree that it is in there, and I think a lot of times we try to get parties to pay attention to the lease, pay attention to the contract. We put all the items in there, and, you know, the term of that lease is one of those essential items that's in that lease. That's what separates it from.
But the terms of the lease are dictated by Maryland state law. So to say that this isn't what's in your lease right now, that's because it's not the law yet, right?
Well, it's, you know, 400 years of common law of how a lease is different from an ownership of property. But I do understand what you're saying. Yes, you do define those terms that would be included.
And so this would be a state and then a county level decision about what else goes in that lease.
Correct.
I have one last question, and then I'll follow up with the rest of you offline. Brian, I'm aware of the document you're referring to, which is like a survey of landlords, like why aren't you building? And then, sorry, not landlords, developers, why aren't you building? And they point to landlord, tenant protections as the reason. I'm hesitant to consider that. I understand that developers or landlords don't like some of the tenant protections that we have, and so they would point to that. But I'm hesitant to take that as sort of empirical evidence, like a survey. And so I'm just wondering, earlier we heard about the empirical evidence from Minnesota and a couple of other, we had a professor here who was talking about the empirical evidence. I'm just wondering if you've had a chance to read those studies and what your thoughts are on those.
I have. I'll just very quickly about the survey. Yeah, you're right. It's not empirical evidence. But, again, we have a housing shortage and you have developers that are saying we have a regulatory environment that makes it hostile to develop here. To the Cura study, there's a couple things that I think are different from the places they looked at than here. First is some of the jurisdictions that they look at, they don't directly compete with one another in the same way that Montgomery County, for example, compares with Fairfax. You've heard from others this session and previously other developers have made the case that investments and money walks to places where it's a lot more hospitable to their investment. And so when presented with the option to develop in, say, Montgomery or Prince George's, they're choosing to develop in Fairfax because it's a better regulatory environment there. So that's sort of a big difference there. The other thing is, I'm not sure that the Cura study makes a difference between single-family new construction and multifamily new construction. We still have single-family new construction in Montgomery and Prince George's County because they're not impacted by tenant protections. That's for sale units. And so, again, I'm just not sure that study is applicable to what we're discussing here in the regulatory environment that we see in Maryland.
Okay, so I'll take a look at that. I think that what I value about that study and some of the other empirical studies, when they're able to sort of hold constant for the other things that you've sat at the table that you and I actually agree on, is some of the permitting, some of the zoning, some of the other things that actually affect whether or not we're building. And the survey that happened in Montgomery County took place at the same time as we had tariffs increasing, at the same time as we had all these other factors that were, we had interest rates increasing, all these other factors that were driving, making it more difficult to develop, period, anywhere. And so I just think it's important, like when we're thinking about using data to drive policy, the more we can kind of consider analyses that are not just surveys and not just anecdotal, but also kind of have the ability to hold constant for the multiple other factors that could be affecting a market at any given time.
Can I respond to that point just very briefly? So Fairfax, DC, Arlington, Loudoun, Howard, Anne Arundel, they're impacted by tariffs, they're impacted by interest rates. They have to raise investment from equity partners, just like Montgomery and Prince George's County did. And since Montgomery and Prince George's County enacted rent control with strict vacancy control, they have all built more housing than Montgomery and Prince George's County.
But
and again,
DC has very strong tenant protection.
They do, and there are some differences
also
there as well. They exempt from rent control everything built after 1980.
Yeah.
So
and Montgomery
again,
County exempts the next 23 years. We'll talk offline, but thank you.
Thank you, Madam Chair, and Madam Vice Chair kind of stole my thunder there on some of the questions I was going to ask. But I guess My question is for Brian. I just want to get more context because I think we can agree that our housing stock is one of the issues, right? I think that one of the most powerful tools that tenants have outside of good laws and protections is leverage, right? Having the opportunity to have leverage. You have other options. That's an important tool that tenants have. So I want to get a better understanding. You broke down that why vacancy control, rent control, combined with good cause eviction would create a world where it would be harder for people to build. So can you just give me the economics as to, or just the more of the rationale as to why that third item of good cause, why does that, if vacancy control and rent control is already the issue, adding this third one, can you further explain why this makes it more, like what is it about this that makes it difficult for people to be able to build?
Yeah, happy to. So say you have a tenant that they decide for whatever reason that they want to stay in a unit for 5 or 10 years or however many years. With rent control in place, that unit is only allowed to get so much rent for that unit. And over time, the difference between what that unit rents for and what the market actually, calls for that unit, the gap between them gets bigger and bigger. So if in year 10, the tenant decides, we're going to move out, we want to buy a house, or we want to move closer to work, or we want to move for whatever reason, and they leave, you still cannot return that unit to market levels because vacancy control prevents you from doing so. And so, again, what the pro-tenant advocates have made, case that they've made is, well, you shouldn't be able to return that unit to market levels because we don't have good cause. We don't have anything that's keeping that tenant in place and preventing them from getting displaced. And again, you just can't sort of have it both ways. You can't say, well, we want to protect the tenant, but we also want to protect the unit. And protecting the unit is the affordability piece when, again, this is a poor tool for housing affordability. And to your point, the best way to protect tenants is to give them more choice and build more housing. You can't do that if you have rent control. You can't do that if you have vacancy control. The data really shows that.
All right, so thank you for that. Second part of my question is, we heard today from earlier panels, they gave jurisdictions where they have all these in place and they're still able to have housing and they still are building and they still have, so can you give me any color to those comments? Because it sounds like it is working in other places. Why would it not work in Maryland?
Sure. So AOBA is tri-jurisdictional. So I do have a counterpart in DC, and we do represent multifamily owners in DC as well. And so to the vice chair's point, yes, DC has good cause, and they also have rent control. However, as I noted a moment ago, DC's rent control does not apply to anything built after 1980s. So really, the way to think about this is, how do these policies layer on top of one another to create a favorable or unfavorable regulatory environment that makes it likely to build here? So if you don't have rent control or it doesn't apply in, for buildings that are brand new, you can live with good cause. Because again, it's probably going to impact a fewer percentage of renters, the really, really bad cases. I'll also say, and I'm happy to send articles that have been in the Post about good cause in DC and how it works there and how long the eviction process is for those tenants that are in breach of lease. And it can take 18 months or more. There was an example of someone who was a smoker and was causing their neighboring tenants to want to leave or relocate on the property. And that landlord, which is an AOBA member, could not get rid of that problem tenant, even though they were in breach of lease. They were doing something that the lease said you cannot do, and they still couldn't get rid of them. And it took, more than 18 months for this case to get adjudicated. So in summary, really, again, it's how these policies interact with each other and layer on top of each other to create an unfavorable environment.
All right, thank you. I look forward to having more conversations offline. Thank you so much.
Delegate Roberts.
Thank you, Madam Chair. I just had 2 questions. One that I'm just curious about, because now we're bringing DC into this situation. I had been hearing that there were some laws in DC with respect to landlord-tenant issues that are being rolled back. Does any of that relate to anything that we're considering here today?
You're talking about some of the TOPA laws that DC has. It does not. It doesn't apply. The Rental Act that the mayor pushed, it's a totally separate issue. It doesn't apply.
Okay. And then I'm very concerned because I've heard references of issues in Prince George's County. But it seems like all the examples that were given were like in Montgomery, Anne Arundel, or Baltimore County or something like that. I just want to know where the problem areas are that anyone may be aware of in Prince George's County. Because I do know that we have had council members, specifically Council District 8, our council member in District 8, where he had took some strong actions against, there was a particular apartment building that was really just trifling, for lack of a better word. But I know that the county itself was able to, take measures and to help out with that situation. So I'm just curious to know where, if you all are aware, because maybe this isn't the panel, but where at in Prince George's County those references are being made.
Yeah, I can't speak to specific properties in Prince George County. I've of course, have heard of other instances in Prince George County where something like this might occur. But to your point, and a point that Mr. Enton made, there are other tools in the toolbox to address these issues, whether it's the anti-retaliation statute, whether it's different additional enforcement and protections at the county level that the county has to help prevent some of these things that have been, these claims that have been made. And so there are already a lot of landlord and tenant protections that already exist today without this.
Oh, okay. All right. Thank you. Thank you, Madam Chair.
Seeing no further questions, thank you very much for your testimony, gentlemen. Seeing there are no more questions, that ends the bill hearing on House Bill 774. We will now move on to House Bill 1009. Before I have Chair Corman begin, I just want to acknowledge our former colleague and friend, Ana Sol Gutierrez, who's in the audience. Welcome.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Let me just say I've sat through that good cause hearing many times, so appreciate what you've all just been through. Yes, so good news, this bill is not about ICE, but it is about the federal government. And it's a little bit different than what we were hearing on the floor this week. It's actually kind of trying to address the opposite problems. I'm Delegate Mark Corman here to present HB 1009, Land Transfer Accountability Act. And although there are some circumstances where some of our colleagues may not want the federal government to be in their districts, there are other situations where we're worried about the federal government leaving our districts. About a year ago, a list was posted online by the Federal General Services Administration putting up for sale 100 buildings, 83 of which were in Maryland, primarily office buildings in the DC suburbs. That list was later pulled down, thankfully, but obviously is a cause for concern in areas like Montgomery and Prince George's County, where we have a lot of federal employment and federal workforce. In my county, I think we, as of a year ago, had about 50,000 jobs that were federal in the county, not counting military, right? So of course we have other county residents who might work for the federal government but commute to DC or, God forbid, Virginia. But we also had in the county 50,000 federal jobs in office buildings and other facilities. And so there's a concern about a fire sale of this type of property. In addition, last year, Congress was looking at in their reconciliation bill, what some call the big ugly bill or the big beautiful bill, depending on which side of the aisle you're on. There was a discussion about doing massive public land sales in terms of wilderness lands, refuge lands, BLM land, things like that, which is also a cause of concern. We want these lands to be preserved and protected. That's why they were owned by the federal government to begin with. And so this bill would try to do two things to address this. One, it would require, if federal land is being sold, before that can be recorded locally, it has to go through a Attorney General and State Department of Assessment and Taxation review to be certified that it follows the law. Of course, if something passes in a piece of legislation through Congress that says something will be sold, that would follow the law. But of course, we know there are other times when this current federal administration doesn't always go to Congress to ask permission. And so we want to make sure that if a sale is happening, it's happening lawfully. And the second thing it does is it puts an enhanced transfer tax on the subsequent sale. So we can't tax the federal government So what we do is after that land is sold, if that buyer then decides to resell the land, there would be an extra transfer tax on it that would help to go fund program open space. Now, let me just say that I know Delegate Pippi's not here, but I know there are many other constitutional lawyers on this committee, and I know people have different thoughts about, the permissibility of this. I worked as hard as I could with my former counsel. I don't know whatever happened to that guy, but our former committee counsel, who's blushing up there, to try to craft a bill that we thought made sense. But I, of course, leave it to you all. This is now your jurisdiction if there are better ideas. But while we're thinking about on the floor about how to keep certain things out, we also need to think about the other side of the equation, which is there are certain things we want to keep in. And we want to make sure there's not a fire sale of federal properties that would really be disruptive to our state and local economy. So that is the bill, Madam Chair. Appreciate the opportunity to present.
Thank you, Chair Corman. Okay. Delegate Turner.
Thank you. You said you had 3 things. I only wrote down 2. What was the third thing?
It was actually 2. I might have misspoken.
Oh, okay. I'm sorry. I'm taking good notes.
Perfect. Thank you.
There are no further questions. Chair Corman, thank you for your testimony.
Thank you.
There are no further witnesses. That concludes the bill hearing on House Bill 1009. We will now move on to House Bill 929, and we have our colleagues from Ways and Means as secondary. Welcome Delegate Young and Delegate Wims. Who is presenting for Carroll County? Delegate Rose.
Thank you, Madam Chair, and thank you, members of the House Economic Matters Committee and my friends from my former favorite committee, Ways and Means. I'm here today to support one of our Carroll County delegation bills, House Bill 929. House Bill 929 basically would allow our county to deny a issuance of a permit or inspection from renewing licensing or permits due to unpaid personal property taxes. This has been a problem that we have dealt with apparently for a number of years, and we do not have an efficient or effective mechanism to hold businesses responsible for their unpaid property taxes. So they continue to operate without penalty for failure to pay the tax. The only option at this point right now currently is that we would have to go through the county attorney's office and pursue a costly court proceeding. So basically, it's just allowing them to use this mechanism to deny the issuance of these permits if they have not paid the tax, and once they pay the tax, they can then move forward with the operation of their business. There was no unfavorable testimony submitted. Our delegation voted unanimously for this. We have a letter from the county available for you. It should be in your packet. And the Senate cross-file has already passed unanimously out of that committee. Happy to answer any questions, and I ask you for a favorable report.
Thank you, Delegate Rose. There are no questions. Thank you very much. I do have 2 people signed up, Anthony Nicholas and Pam Meister.
Good afternoon. I am Pam Meister, Carroll County's Legislative Liaison. I don't have very much to add. You did a great job, thank you, but I'm here to answer any questions that you have. I will say that the Senate version did pass with a small clarifying amendment that I will share that doesn't change anything important in the bill, but this just closes a clear enforcement gap and enhances accountability. So we ask you on behalf of the commissioners to please offer a favorable with amendments report. Thank you.
Thank you. Still no further questions, so thank you very much. And no further witnesses. That concludes the bill hearing on House Bill 929. We'll now move on to House Bill 913, Charles County Delegation, Governing Bodies. Is someone introducing that bill? No one? Okay, we'll skip to, is Delegate Allen here? We'll move on to House Bill 778.
How's it going, everybody? All right, Madam Chair, members of the committee, Delegate Pruski, great to see you all. My name is Nick Allen. I'm here today to testify in support of my bill, House Bill 778. I believe this is my second of several housing bills you're going to hear from me this session. Admittedly, I drafted a lot of those bills while I was on the committee that handled housing. So now you guys get to help me with that. So all of the bills that I'm working on this year, housing-wise, they're all different, but they're all proverbial tools in the toolkit. And the overall intent of them, I think, is the same. You guys have heard multiple times already this session, multiple times already today, and you will continue to hear how we are in a housing crisis, which in turn causes an affordability crisis. And I believe that the problem is largely one of supply and demand. We simply do not have enough housing supply. And I'm not talking about just so-called affordable housing, which my last bill you heard was all about. We need as much housing as we can get, and that's affordable, senior, silver, starter homes, and everything in between. This bill is about the in-between. This bill advances the concept of so-called middle housing, the types of homes that fall in between large-size, single-family houses and high-rise apartments. It uses the same definition we codified in 2024, duplexes, triplexes, quadplexes, cottage clusters, and townhouses. Simply put, these are the kinds of homes that Maryland needs more of, but too often does not build or does not allow. I mean, personally, I know in District 8, I can't remember the last time I saw a duplex being built. So House Bill 778 is a targeted bill. It applies only in areas served by existing public water and sewer systems, directing growth to places where infrastructure already exists or is planned. All middle housing must meet the public health, safety, and welfare standards, including building codes, and may be subject to adequate public facilities requirements. The bill promotes clarity and predictability by requiring local jurisdictions to allow middle housing by right on vacant lots existing before January 2015 in single-family zoning districts served by public water and sewer. It requires that at least 25% of those lots in new subdivisions of 20 or more single-family homes allow middle housing. It ensures setbacks that are no greater than those for single-family homes, exempting middle housing from minimum lot size requirements, limiting off-street parking to no more than one space per unit, and requires applications to be reviewed under the same procedures as comparable single-family homes. I think that's very important as well, because we don't want unreasonable limitations on building these housing types. The bill also overall establishes an affirmative duty for counties and local jurisdictions to evaluate vacant, unused, or underutilized commercial and industrial land for potential housing. Again, I know in Baltimore County we have plenty of that. This encourages a smart reuse of land already connected to infrastructure and creates new opportunities for homes in appropriate locations. And I know in a lot of jurisdictions when we talk about development can kind of be a triggering word, but for a lot of people, redevelopment is a much more palatable way to approach things. And that's one of the things we're talking about here. But I also want to be very clear on this point that this bill respects local authority. It does not eliminate zoning powers. Instead, it sets reasonable statewide guardrails while allowing jurisdictions to adopt policies and design guidelines suited to local conditions. It also preserves protections for historic properties or properties that are eligible for inclusion in the Register of Historical Places. So I view this proposal as a pragmatic one, not a radical one. Maryland communities were once built with duplexes, townhomes, and small cottage homes integrated into neighborhoods, but over time, many of these options have simply been zoned out or just not built. I'll also note that I have prepared sponsor amendments that narrow this approach even more. I know we talked about it in the interim. The bill was ended up being drafted a little more broadly than we had initially planned. So I actually, again, for the sponsor amendments, what they're going to do is they will limit the focus of the bill to priority funding areas. So these are the areas that, again, are prioritized for funding, but they're also the ones that really should be our most urbanist areas. And it pushes them to really kind of put their proverbial money where their mouth is and actually be urbanist if they're going to get this priority funding. So House Bill 778 also makes better use of existing infrastructure, and it expands housing supply in a thoughtful way. So if we're serious about addressing this housing shortage, and I believe all of us are, we must be serious about housing supply, and I view this as a meaningful step forward. I now turn it over to my panel, and I look forward to answering all your questions. Thank you.
Thank you again, Lisa May with Maryland Realtors, and we thank Delegate Allen for working with us on this concept. I was digging through some U.S. Census data from the past 60 years, just for fun in my spare time. It tells an interesting story. Housing production used to be much more varied. If you go back to the 60s and 70s, middle housing types were approximately 5 to 7% of the building permits that were pulled each year. By comparison, I pulled 2025, the most recent full year. Permits for 2, 3, and 4 unit buildings were 0.36%. 60 units over 16,000 permits that were issued last year. It's not because people are no longer interested in duplexes and triplexes and quadplexes. It's because we have more or less outlawed them through the zoning decisions that we have made over time. Now, single-family homes are going to continue to be the majority of homes built. That was true back then. It is true now. It will be true in the future. But this bill is going to help us get some of that diversity in our housing stock back and to give people choices and houses that fit how they live now. And so we think that is worthy of promotion. We think that that is worthy of discussion, and we ask for your support. Thank you.
Okay, I'm not seeing any questions.
Nailed it.
Thank you very much. And I appreciate your explanation of the context of the housing policies.
Thank you.
All right, next we have in-person Lori Graff. Okay. Dan Reed. Is Dan Reed still around? Or has he left? I saw him walking out earlier.
Hello, Madam Vice Chair, members of the committee. Lori Graff, CEO of Maryland Building Industry Association. We've already had a long day, so I will not be repetitive. We all agree we have a housing shortage. What we don't agree is how we get to fix the problem. So there's a lot of options. You guys are going to hear a lot of options. You already have heard a lot of options. This particular approach is very narrowly tailored. You heard about the sponsor's amendment. We've got to do something. We've got to do something now. Permit numbers are down. Again, you heard Ms. May talk about we can't build a lot of different products here. I will go out here after this session and I will spend a lot of my time in local jurisdictions trying to figure out how we can build housing and honestly fighting negative legislation on building housing. We have to figure out a solution, and we have to do it now before it's too late and we're losing more and more of our population. So with that, we ask for a favorable report. Thank you.
Thank you. All right, next we have unfavorable Dominic Butchko and Angela Bailey through Parry.
Sure.
I'm sorry, Dan, you just missed it. I think you just missed your cue.
Okay, thank you, Madam Sitting Chair and members of the committee. Angelica Bailey Thupari for the Maryland Municipal League in very respectful but strong opposition to this piece of legislation. This is, with all due respect, not a redevelopment bill. This is another major local preemption bill that was put forth without partnership with local governments. We were not aware of the PFA's amendment, but that's a good place to start. It's a good example of one of our major concerns with this piece of legislation, which is that it is attempting to push higher density development into already dense areas. Municipalities, if you've heard me say, we have 2 million of Maryland's residents. We only have 4 or 5% of the land area. Many municipalities are already struggling and doing their best and coming up with innovative and interesting ideas to solve our housing crisis and to be good partners on the ground in ways that work for our members, in ways that work for our residents with all of their unique, diverse needs, abilities, and resources. And this bill is not a useful tool in local government toolboxes. It is not fully baked. We have several other big bills that are before us this year that have been worked out in partnership with local governments, which we appreciate. So we want to be partners in fighting this issue, but this bill for us is not it. So we would request an unfavorable report. Thank you.
Madam Chair, members of the committee, Don Butchko with MACO here in respectful opposition to House Bill 778. First, I think we need to take a step back. Block by block zoning is an incredibly difficult task when you're at the local level, and doing it from the state level is even harder. Zooming in on the bill and one specific provision, they talk about allowing for housing on commercial as well as industrial properties. We already allow for housing in commercial areas. It's called mixed use. It's a tool that we use widely, but allowing for housing in industrial areas, allowing for residents to be where we're using chemicals, where there's processes, where there's environmental impacts, that's just unwise policy. Additionally, this committee is hearing a number of bills that MACO and MML have been working hand in glove on, as well as with the administration, particularly the Housing Certainty Act. There are several provisions in this bill referencing unreasonable standards. The way that those are written, they directly counter the Housing Certainty Act. They directly counter bringing more certainty to housing. We greatly respect the delegate. You will hear a bill from him later on. You may have heard of it, Bambi. Second best housing bill, maybe the best housing bill of the session. But this one in particular needs a lot of work, and it needs a lot of work in the next 46 days. And so with that, we urge an unfavorable report. Thank you.
Did you speak, Angelica?
Yes, thank you, Madam Chair.
Delegate Chi.
Thank you, Madam Chair. So I appreciate your concern, but my question is, are you concerned simply because of where this might apply, or you're concerned in principle of converting, let's say, industrial zoned land to housing? Because there is a tendency for some jurisdictions in losing their industrial land because they get upzoned, right? So like in Montgomery County, this is an issue, but I don't know if that is your concern. It's just, you know, in general, you don't think it's good policy.
I think we have several concerns with the way the bill is crafted, that being one of them. There are difficult sections in here that are difficult to interpret. There are sections in here that we view as potentially competing with each other, or one potentially overlapping the other. The industrial one is a particular one. It's very odd to say that we're going to combine residential and industrial use. Residential and commercial we do all the time. That's a downtown. But industrial in particular is niche. I do want to.
Yeah, and there are logistical and pragmatic reasons for that. In a lot of cases, for example, train tracks will run through industrial, but residents don't want that in their neighborhoods. Think of an Amazon warehouse or a CXS train line. I'm thinking of Canton in Baltimore City, for example, which often backs up with lots of traffic because there is the rail station or the rail tracks that go right through and causes a lot of congestion. People don't want that where they're living, and they don't want their kids to have to cross those train tracks. And they don't want the traffic that comes with the Amazon warehouse. It's often zoned that way for a reason, which also, you know, we didn't touch on comprehensive plans, which, as we've said in this committee before, is a major democratic process that involves your current residents and what they want their communities to borrow a phrase from Dom, look, smell, and feel like. And it's often very intentional that there is not residential and industrial mixing together.
Seeing no further questions, thank you very much for your testimony. Seeing no other further witnesses, that concludes the bill hearing on House Bill 778. I'm going to go back. Is there anyone here to present House Bill 913 for Charles County? Nope. Okay. I also don't see Delegate Rosenberg, Taylor, or Addison. Are you here? Nope. Okay. Then we'll move on to Delegate Holmes. With House Bill 951.
And the crowd goes wild. Good afternoon, Madam Chair and Vice Chair and members of this wonderful committee. It's so nice to hear you all talking about this, one of my favorite subjects. No, my most favorite subject. Before you right now is House Bill 951. And this is a very simple piece of legislation, and it's just a matter of trying to fix some archaic ways things are done in the court system. And so that you don't get bored in hearing my voice for the rest of the afternoon, members of the committee, I'm going to turn it over to my friend Mahassan El-Amin, who is the clerk of the Prince George's County court system, to explain in great detail in terms of how this bill will make things much better for the court system. If you don't mind, Madam Chair.
Not at all. Welcome.
Thank you. It's a pleasure to be here. Thank you, Madam Chair. Thank you, Delegate Holmes. And thank you to the members of the committee. For the record, my name is Mahassan El-Amin, and I have the pleasure and privilege of serving as the clerk of the Circuit Court for Prince George's County. And I am here on behalf of the Clerks Association and all 24 clerks. I am asking that a favorable report be issued for HB 951 because it removes the 3-inch margin requirement that we had put in place in the last bill last year because it has been proven to be unenforceable. We are getting recordings that have been shrunken so we can't see them, and we can't charge the 3 times fee when we do get margins that are outside that 3-inch margin. So it's basically fixing that problem. Very simple. The other simple part of the bill is to remove, is to add back the language that was inadvertently deleted so we can keep track of the changes that are made to recordings. It's really important for researchers, title searchers to basically document the changes that are on recording. So those 2 changes in of itself make it a very simple, easy bill. And once again, we would ask for a favorable report. And I am here to answer any questions. And once again, thank you, Delegate Holmes, for your sponsorship and continued support.
Seeing no questions, thank you very much. I'm just making sure this was 951. Yes, there's no other witnesses and no questions and no other panelists, so that concludes the bill hearing on 951. Delegate Holmes, if you would be so kind, so you have 3 bills, 3 more, and I know they're not short. If we could let I saw Delegate Taylor walk in. Is she in here? Oh, there she is. With 920, Delegate Taylor?
All right, start with 920.
So colleagues, we're somewhat out of order because legislators weren't present, so I had to keep moving along.
Look, I understand. Okay, good afternoon, Chair Valderrama and members of the Economic Matters Committee. For the record, my name is Delegate Kim Taylor, representing Prince George's County's District 23. I'm actually excited to be here today to provide testimony for House Bill 920, which is one of 4 bills that address the Black Caucus priority to address appraisal bias in Maryland. First, let me give you some background. Back in 2020, 2021, I was the HOA president in my neighborhood. We had several lots that had not been built upon yet, and one of the lot owners called me and asked, is it the reality in Prince George's County that you will pay more to build a home than it appraises for? And I said, well, I don't know, because I actually purchased a home. So I started to make phone calls. We called a friend. I called Delegate Marvin Holmes. I called the Prince George's County Realtors. We called Kristen Jackson. We ended up with conversation and meetings with the Fair Housing Alliance. And with conversations with some of my other neighbors, we found that one neighbor had gotten an appraisal recently at that time I had gotten an appraisal recently, and around the same time, for collateral loan for a business acquisition. There was another that was refinancing in my neighborhood that got a appraisal, and then there was one that was turning construction into permanent. We all got the same appraisal. And we were shocked. It's like, how can that be? The problem was there were no comps. An appraiser can only use what is in the system. That led actually Delegate Holmes at the time, well, he's still Delegate Holmes, but that led Delegate Holmes to propose a bill that passed that established the Property Appraisal and Valuation Equity Task Force. That was in 2022. The task force was charged with identifying policies to reduce bias in property valuations through enforcement, compliancy, and transparency. The task force completed its work in late 2024 and had several recommendations. One of its key recommendations was the timely reporting of new residential construction sales through a multiple listing service or similar mechanism. Thus, we have House Bill 920, which requires a developer, builder, broker, or real estate agent to report the final sales price of a newly constructed home into a multiple listing service within 30 days of the sale. Limited access to new construction sales data can constrain the availability of comparable properties, particularly in growing communities and communities of color, where appraisal gaps and undervaluation concerns have been documented. Accurate comps or comparables are essential for fair property valuations, for responsible lending decisions, and to ensure Maryland's homebuyers are informed. Since last session, there have been many productive conversations over the interim with stakeholders, including members of the real estate industry and representatives from Bright MLS. And Bright MLS is actually the portal that garners most of the MLS business in this entire region. I have specifically suggested to Bright that they consider developing a reporting product or platform structure that would be amenable to developers and builders. One that recognizes the operational differences between traditional resale listings and new construction transactions, while still ensuring the transparency that this bill seeks to achieve. And that was in response to some of the opposition from last year's bill hearings. My goal is not to create burdens, but to create collaborative consistency and accessibility in sales data that would strengthen Maryland's overall housing market. And to conclude, which I know you're happy that I'm concluding, by requiring timely reporting of final sales prices for newly constructed homes, this legislation advances transparency in pricing, market accuracy through better data, and equity in access to information. And it's for these reasons I respectfully request a favorable report on House Bill 920. Thank you.
Good afternoon, Chair, members of the committee. My name is Christian Jackson. I'm a certified residential appraiser in the state of Maryland, 20 years of experience, and I've submitted full written testimony for the record in support of HB 920. HB 920 simply requires that within 30 days of closing, the final sales price of a new home be entered into the MLS or a similarly accessible database. It does not require builders to market their homes through the MLS. It only requires that once a sale is completed, the details of the sale be reported. In Maryland, the MLS is no longer just a marketing tool. It is the most reliable and centralized source of verified residential sales data used by appraisers, realtors, lenders, and consumers alike. Currently, builder reporting is inconsistent. Some report all sales, some report selectively, and some report none. And that creates huge gaps in market data. Complete and accurate data is essential for credible appraisals. When new construction sales are missing, it affects valuation accuracy and can unintentionally create inequities in the lending process. This bill promotes transparency, strengthens data integrity, and supports fair and equitable housing outcomes. I respectfully urge the committee to give HB 920 a favorable report. Thank you for your time.
Thank you, Madam Chair. Again, Lisa May with Maryland Realtors. We are here favorable with amendments on the bill. We certainly agree with the spirit of this legislation. More data informs better appraisals. You can make better decisions. I think that that's pretty straightforward. But since this is a new committee and you didn't have the privilege of sitting through this discussion last year, we just wanted to explain for those who are not familiar what the multiple listing service is. This is used mostly, as was mentioned, to market resale homes for sale. New home entry, use of the MLS for marketing new homes is really dependent upon the market, the type of development, the type of builder, whether they need that exposure or whether they have a separate marketing plan on their own. But Bright MLS, which is the one that covers the entirety of Maryland and several other states, is a private corporation. It charges a fee for its service. It has shareholders to which it pays dividends. For our purposes, those shareholders are the local realtor associations that are in each of your communities. So the Anne Arundel County Association, Prince George's Association, and so forth. Because of that, we just want to be very, very clear. There is a real possibility that our local realtor associations could profit from the passage of this bill. We just want to be transparent about that. That might not be the direction that you want to go. You may not want to say to an industry, you know, the government is telling you that you need to use this other private company and pay for their services. And if so, then we would encourage you to look at the clause within the bill about how we can develop another type of database, whether it's through the state of Maryland or somewhere else, to sort of get around that part of the bill. Thank you.
Thank you. We'll start with Delegate Weigel.
Madam Chair, I'm sorry, we have a witness on.
Oh, is she part of your panel?
Yes.
We do have one. I didn't know she was part of your panel. Okay,
Thank you.
Jacqueline Priestley.
Good afternoon, Madam Chair, Madam Vice Chair, and other members of the committee. My name is Jacqueline Priestley. I am a Prince George's County resident and co-founder of the Fair and Unbiased Appraisal Advocates. I also recently chaired the state task force that Delegate Taylor mentioned on property appraisal and valuation equity. I submitted a written testimony, and I'm also here virtually today to express my support for House Bill 920. In 2021, as the construction of my family's home was nearly complete, my husband and I prepared to move from a construction loan to a 30-year term loan. And during that process, we received appraisals that we felt didn't accurately reflect the actual market value of our home. So given our experience and the many examples that Delegate Taylor just shared a few minutes ago around other new builds, refinances, et cetera, we wanted to rectify this situation. So my husband and I had our home listed on the MLS after we closed on the purchase to reflect our actual build cost. In listing our build cost, other families that I just mentioned, the examples that were shared, were able to order new appraisals. They were able to use our transaction as a comp for themselves, and were able to secure new appraisals that reported their homes at higher values. And so in short, this approach of listing all transactions on the MLS works. It is simply a move of transparency. Additionally, as part of my work with the task force, we examined the approach and impact of adding the final sale price of a new home into an MLS or similarly accessible database. So we noted in our report that, quote, the task force believes that timely reporting of new construction sales will increase transparency in sales prices and help provide sufficient comps in neighborhoods that would otherwise have insufficient sales data to determine an appropriate opinion of value, end quote. Opponents of House Bill 920 state the MLS shouldn't be used and that instead the State Department of Assessments and Taxation data is an existing alternative. However, on February 20th, 2024, during a task force monthly meeting, then SSTAT Director Michael Hicks stated, quote, With SSTAT, the law is very clear that the only thing that SSTAT's data can be used for is the issuance of tax bills. Nobody is allowed legally to rely on them to issue any appraisals or for any other purpose. For these reasons, I urge the committee to issue a favorable report on House Bill 920. Thank you.
Thank you, Ms. Priestley. We'll start with Delegate Weibel, then Adams, Roberts, and then Queen.
Thank you, Madam Chair. My question was in regards to what is the best source for this information. And so I know in the old days when you recorded a deed at the courthouse, it would reference like $1 or more or whatever. But today, are the actual sale prices listed in the deed, or is it still vague?
On the deed?
Yeah. So when you record that at the courthouse, does it list the sale price or no?
I don't think it's recorded. Do you know the answer to that? I don't know the answer to that, but I know that those records eventually get to SSTAT so they can charge you for your tax bill. But yeah.
So SDOT will record the sales price, and they'll have a recordation date for when it gets recorded, not from when it actually transferred. And a lot of times sometimes it'll take 3-4 months before it actually pops up.
So is SDOT getting their information from the courthouse? Or are they getting their?
Yes.
From the
So they do have it.
Correct. But it's just the sale and the sale, the recordation date and the sales price. That's the only data you get with that.
Okay. All right, thanks.
Thank you, Chairs. So the problem that we're trying to solve is that the appraisals are coming in low. Is that the problem? And
Yeah, I mean, they're coming in lower than you would expect. In my case, my appraisal was actually $300,000 less than I paid for my home. I would think if Ms. Priestley's still on the line, her home was the same home that her builder owns and built himself, and the home in Montgomery County, which was pretty much exactly the same as the home she has, was about $1 million more valued than her home. So typically in Prince George's County, no matter where you are, even if you're close to the water, which, we all know in Annapolis, waterfront property is prime and, really, really valuable. But even in Prince George's, you'll find homes right there on the water, great views of the city, very near a metropolitan area like Washington, D.C. Still, you're not going to get the appraised value that you would have thought you would get. And it's just unfair that just because of where you live, your homes are valued lower.
And so the follow-up question to that is, you believe that by including new home construction in the universe of properties, that in essence raises the valuation of all the properties? Is that the?
Delegate Adams, may I address the question?
Sure. Yeah.
Sure. So in my experience as a homeowner in Prince George's County, for example, I've bought properties in DC and in two properties in Prince George's County. The issue is that we're one of the few areas around the Beltway where there is still land to build. So we're not squeezed in the same way, perhaps, as other neighboring jurisdictions. What that means is there are a lot of new homes still being built, thousands of homes being built. And every time that a new construction is built and someone wants to buy that home, they can't, so 1,000 homes are built in the county this year. And those 1,000 homes are going to go for sale for next year. 1,000 homes could not be considered as comps. And that's a very unique reality in Prince George's County, Maryland, because homes are being built, outpacing other jurisdictions perhaps, and those homes cannot be used because there's no public information for which appraisers are looking at to use those properties as comps. They're only looking at resale properties as comps.
All right, last question, and that is, that's all right, I got that. The last question is, have you looked into whether there's a difference between the appraisal that comes from a bank order appraisal versus one that you would get privately?
Well, usually they're bank ordered. In my cases, they've been bank ordered for one reason or another.
I see.
But
So
Yeah.
in the process between a privately ordered appraisal and a bank ordered one, from a value perspective, doesn't change much. You're still going off of comparable data. So as an appraiser, this bill is super important. It's something that appraisers have been squawking about for a long time because we don't have the data to make assessments whether or not we're coming in over or undervalue. We're only limited to what, say we're appraising a house inside of a new construction community, let's just call it South Lake and Bowie. I'm at the mercy of the builder to give me whatever comparables they can give me if they don't record them.
I'm just going to reinforce it. So you don't discern a difference in your testimony between a bank-ordered appraisal and one that you just call an appraisal company and say, appraise my property?
From a value perspective, correct.
Delegate Adams, may I address your question as well?
Go ahead, Ms. Priestley.
The example that I gave, that when we had a realtor put our actual bill costs onto the MLS, that one action enabled at least 2 other properties I know nearby to appraise for what they wanted, whereas those exact same 2 properties prior to that were appraised for significantly less. That proves that with more data comes better accuracy in the actual appraisals of homes.
Thank you so much for that answer. Delegate Roberts? And just direct your question to whom it will be.
Thank you, Madam Chair. And my question is addressed to whomever can answer it.
Okay.
But the first person gets the dibs. I was looking at the unfavorable written testimony for MBIA, and some of the issues that they were saying was also data is verified and on SDAT website. MLS is designed to be a sales tool, not a tool for appraisal. So where does SDAT fit into the MLS conversation for you all?
So SDAT honestly gives us very minimal data. We have address, date, price. Sometimes we have to go off of that, but we also have to wait 3-4 months before it actually pops up in that stat from a sales perspective. So real-time sales data is essential. And the MLS, while it was originally meant for marketing purposes, appraisers mainly use MLS for our data. That's our first stop that we go. So if we have to go dig in SDAT, sometimes we'll have to go to the builder itself to get comparables. There's one builder in particular I know of that we have to go to their corporate office to get comparables, and they're not even local. So, I don't know what comps they're giving me. I don't know if they're giving me, all the comps, or they're just giving me the ones that they want to give me, they're cherry picking them. So just transparency in the data is essential for us to do our job.
Okay. All right, thank you. And then my second question, I just wanted to read this part of their letter. It says, this bill does not address the housing affordability issue in Maryland. HB 920 does not increase supply, reduce regulatory barriers, streamlines permitting, or lower costs. Instead, it adds another layer of compliance at a time when Maryland needs more housing production. But that's not the purpose of this bill, right? The purpose of this bill is to...
The purpose of this bill is to make sure there are comps available in the market so our appraisers can accurately value our homes. Also, it gives us a sense of transparency, as if we don't have comps for recent home builds that are sold, how do you know how much they sold for? There could be a 900 unit development, and if only 2 or 3 of the homes out of the 400 that have been sold are put in the MLS, how do you, our appraiser here has said they actually have to go to the builder and find out how much the homes have been sold for. And then how do they know that what they're given is all the information and not just cherry picking like he mentioned? So,
Okay.
Yeah, it's all about transparency and making sure we have accurate data available.
Thank you. Thank you, Madam Chair.
Thank you, Madam Chair. So I think my question is going to go to Lisa first, Ms. May. So you cautioned us about using, I guess, this one vendor. Is it just one vendor that does the comps for all of Maryland?
So there is one MLS, one multiple listing service, and that is unique. There are states that have multiple ones that maybe even down to the county level for their MLS. But we have had sort of a super regional MLS for at least 20 years, possibly. So our MLS covers portions of Virginia, Maryland, Delaware, New Jersey, Pennsylvania. I think it goes a little bit into North Carolina. Okay, yes, Christian's backing me up here, so thank you. So yes, we have one in Maryland.
So I guess I'm kind of concerned, I guess I'm confused because as the delegate mentioned, we don't have this issue in Montgomery County as much. I know a couple of areas where people will complain that, hey, this was a little different than the same builder in this other zip code, but not like the degree that we see with Prince George's. So if it's one system, is it just why are particular areas not getting those comps in as quickly?
Well, Delegate, it may actually not have to do with the comps. There can be a lot of factors. I think many of you who have been around a while remember that we had an appraisal gap financing bill because there are some historically underserved, undervalued communities whose property tax values were just as the delegate described them, that it was essentially costing more to build the home than what the market price of that home would be reflected. And so the state created this appraisal gap financing program to help build homes where it costs more to build them than it would cost to sell them. So some of that is rooted in historical appreciation. Some of it could even be rooted many years ago in redlining or other discriminatory practices. But then you also get regional variations in home builder activity. Some may use the MLS to market their homes more in certain areas of the state than they do in others. That could be market-based, that could be local custom, that could be the type of home builder that's operating in that area, a large national home builder versus a more local custom or infill home builder. So there are just a whole lot of variables that can go into, in my opinion, why that is the case.
Okay, thank you.
Seeing no further questions, thank you very much. For your panel, we'll move on to the unfavorables. Lori Graff.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Lori Graff. I'm CEO of Maryland Building Industry Association. I'm here in respectful opposition. First of all, I'd like to thank the sponsor. We spent a lot of time over the interim. We've had many meetings about this. I was on the Appraisal Gap Task Force. I was opposed to this part of it. There's a bunch of records on that. So we have some concerns. It's not about transparency for us. That is not a concern of ours. Our concern with this bill is that you are mandating our industry to use a privately owned company, and that is what MLS is. The bill requires us to enter sales price that is in SSTAT. If we have issues with how SSTAT does it, which I will tell you certainly we have some concerns about how SSTAT operates, we'd love to have that conversation. But this bill mandates us to use MLS, which is a realtor tool. That's what it was designed for. And that's what it is. And some of our members use it, some of them don't. They have to subscribe to it. You have to join it. You can't just go in and put in the sales price. You have to do a whole entry. They have a lot of rules of how they operate and what they're looking for when you are a member of MLS. So with that, we happy to work on some solutions. We believe that we'd be happy to figure out a better way to do it. We just don't think that this particular bill is that way. So thank you.
Thank you. I don't see any questions for you, Ms. Graff. Thank you for your testimony this afternoon. There are no further witnesses for this bill. That concludes the bill hearing on House Bill 920. Delegate Taylor, since you're here and your next bill is like you, we'll take that up. And I know we are going out of order, so anyone who's here waiting, appreciate your patience, but when we were calling down the list, folks weren't here to testify. So. Pardon? No, I know that someone from Charles County is coming, but Delegate Taylor had a bill right before this, so.
Okay, since it's just me, my testimony is going to be a lot longer. Just kidding. Chair Valderrama, Vice Chair, and members of the committee. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. As amended, and I'm hoping you have the reprint, House Bill 810 requires the State Department of Assessments and Taxation, or SDAT, in coordination with the Maryland Judiciary, the Maryland State Police, law enforcement agencies, and the Office of the Attorney General to conduct a structured study evaluating whether blockchain-based tools could strengthen how real property ownership is recorded, verified, and accessed when disputes arise. The primary motivation behind this bill is a growing procedural challenge involving squatting and fraudulent occupancy claims. Law enforcement officers are increasingly responding to properties where individuals present questionable leases or documents, and even when a lawful owner holds the recorded deed, officers must treat the matter as civil because they lack a rapid, secure way to verify ownership in real time. As a result, homeowners can face lengthy court processes while their property remains unoccupied or unsold. House Bill 810 does not change eviction law, expand police authority, or alter judicial due process. It simply directs the state to study whether modern technology could provide a more secure and reliable verification tool to help officers, courts, and property owners distinguish legitimate ownership claims from fraudulent paperwork. This bill directs the state to study whether blockchain technology, which is, it's going to get technical here, a distributed ledger designed to create tamper-resistant, time-stamped records, which could enhance the integrity and accessibility of property information. If such tools were explored, they could allow authorized users to quickly confirm whether a title record matches verified state data, reducing confusion during high-stress encounters involving alleged trespass or squatting. And we've seen some of that on TV recently. This legislation is exploratory. It does not replace Maryland's land record system, does not create legal property rights, and does not remove judicial oversight. Any potential application would remain subject to existing privacy protections, procurement standards, and coordination with the judiciary and law enforcement partners. The goal is simply to evaluate whether a secure digital verification layer could support faster, more consistent decision-making when ownership disputes occur. By directing the state to study this issue in a measured and collaborative way, we can determine whether emerging technology can help protect homeowners, support law enforcement, and strengthen public trust in our property systems. For these reasons, Madam Chair, I respectfully request a favorable report on House Bill 810.
Thank you, Delegate Taylor. Delegate Weigel.
Thank you, Madam Chair. Just one question. Have you seen the fiscal note?
I have. But the fiscal note you're looking at, I don't think is attributed to the study.
So is that?
It's prior to the study.
That's the, based on the old bill?
Yeah, we changed it.
Okay, thanks.
You're welcome.
Seeing no further questions, thank you, Delegate Taylor.
Thank you.
Seeing no other witnesses, that concludes the bill hearing on House Bill 810. We will circle back to HB 913 for Charles County. Someone's here to present? Great.
Good afternoon, Chair, Vice Chair, and members of the Economic Matters Committee. I am Ariel Moore, Chief of Staff to Delegate Deborah Davis. She could not be here today. I am here to request a favorable report for House Bill 913, a bill designed to enhance the governance of common ownership communities in Charles County by requiring essential training for members of their governing bodies. This legislation is a necessary step in ensuring that community associations operate effectively, transparently, and is in the best interest of their residents. We have received a unanimous support from the Charles County delegation along with the Charles County commissioners. Furthermore, this bill will improve community governance, enhance transparency and accountability, reduce conflicts and legal issues. This legislation is a proactive measure to support the sustainability and well-being of common ownership communities in Charles County. By implementing a standardized training requirement, we can foster stronger and more effective leadership and enhance the quality of life for residents. Therefore, I respectfully urge the committee to issue a favorable report on House Bill 913. Thank you.
Thank you. I don't see any questions for you. We'll also, but we do have virtual witnesses. Eileen Lynch Britt.
Hello, Madam Chair. Can you hear me?
Yes.
Okay. Hello, Madam Chair and esteemed members of the committee. My name is Eileen Britt, and I serve as an HOA board president in Charles County and as a co-founder of the HOA Alliance in Maryland, where we support and train local HOA leaders who are doing their very best to serve their neighbors. I rise in support of House Bill 0913. This bill is personal for us. Every week, we work alongside volunteer board members who are teachers, veterans, retirees, small business owners who have stepped up to lead because no one else would. They are entrusted with managing millions of dollars in collective assets, reserve funds, stormwater systems, contracts, and the largest investment most families will ever make, which is their home. And yet we ask them to do this with no required foundation in fiduciary duty, financial oversight, or an understanding of Maryland Community Association law. We see the pressure they face. We see the confusion. We see the mistakes that can happen, not out of malice, but out of a lack of guidance. In Charles County, we've partnered with our community commissioners and the College of Southern Maryland to provide governance education. We're actually establishing it right now because our leaders have asked for help. When they receive training, we see the measurable differences, fewer conflicts, stronger financial controls, clear decision-making, and restored trust between boards and homeowners. All Charles County commissioners support this bill because they understand that strong governance protects infrastructure, stabilizes housing, and strengthens communities. House Bill 913 is not punitive, it is protective. It is not burdensome, it is foundational. It gives leaders we support the tools that they need to govern confidently and responsibly. When we equip volunteers with knowledge, we reduce costly errors, we build competency, we build trust. On behalf of HOA leaders across Charles County who simply want to do this work well, I respectfully ask for your support of House Bill 913. Thank you.
Thank you, Ms. Britt, for your testimony. I don't see any questions for you. We'll move on to our next virtual, Danielle Mitchell.
Good afternoon. Good afternoon, committee members. This is Danielle Mitchell. I'm the Acting Deputy County Administrator for Charles County Government. I'm here on behalf of the Board of Charles County Commissioners, urging a favorable report on HB 913. I really just second everything that Ms. Britt and Ms. Moore have said so eloquently. This is something our commissioners fully support. It's really, I think, probably the third year that we've submitted something similar. In terms of just hearing back from our community members. We go through a process every fall where we seek legislative proposals from residents, and this comes to us each fall for at least the last 3 years that they are desirous of at least minimum standards for training of these HOA and common ownership communities. So I would just again urge a favorable report, and then I would only add that we may need to look at how we go about, like this could very well be an online training program. If we have the resources to do it, we would like to expand it into something more comprehensive, but we really want the ability or the backing to say that it is mandatory, which is why we're seeking state support. So if there's no questions, I just thank you for your time.
Thank you, Ms. Mitchell. Seeing no questions for you as well, and no further witnesses, that concludes the bill hearing on House Bill 913. We'll now move on to House Bill 59. Delegate Addison has joined us. And we're also welcome, we have Judiciary serving as secondary. We have Delegate Williams with us as well.
Alana, you can sit right here. Good afternoon. Good afternoon, Madam Chair, Vice Chair, and the members of the Economic Matters Committee. For the record, my name is Delegate Jackie T. Addison, and I'm here to testify in support of House Bill 59. I will be sitting in as my intern, Alani Naper, will do the testifying on this bill. And I also would like to add that I do have an amendment for this bill as well.
Okay. Good afternoon, Madam Chair Valderrama, Madam Vice Chair Charkoudian, and members of the Economic Matters Committee. My name's Alani Napier, intern for Delegate Jacqueline Addison, and I'm here in support of House Bill 59, wrongful detainer proceedings. This bill seeks to streamline and strengthen the legal process for property owners who fall victim to wrongful detainers, ensuring that they have a clear and expedited path to reclaiming their homes. Imagine returning home after spending 90 days away in the Maryland General Assembly, only to find strangers living in your house. Your front door locks have been changed, your personal belongings are either gone or damaged, and the people inside, who have never met before, claim they have a right to stay. You call the police hoping for immediate assistance, but instead you are informed that this is a civil matter requiring legal proceedings that could take weeks or even months. You are now homeless in your own city, facing a legal battle to reclaim the very home you worked so hard to maintain. This is the harsh reality that many Maryland homeowners have faced due to current gaps in the law. In Bethesda, Maryland, Tamika Good unlawfully occupied a $2.3 million home and occupied it for nearly 9 months while neighbors lived in fear, and the case slowly moved through the courts. Ms. Good was charged and even taken into custody at one point, but after being released, she returned to the property, further prolonging the ordeal. Although she was ultimately convicted of trespassing and breaking and entering, the drawn-out process exposed gaps in enforcement and the difficulty property owners and communities face in resolving squatting situations quickly. This case illustrates why stronger, clearer procedures are needed to protect homeowners and prevent prolonged unlawful occupancy. Wrongful detainers, commonly associated with squatters occupying homes without permission, have become an increasing concern in Maryland and across the country. The National Rental Home Council reports that squatters have exploited legal loopholes, delaying evictions and costing property owners thousands in legal fees and damages. House Bill 59 aims to close these loopholes by ensuring a more efficient legal process for homeowners facing wrongful detainers. The bill clarifies the legal definition of unauthorized occupancy and establishes expedited procedures for property owners to regain possession of their homes. It balances the need for due process while preventing abuse of the system by those who unlawfully take over residences. By passing House Bill 59, Maryland will take a significant step toward protecting homeowners from wrongful detainers and ensuring that property rights are upheld. I respectfully urge a favorable report on this bill. Thank you. Thanks.
I don't want to follow that if you want to follow it. All right.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is Nicholas Blendy, and I'm an assistant sheriff in the Baltimore City Sheriff's Office. We are here for informational purposes on House Bill 59, as we are the ones who do all of the evictions in Baltimore City. And I believe Delegate Addison had a version of this bill in last year, which we did support because the status quo going into last year was very much in need of change. The General Assembly did take action in the vein of the current bill before you, in which we, I think, agree is the correct way to do it, which is to expedite processes for egregious situations in the judicial forum. Deputy sheriffs in Baltimore City, and usually in all of your counties as well, are the ones who do the evictions. I can speak on behalf of our office. We do not act as street judges, so what my peer here to the right said in her testimony is true. It is a civil matter. And so an expedited process in front of a judge to hear the case is, we believe, the way that things are going. Last year, you did create an expedited process. I believe you get a court date within 10 business days. And for our purposes, what we care a lot about, too, is the due process to the occupants. We are required to serve, when you file your case, within 4 business days, 5 different ways. We have to do 2 different types of mailings. We have to knock once, knock on a different day, and then if all unsuccessful, post the notice at the door. The delegate's bill before you is in that vein. It is, in our opinion, a prudent way to think about things. And I'll just say this, these are real problems that we see in Baltimore City. So the delegate is speaking from facts that we see on the ground. I don't think that this is an issue that's going to go away, and I do think it's going to require continued attention and potentially additional actions from this committee. Happy to answer any questions. Thank you.
Did you say your name is Sam?
No, I'm sorry. That's my boss. I don't know why I came in that way. My name is Nicholas Blendy. I'm the assistant sheriff. Sorry for the sign up.
Again, Madam Chair, Lisa May with Maryland Realtors. And as was mentioned, last year we did pass legislation that was a compromise that applied to all forms of squatting which may occur in the state. But the ones that we see and that our members see, we think are worthy of maybe some further consideration and refinement. When properties are listed for sale or lease, that is a public announcement that this home is either currently vacant or about to be vacant. And it's a nice little invitation for someone who's looking to illegally occupy a property. And in practical terms, what happens if a squatter shows up before settlement, that home sale is likely not going to go through. I don't know a lot of people who would continue to buy a property if someone is occupying it and you have no idea when you will be able to get them out. If they arrive after settlement, that's almost even worse. The new owner or the new tenant, in the case of a renter, has already given notice at their prior rental or has already sold their homes. They have packed up, they have put things in boxes, their things might even be on a moving truck, and now they're stuck. And they don't know exactly when or for how long they're going to be out of the property that they have just agreed to legally occupy. So we do appreciate the sponsor recognizing this, bringing this forward, and we look forward to working with this committee on possible solutions. Thank you.
Thank you. So in the example, Delegate Addison, that you provided, or that your intern provided, and I guess it was in Montgomery County, the $2 million home, how does one get in there? Or was she the prior owner? Or I'm just curious, how do they even squat there? How do they get in?
So most of the times when people are swatting, what they do is they change the locks on the door. Just for the record, I have a swatter that lives 2 doors from me who has been living there for 4 years now. Yes, and this is the reason why I brought this bill. 4 years now she's been living there. What they did was they got a fake lease, moved in, it was vacant, they moved in, the homeowner was fixing up the property to rent out. They moved in. I guess they wrote around the block, noticed that no one was living there. They moved in, changed the locks, and by the time that he noticed that someone was living in his house, it was too late. They had already had a lease. The police came and said to them, we can't do anything because they had a lease in their hand that they went out and they purchased from like a Staples or one of the, yes, it happens. My spotter still lives 2 doors from me today after 4 years. So that's how they get in.
Delegate Chi?
Thank you, Madam Chair. So I'm trying to understand. Can you think of, I'm trying to understand what kind of people demographically are likely to commit this squatting offense, right? Are they relatives who claim a stake in the property? Are they likely to be people who already used to live there and think they have a reason to go back? I mean, is there any relationship between, is there a pattern that you can point to say, usually these are the people who are likely to go in, or are they just random opportunistic people who really shouldn't be near the property at all because they have nothing to do with these properties?
If I may answer for the delegate, I think that's a great question, delegate, because you're hitting at something that's confusing in the reporting that probably should be clarified. Every squatter case, if you think of a squatter as someone who is the situation like the one that Delegate Addison just described, is removable through a wrongful detainer action. However, not every wrongful detainer action is related to a squatter, if you want to think of it that way. Like all A's are B, but not all B's are A. So for example, wrongful detainer, there's 4 ways you can get somebody out of a property through a civil action in Maryland. Failure to pay rent, summary ejectment action, tenant holding over, and breach of lease. All 3 of those are for legitimate landlord-tenant relationships involving leases or oral agreement arrangement or overstaying a lease term as a tenant holding over. This 4th action, wrongful detainer, is when there is no landlord-tenant relationship. So that can be a relative that you allow to stay in your property because you're trying to do the right thing, and then they have overstayed their welcome and they have no right to stay. You would use a wrongful detainer to remove that person if they wouldn't move out voluntarily. However, these are also what you use for somebody who is either committing a fraud scheme, like the description that Delegate Addison has given you, where they've dummied up a lease and are saying, oh no, I'm supposed to be here, and the local law enforcement will walk away and say, you got to go in front of a judge and get me a paper before I can put you out. Or what we also see in Baltimore City, and I think is common around the state, somebody who's the victim of a scam where somebody sees one of these rental properties and is like, oh, I saw a realtor box on it, so let me go chop that box off, go find somebody on Facebook Marketplace or on Craigslist, if people still use that, or Reddit, I don't know. And then they go and give somebody a deal that's too good to be true. And then those people, it's a double victim at that point, because you not only, as the owner of the property, losing the right to possess and control their property, you're also having somebody who's now probably paid $1,000, $2,000 on Cash App or something like that for a security deposit, gets the keys that the person took off the lockbox, and then goes in there, and then they come and find out when the real owner comes in, or the realtor company or whoever is like, what are you doing here? So it's an extremely complicated issue, and that's why from our perspective, we said that we don't think this was one that's going to not need tweaks or go away, but you know, we appreciate the delegate bringing it to attention. I hope I answered your question in a helpful way.
Is there any circumstances under which a person may need more time before he or she is successful? Because I'm reading the Maryland Legal Aid argument, which is unbelievable, right? It was pushed back against this bill, saying that's not enough time, which is on the argument of due process.
Yes.
So I'm trying to understand, why is it important for the squatters to be given enough time? Is there any legitimate reason for a person to occupy a property?
I mean, I think I assume their argument, without having read it, because I would make it if I was them, is that not everyone is going to be a bad actor, and sometimes, you know, you could have a nefarious property owner abusing this power because they know that their tenant's going, or they know that this person's maybe going on vacation. And so if you shorten the window for due process notice, right? Because we're just talking about notice, right? Can you make a knock attempt? Can you send a mailing? Can you post a notice? If you do not give them adequate time, then their procedural due process rights are probably not being satisfied from that perspective. Again, that's why it's a really complicated issue, because as we see in the sheriff's office, those of us who do evictions, we want as much process as can be given within a reasonable amount of time, because that reduces negative conflicts at the time of an eviction. If everybody's on the same page that you got to go and be out, they tend to be out before you have to use the force or threat of force to move them out and change the locks. And that's the best outcome. Everyone is, a court order is being obeyed and a peace officer is not required to take any action. So there is something, and for us, the current law that went into effect on October 1st, it does give us a really quick turnaround and we have had to dedicate an entire, we were able to do it with existing resources. So I'm sure that you would hear other sheriffs come here, and I'll just speak for our office. We could do it the same day, but then we'd have to probably hire some more people and the fiscal costs would go up. And is that where we want to be? So there is a balance here, and I think the delegate's trying to strike it. And I think it's a very difficult situation. So that I think the legal aid's argument does have significant merit, but what it's about balancing and making sure that, because we still have homeowners who are like, why am I being abused? Thank you.
Delegate Pippy, did you change your? What? Oh, okay. Then Delegate Queen, and then Delegate Williams, and then Delegate Roberts.
Is it me now? Oh, I thought he was waiting for his mic. Okay, I'm sorry. Thank you, Madam Chair. So my question, I guess, is also related to the unfavorables, but mine is more so from the Office of Attorney Generals, who is basically saying we just did something with retainers, and why don't we let that play out? Can you kind of understand that concern or let us know what that means?
Yeah, and again, I'm here on informational purposes, so I'm probably a very good person to ask. Thank you, Delegate. I think that's sort of my office's position too, which is we don't have data on the new changes in law, except for since October 1st. So we're talking October, November, December, January, and finishing February. So what we are seeing is all of the jurisdictions around the state, we've talked about this at Sheriff's Association meetings, and we talk about this internally, we are working through it. We are probably one of the highest volume jurisdictions in Baltimore City, so we have seen an increase in the use of it. And I do think that if the committee wanted to heed the advice of, or the testimony of the Attorney General and wait to see how the current law continues to play out before we take tweaks to it, that is a very legitimate perspective that the OAG has, and one that I think that we share.
Okay, thank you.
Delegate Queen kind of stole my thunder a little bit.
Me too.
Because yes, we did change this just last year, just went into effect. And I guess, Delegate, you had mentioned you had some proposed amendments, and I guess I would like to kind of, I don't know if you have a copy of the amendments, but just really, I'm just curious as to what those amendments address, because I know there is some opposition to the bill, some concerns around due process and things like that, especially as it relates to kind of the 24-hour issuance of the warrant. And those types of things, just really, and also just the court's ability to be able to expedite what you're proposing. I know the judiciary has submitted testimony that they have some grave concerns about being able to effectuate what you're proposing within the timeline that's being proposed.
So, thank you so much, Delegate. So I do have a copy of the amendment, and probably will have to put another amendment in as well. But what it says is that the homeowners, the sheriff, the filer, landlord shall file for removal of the swatter for sale or rent of the listed property. Okay. So that's one of the amendments that we were proposing in the 5-day notice with the publication, the regular posting, and the certified mail.
Okay. Okay, thank you.
You're welcome.
I turn my light on.
Oh, he shouldn't be
All right, I'm sorry. Good, okay, thank you, Madam Chair. So remind me, the bill from last year, SB 46, did that address the sheriff's portion at all?
Yes,
Sure.
yes, Delegate. It imposed that because we do the posting, the mailing, at least I can speak in Baltimore City, your exclusive remedy for all of this is the sheriff's office by statute, I think, and also court rule. So it does impose upon us a strict timeline that is a very quick turnaround and is probably the quickest turnaround you could get without devoting additional financial resources to sheriffs.
So a timeline for the posting or a timeline for the eviction?
The timeline for the eviction hasn't changed. I'll explain. So the posting is,
that one.
yeah. So the posting, yes, the posting changed because now when you file the case in the court clerk's office in the district court, when it actually it doesn't even give us the transmittal time. It requires us to mail regular, mail certified, knock attempt on a different day, and physically post if the 2 knock attempts fail for personal service within 4 business days. There is no requirement or delay on doing the eviction. If you get the judgment at the wrongful detainer hearing, you may immediately file for the warrant of restitution. And then it's a scheduling matter between the respective sheriff's office and the property owner in order to
Okay, so that bill from last year didn't address the scheduling or anything post writ or petition of warrant or restitution, correct?
It did not.
Okay, all right, so here's my point. So anyone that, and I'm just gonna say it, I practice a little law, landlord-tenant law in Baltimore, among other jurisdictions, but here's what I found out in Baltimore, is that if you are lucky enough to get a judgment of possession, right? So you get the posting done, everybody shows up to court, you make your arguments, you have a trial, and then the court finds, yeah, this person's not supposed to be in there, whether they were duped by a neighbor and created a fake lease and posted on Craigslist, which happens a lot in Baltimore. And I'm only referencing Baltimore just because it's a big jurisdiction. It happens in other jurisdictions too, but, or someone, I don't know, conspires with and then gets in there. But the bigger issue, what I see it is, even if you get that judgment of possession, you now have to wait an appeal period, and then you have to file a petition for a warrant of restitution from the court. The court has to then approve that at their leisure. And then, once that's approved, then that has to then go to the sheriff's office to coordinate. And what happens if it's 38 degrees or below in Baltimore City? No evictions. It's a rule in Baltimore, no evictions. If it's 38 degrees or below, the sheriff's office will not, under any circumstances, evict someone. And I bring all this up because the reality is people can stay in a property for a very long time. And I think now people know this. And so from the time you file, you convince some attorney to file a wrongful detainer, the time you get a court date, the time you get the posting, the time you get a judgment of possession, the time you do the petition for warrant of restitution, the time you get that approved, the time you go onto the sheriff's website to schedule the eviction, it's 30 degrees for 2 months. And then finally the sheriff's office gets the information and then they coordinate. I mean, that could be like 4 or 5 months. So I bring all this up because a lot of this is just legal mumbo jumbo, but the reality is people know, it's common knowledge in all the communities that if you can get into a property, they cannot legally kick you out for like 5 months. That's the problem. And that's why this $2 million home was such an issue, because the way the rules are in Maryland is that if I can get in, physically get in, nobody can remove me for months. That's a problem. And, and look, there's a lot of bad actors out there and there's a lot of bad landlords out there, but we got a real issue where somebody can break into a house and you cannot remove them for months. And I'm assuming that's what this bill is trying to address. Yes. But I didn't hear, and I know this bill does have a part about the sheriffs and how fast the turnaround is. And I bring that up because right now, even if on today you receive that judgment of possession from the judge, congratulations, you in fact need possession of this, you still don't get that property back for sometimes months after that, from the point that the judgment of possession is given. And that's when they have to do the cash for keys and all these other further negotiations. I mean, it's like a nightmare. It is. So, isn't that so?
Isn't that so?
Thank you.
Thank you.
Thank you.
And I appreciate the delegate putting it forward. And you're correct. You would not get possession unless you filed for the warrant of restitution, because the judgment in and of itself is not enough. You then have to take, and you may immediately do that. And I'll just say, can't speak for, anything other than we do wrongful detainer evictions every Friday. So if you have anyone who you can direct me to who had an issue with customer service, I'm happy to talk to that individual delegate. So thank you.
Thank you very much. There's no further questions for your panel. Thank you, Delegate Addison. We're now going to move on to the unfavorables.
Thank you.
You're welcome. We have Albert Turner, Joseph Lovelace, Mary Miguel Jordan, Matt Hill, Zafar Shah. Two out of five, not bad. At this hour.
Madam Chair, Vice Chair, Albert Turner, I'm an attorney with the Public Justice Center. We provide legal advice and legal services to members in Baltimore City as well as the state of Maryland. As I believe Mr. Blindy spoke well already, this body passed a bill very similar to this that took effect October 1st, leaving approximately only about 4 months to see exactly how this issue has been addressed. And I know Delegate Williams, as well as others, really worked hard on that bill last year to ensure that both sides were addressed, due process is adequately rendered to those who are in those properties, as well as landlords being able to expedite that. A thing also that I will also just highlight is we oftentimes are dealing with tenants who are being scammed. This isn't something that is just a one-off. This is an incredibly needy thing that we're seeing. I can tell you about a client I had. She was a victim of domestic violence. She was looking to move immediately. She found a place on Craigslist that allowed for her to move in within a couple of days. First month's rent, security deposit. She deposited that, got a key, entered the building, only to find out that 2 weeks later, the actual owner of the building wasn't actually the person that she was communicating with. And when she went to go see where that was, she looked at the WhatsApp meeting or WhatsApp group that she was corresponding with the person with. She tried to check to see if the posting was there, and all those things were gone. And so what happened was she had a vacate because she did not have legal right to that. And that is something that is unfortunate, but as something that we're looking to address in this way. And so if I would plug, I think an issue that we're seeing is fixing this issue at the root, which is making sure that postings online are actually done by the actual owner of the property. I know that you'll be hearing about a bill next week about this specifically to make sure that both landlord and tenant are not being harmed by this fraudulent matter. Thank you.
Okay, Madam Chair, Madam Vice Chair, members of the committee, Zafar Shah, Director of Advocacy for the Human Right to Housing at Maryland Legal Aid. We urge an unfavorable report. However, we do sympathize with the interests of the bill sponsor and with people in the situation that's been described. We know that wrongful detainer actions have risen in filing over 70% in the past 5 years. In 2004, we had the most significant increase in wrongful detainer filings. Does that coincide with roving bandits and online scam networks? I think that actually what we did in 2023 was that as a legislature, you prohibited unlicensed landlords from using the failure to pay rent, the tenant holding over, and the breach of lease procedures in district court. And what we've seen time and again in our cases at Legal Aid is that landlords who do not want to be licensed are filing wrongful detainer cases. Does that mean that the instances that have been described by the sponsors panel don't occur? No, I'm sure they do occur, but not in any quantity that merits such an extreme timeline as proposed by this bill. As has been mentioned, SB 46 was just became effective in October. It already states that a trial must be set at least 5 days, but not more than 15 days after filing. This bill states that that scheduling would have to be 5 days. That implicates that there would not be effective service of process and notice of trial, meaningful opportunity to be heard for the many people who are not so-called squatters. So I'm happy to answer your questions. We urge an unfavorable report.
Thank you. Seeing no questions, thank you for your testimony this evening. We have another unfavorable, Cairo Harris.
Good afternoon/evening now, Chair, Vice Chair, and members of the committee. There's a saying that justice delayed is justice denied, but justice rushed can be justice denied too. My name is Cairo Harris, and I'm a constituent of the Legislative District 45, and I recognize that the sponsor of the bill represents my district. However, this legislation directly impacts my family and my home. Because this bill is my lived reality, I respectfully urge an unfavorable report on HB 59. I've submitted written testimony outlining the history of our home and the irregularities surrounding the tax lien that led to its sale, including notice concerns and issues currently being investigated. I will not repeat those details here, but I ask you that you review them carefully. My family home has been in our family since the 1960s, and I'm now currently raising my one-year-old son there. That home represents generational stability in a city where generational stability has not always been easy to secure. Recently, an individual claiming to be the new owner referred to me as a squatter. Under an expedited process like the one proposed in HB 59, that kind of characterization could quickly become the basis for removal before errors are fully examined. I am not a squatter. My family has lived and maintained that home for 60 years. HB 59 would compress hearing timelines, shorten appeals, and require execution of possession within 24 hours once foreclosure is complete. But post-foreclosure cases are often where mistakes surface, improper notice, misapplied payments, and administrative errors that you'll see in my written testimony. Those issues cannot realistically be addressed in 5 business days. Speed may serve the market, but it does not necessarily serve justice. And once a family is removed from a generational home, the harm is irreversible. In a city built on generational sacrifice, we should not make it easier to erase generational homes. You cannot fast-track displacement and call it due process. For these reasons, I respectfully and strongly urge an unfavorable report. Thank you.
Thank you for your testimony, Ms. Harris. We don't have any questions for you. Thank you for your testimony. We do have a couple virtual unfavorables. Catherine Davis.
Good afternoon, Madam Chair and members of the committee. My name is Catherine Davis. I'm the Director of Pro Bono Resource Center of Maryland's Courtroom Advocacy Program. Last year, we represented over 2,500 low-income tenants facing eviction. 30 of those tenants were sued under wrongful detainer, and of those, only 2 cases resulted in judgments for an owner. I'm here today to urge you to resist calls to speed up the wrongful detainer actions based on simply listing a house for sale or lease or for any other reason. I'd like to share an example of the potentially disastrous impact that HB 59 could have on our clients, most of whom have a valid lease but just need help proving it. Last summer, we represented a single mother supporting 4 family members, 2 minors and 2 with disabilities. She had been living in her rental house for over 6 years without any issues until her landlord filed bankruptcy and then lost the house to foreclosure. Our client continued to pay rent, but the new owner filed a wrongful detainer action in an effort to evict her and her family quickly. We first secured a postponement, which gave us time to figure out the history of the property and gather documents needed to prove her right to stay. We then prevailed in court based on proof of valid lease that had survived the foreclosure. Under HB 59, the owner would have only needed to list the home for sale to get a hearing within 5 days. It's unlikely that our client would have had time to make arrangements to come to court, much less consult with an attorney and mount a defense in just 5 days. Property rights are important, but so is a family's right to a safe and stable home. I urge you to consider the unintended consequences of legislation such as HB 59 that effectively removes judicial review from eviction actions based only on an owner's listing of the property for sale or lease. Evictions are traumatic and life-altering. They simply cannot be allowed without judicial oversight and the time and right to be heard. So with this, we urge an unfavorable report. Thank you.
Thank you, Ms. Davis. There are no questions for you. Thank you for your testimony this evening. We have one more virtual unfavorable, Nika Namdi.
Here I am, it's the end of the day. So I have an update and I have a. Good afternoon. My name is Nika Namdi. I'm the Executive Director of the SOS Fund. The SOS Fund urges an unfavorable report on House Bill 59. The SOS Fund is a nonprofit organization addressing systemic housing instability experienced by historically redlined communities in Baltimore City. One of the focuses of our work is tax sale. HB 59 would allow homeowners and heir occupants to be evicted from their home after the right to redeem has been foreclosed due to a tax sale. It is necessary that they have a full and fair hearing that occurs post foreclosure, because more often than not, the homeowner is unaware of their rights, or the underlying tax lien may be invalid due to notice issues, misapplied payments, and the lien purchasers often list the properties for sale before picking up the deeds. I'd like to just share the story of Marlena Jackson, an 82-year-old heir who was facing tax sale foreclosure, who the lien purchaser attempted to board up in her home. If not for the work of the SOS Fund and others, she would have lost her home. We have been able to reverse the tax sale foreclosure, but under HB 59, she would have been treated, if HB 59 was the law, she would have been treated like a squatter and summarily removed from her home with, less than a full and fair hearing in our estimation. This is a single story, but there are many more we could share about how HB 59 will cause harm to those experiencing tax sale foreclosure. This bill erodes homeowners and heirs' due process rights when experiencing a tax sale foreclosure. The SOS Fund urges an unfavorable report on HB 59. Thank you.
Thank you, Ms. Namdi. We have no questions for you. Thank you for your testimony this evening. Seeing that there are no other witnesses, that concludes the bill hearing on House Bill 59. We will move on. Is Delegate Rosenberg here or a representative? Oh, there he is. Thank you. Here he is. Delegate Rosenberg with House Bill 956.
Thank you, Madam Chair and members of the Economic Matters Committee and Madam Vice Chair. This committee wisely was the origin of the legislation, now the law, requiring that a reserve study be conducted by a significant number of housing structures in the state to avoid the calamity, the catastrophe that occurred in Florida when the building fell down. That is an admirable and important preventive step, but we also need to have, in the condominium situation, not tenants, but condominium owners who can afford to meet the costs that the reserve study has forecast or even mandated for the condominium building. In the Northwest Baltimore Park Heights corridor of the 41st District, CHI, represented here by its CEO, Lisa Budlow, brought to my attention the fact that there are a significant number of condo owners who can't afford to meet the requirements of their reserve payment, and therefore their buildings are in jeopardy, which is contrary to the purpose of requiring the reserve study to be conducted. This bill would not set up a fund. It would it would require, if enacted, DHCD to conduct a study this interim of the nature of the problem so we can see to what extent it exists throughout the state. And I think it's essential that the purpose of the study, of the reserve study, is to prevent calamities, to prevent deterioration. to a lesser degree, of these properties, especially when they're occupied by seniors. And reviewing that process by assessing the ability of many homeowners, many condominium owners to meet that obligation is what's needed, is the next step following what we as a committee, you as a committee, then we as a legislature have done with the existing requirements. So would urge a favorable report and defer to Lisa Budlow, who knows this firsthand. Thank you.
Good afternoon, Madam Chair and members of the committee. I'm Lisa Budlow. I'm the CEO of Chai, a community-based nonprofit in Northwest Baltimore. As Delegate Rosenberg mentioned, in our service area, we have over 20 condominium buildings, all of which are way more than 40 years old, all of which are in various states of disrepair. We've been hearing about this issue for years from residents of Northwest Baltimore. They're older, they're living on a low income, they're living on a fixed income. You know, they kind of budget for their condo fees. And what they're finding is two different scenarios. One, there's major repairs that need to be done, and they're not being done because there's not money in the reserve accounts. So that's one issue. We heard from one a resident who lives on the 4th floor of a building and the elevator's broken and she can't use the stairs and she just became homebound. So big issues that are not being addressed because there's no money, or the issues are being addressed. Good news, except still there's no money in their reserve accounts. And so these low-income older adults are facing special assessments that they can't afford. Those assessments can put a lien on their condo, they can lose their condo, and they can become unhoused. It's a dire situation, and what this bill does is ask for us to study it. We're not looking at every condo building in Maryland. We're looking specifically at older buildings that have gaps in the amount that is in their reserve account versus the amount that needs to be in the account. And then for those older buildings with reserve account gaps, we want to know how many of those residents are older and how many of those residents are low income. That's the targeted issue that we want to study. It's not every single condo building in Maryland. We need to examine the extent of the issue so we can make a thoughtful plan to address the issue. We'll have safe buildings, we'll have older adults that are safe in their homes and able to keep them. Thank you very much.
Thank you. I don't see any questions for you, Delegate Rosenberg or Ms. Budlow. Thank you for your testimony this evening. We do have a couple virtual favorables. Rosalie Sklar. Then we'll move on to Delia Ben.
They were there a minute ago.
Okay, hello.
There you go. You can begin.
And Rosalie Sklar is right next to me here, right on my computer. In the building that we live in, we've got a number of, I would say the building is predominantly elderly people, and many of them are on fixed incomes. And my husband and I are no exception. We've got fixed income, and at the time when we made provision for our future retirement years ago, we really thought that we would be able to live comfortably. And now we find that every year before the AGM, when they're going to announce the assessment, we're all nervous, we're all frightened because we don't know if we're going to be able to continue to living here because we don't know if we can come out on what we've got. So I really would urge the study because I think it's so important. At our stage in life, when you get to our age, you really don't want to have to be worrying about every year that there's an assessment coming up and am I going to be able to keep my condo? Where am I going to go and what am I going to do? So I would encourage this to alleviate the burden on elderly people if possible. Thank you.
You're welcome. Would Ms. Sklar oh, there she is.
Hi, my name is Rosalie Sklar,
And I am a 92-year-old widow who has been living in Park Towers about 13 years. And I am no longer working, and definitely having to watch funds and watch our monthly fee going up, and up because of needed repairs. And it's very difficult for me to figure out how long I can stay here with what is taking place. So, as Darius said, there are a number of people living here in that same type of situation. And for me, I can't impress enough how important I feel that a study of this type is definitely warranted. The thought of having to move at this age is not very appealing, but I'm little by little seeing it's down the road, depending how much longer I'm around. So thank you for listening, and I hope we will have a positive outcome. Thanks.
Thank you, Ms. Sklar. Don't go anywhere. We have a question from Delegate Queen. Oh, it's not, okay, I'm sorry, Ms. Sklar. It's pointed at a panelist, but thank you.
Thank you, Madam Chair. So for the sponsor, you mentioned, and your co-panelists mentioned that this wouldn't be a study of all the condominiums, but the ones that you want to make sure have enough money in their reserve and see where the gap is. I guess I don't know, how do you ascertain that without doing all of the studies? Is that making sense? Do you know how many are in this predicament already, or you have some other data to determine that? Because I don't get a sense of how you would know how much money they have in their reserve without checking all of them.
Yeah, thank you for the question. And it's just an opportunity to clarify. You do have to look at all of them to figure out which ones need the help. I just think I was referring to, I think there's some reluctance to study because of the thought of, okay, then what, right? Are we gonna study and find out that there's a big issue and are we gonna have the money, the funds to address the issue? And so I just was trying to point out that, in fact, what we are looking for is a subset of the condos in Maryland. We will have to look at all the condos to find that subset, but once we find that subset that has the need, that's what, that's the purpose of the study, because what we want to know is the extent to which there are folks like the women who were just testifying that are in need, and that need is really restricted to the low-income older adults living in buildings that are older themselves so that they have, real repair needs. And also those are the same buildings where the reserve accounts just haven't kept pace over the years until the recent requirement, so that there are these gaps. So yeah, I guess the study will have to look and find that subset, but the target of, this solution that we're looking for is gonna be targeted at a much smaller subset of the condos.
Can I ask Mrs. Sklar a question? She may live in the same building that my grandmother lived in.
Ms. Sklar, are you still there?
Ms. Sklar, thank you, Madam Chair. Are you in 7111 or 7121? What's your address?
7121.
Okay. Next door to where my grandmother lived. So I don't have a conflict.
Who was your grandmother?
Sylvia Heck.
Sylvia Heck?
Hecht.
I
Before your time.
think, how long ago was that?
20-some years ago.
Oh, that's a little before my time.
Sure. Thank you.
Thank you, for sure.
Thank you.
Thank you, ladies, for your testimony this evening. So cute. We will now move to our favorable with amendments. If they're here, our two honorary committee members, Jeannie Hyatt and Jeannie Pulse, are they here? They
went
left.
back to Cross
Oh,
Keys.
poor Delegate Holmes, they left. Okay, then is Diane Davis still here? Diane Davis? No, okay. All right, seeing there's no further witnesses,
Thank you.
that concludes the bill hearing on House Bill 956. Delegate Holmes, it's your show now, and thank you for your indulgence. Is he here? Delegate Holmes, it's your show now for the rest of the evening. Technically, you're on time, because you're at the bottom of the list. I was just
Yes,
able to
I
squeeze you
understand.
in for one of them.
Good afternoon. My name is still Marvin Holmes, and it is still good to be back and listening to all of the subject matter. And it's very, very interesting to hear the subjects of bills that I have put in over the past 10 years coming back to life, I think. Good afternoon. My name is Marvin Holmes, and I'm here to discuss HB 841. This is a bill that is looking at annual meetings. Some of you may know in a previous career, I was worked in the engineering field, and it was my responsibility to design and construct subdivisions, office parks, and stadiums of the like. In that capacity, I would be the declarant's representative for the HOAs and condos that my client would have constructed. And what this bill does is it creates that when 25% of the HOAs or condos are purchased, that the declarant has a member that is a lot or unit owner within the board of directors. And this bill, what this does is it simply creates some historical content for the unit and lot owners when they take over the condominium or condo from the declarant. You all have your own, I think all of you have your books for HOAs, condos, and co-ops. And in those books, you will see that there's a difference in the condo ownership when it takes over from the declarant. Condos take over at 50%, HOAs take over at 75% when the declarant is no longer in control of the board. What this bill does, it says at 25%, then there should be one member of the public represented on the board of directors. And with that, Madam Chair, I will take any questions.
Delegate Adams.
What was the number percentage-wise? Is that the bill?
The bill is asking that the declarant choose or pick a member of the lot owners or unit owners at 25%. When there's purchasers of 25%, the declarant will select someone to be on the board with the declarant so that there is some historical knowledge carried when the unit owners and lot owners take over completely at 50% of the condominiums and at 75% of the homeowners associations.
Okay, so I guess builder developer likes to hold on to control until their project's developed out, but you're saying...
That is correct. Typically, I didn't cut you off.
No.
Typically, what happens is that the declarant releases full control at the benchmark of 50 and or 75%. And what I've found is that there's no historical content of the public of what has taken place previously.
Thank you.
Seeing no further questions, thank you, Delegate Holmes. We also have, for favorable, Kim Glaude. Sheila Daniels Henriquez.
Okay.
Oh, Sheila's not here. She's not here. Chair and members of the committee, my name is Kim Guade, and I'm a homeowner residing in a common ownership community. I respectfully submit this testimony in strong support of House Bill 841. For many years, homeowners in communities like mine have operated with limited transparency and insufficient safeguards to ensure fair governance. In my own HOA, homeowners have serious and ongoing concerns about whether elections are conducted fairly, whether votes are handled independently, and whether homeowners are receiving timely and complete access to financial records. Since approximately 2014, our property management company has exercised extraordinary influence over the day-to-day operations of our community. In practice, the board has allowed significant authority to shift to the management company, leaving homeowners feeling excluded from meaningful participation in the governance of the community that we financially support. Meanwhile, HOA fees continue to rise while homeowners lack clear visibility into how those funds are being allocated. Our neighborhood is showing signs of decline, and homeowner confidence in the governance structure has eroded. When transparency and fair process break down, the financial stability and property values of entire communities are put at risk. House Bill 841 directly addresses these systematic concerns. Its provisions requiring independent election oversight, secure ballot handling, open meetings, and timely access to books and records represent essential common sense protections of Maryland homeowners. These safeguards are not merely procedural. They are fundamental to restoring trust, accountability, and proper homeowner participation in common ownership communities. For these reasons, I respectfully urge the committee to issue a favorable report on House Bill 841.
Thank you. And I'm sorry for butchering your name. Your name sounds much prettier the way you said it.
Yes,
Guade.
it's Kim Guade.
With your testimony, I see no questions for you. So we'll move on to the virtual favorable, Tara Coleman. Ms. Coleman, are you there?
Hello, everyone. Madam Chair, Vice Chair, and members of the committee. My name is Tara Coleman, and I'm a 21 plus years honorably retired and permanently disabled military veteran. I'm a law-abiding citizen, and I'm a homeowner.
Ms. Coleman, are you able to show yourself on camera?
Yes, can you hear me?
Yes, are you able to show yourself on camera? Yes, are you able to show yourself on camera?
Oh, please forgive me, Madam Chair. I'm suffering from migraines and vertigo, and I've been very sick, so I'm laying in bed, so I'm not in a presentable state. So please forgive me.
Yes, it's fine.
Can you hear me, Madam Chair?
Yes, we can hear you.
Okay, so I too am experiencing the same problems in my community association. The name of my community is the Villas at Wall Chapel Town Center Condominium. Located in Gambrills, Maryland. And there's been illegal activities going in my association by the property manager and board treasurer to include. Okay, so I too am experiencing the same problems in my community association. The name of my It involves illegal located in Gambler's, Maryland. And there's been illegal activities going in my association by the property manager and board treasurer to include.
Ms. Coleman, unfortunately, we're not able to hear the rest of your
To include
testimony. Ms. Coleman, are you there? Okay, she's not there? All right. Ms. Coleman, unfortunately, we're not able to hear the rest of your testimony. Yeah. Ms. Coleman, can you turn your YouTube off because it prevents us from hearing what you need to say? And if you're not able, it's okay concerning your situation. Unfortunately, we won't be able to hear the rest of your testimony. Okay, she's not there. All right. All right, Ms. Coleman, I apologize. I'm sorry for your situation. We appreciate you trying to come forward and bring us your testimony. Unfortunately, we're having technical difficulty. But thank you so much for wanting to testify this evening. Colleagues, we'll move on to our favorable with amendments. We have Karen Strawn. Actually, we also have Cynthia Kent and Michelle Jackson, if you're here.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. I appreciate you hanging in there with us. I know it's been a long day. 841 is about when the association is still under developer control. Most of the laws in the condominium article and the HOA article do not have anything to do with when it's under developer control. They're not even required right now to have a meeting where people can come and find out what's going on in their association. This would require at least one open meeting each year so that people can know what's going on with their association. It would also require them, once they are at 25%, to add a unit owner or lot owner as a board member so that that person will be able to share with the rest of the community. The developer is still going to have the majority of control at that point. It's just going to be adding one person to at least make sure that the community has a voice as well. It also says that there's going to be no commingling of funds or records, which is very, very important to make sure that if there are problems where when the association gets turned over, that you can determine whether or not that was the fault of the developer that there are no funds or if it was being done by the failure of operating expenses to be paid, things of that nature. We have asked for an amendment. When this bill was presented in the past, it included a provision that says before the county releases a bond, that there be a notice that goes to the board so that that one board member gets a copy of that notice as well. And it simply is a notice provision. That way, so if the roads are not completed, then they can simply say to the county, contact the county and say the roads are not completed, and so that they won't release the bond. We find many times, we get complaints all the time at the Consumer Protection Division that there are bonds that were released and the property was not taken care of. The things that were supposed to be done were not. So for those reasons, we urge a favorable report with amendment.
What is your name, ma'am?
I'm sorry, Karen Strawn with the Consumer Protection Division.
Good evening, members of the committee, Madam Chair, Madam Vice Chair. My name is Cynthia Hitt-Kent. I am a member of the Maryland LAC for Community Associations Institute. We are here to support Bill 841 with the amendment as Ms. Strong has indicated, and I can give you firsthand experience. When the association is created in the very beginning, it is a corporation and it should act like a corporation. But we do find that many of the builders are building, many of the developers are developing. They might not pay attention to the governance issues. However, if they have annual meetings, if they appoint members of the homeowners to the boards, then there is that institutional knowledge and that association once it is transitioned to the owners, will have that institutional knowledge, will be able to carry forth. Many of the homeowners I've represented over the years, of the homeowner associations, have said, wait a minute, we just got control of the HOA, we have no idea what to do. And if there is that prior experience of at least one person on the board, that transition will be easier, that transition will be better. We also like this idea of the notice of the bonds, because again, these are homeowners who are going to take over this community, and they need to know that the county has agreed that those bonds can be released. This is just a notice provision. The county can still release the bonds if it is appropriate to do so. We leave that to the counties. But again, it is institutional knowledge that the association comes into transition with that enables them to do their associations better. We urge your favorable consideration of the amendment and favorable support of this bill. Thank you.
All right. Good evening, everyone. Good evening, Madam Chair and members of the committee. Thank you for the opportunity to speak. My name is Michelle Jackson, and I've been a unit owner at the Elmont Condominium in Baltimore for 4 years. I'm here to strongly support this legislation because it brings much-needed transparency, homeowners' participation to condominium and HOA governance. And I also agree with my fellow panelists here in terms of some of the amendments and what they have to say. So I'm going to move on to what my recommended amendment is. I respectfully recommend strengthening this bill with one amendment: require existing condominium associations to hold bi-monthly or at least quarterly owner meetings. Many associations meet once a year, which limits transparency, leave owners without a consistent forum to raise concerns or stay informed. Regular meetings would improve communications, accountability, problem solving across the board. This bill, especially with this proposed amendment, moves toward healthier, more democratic, more transparent community associations, and I urge its passage. And since I have a few more moments, I would like to say that I'm new to living in a condo. However, I lived under the Columbia Association for over 25 years, so I'm used to governance. And I feel what's lacking in a number of the condos and the one that I live in is that there's no voice. And unit owners, we get invited to board of directors meetings that's controlled by the property management company, and I'll to discuss that on the next witness statement. But we have no control, no say. They're making decisions, and as a new unit owner, I moved in not knowing that the reserve study was not fully funded. I would have never chosen to move there. So my representative said they want to do a study and help lower incomes. What about the new homeowners who moved in and they should have had a reserve study? And then now I may get an assessment for an extra $5,000 or $10,000 to oversee what my unit owners that have lived there 20, 30 years have not paid.
Thank you, Ms. Jackson. I see no questions for you, ladies. Thank you for your testimony this evening. There are no further witnesses on this bill. That concludes the bill hearing on House Bill 841. Delegate Holmes, your next bill, 955.
Thank you, Madam Chair. Again, my name is Marvin Holmes, here with another piece of legislation, HB 955. I'm going to start by very briefly, discussing a piece of legislation that was approved last year. It is Senate Bill 758. Senate Bill 758 seemed to have caused some confusion to some people. And what I'm attempting to do with HB 955 is just to bring some clarity, at least to one provision of the Senate Bill 758 from last year. And the only provision that I'm addressing with this HB 955 is that in the previous legislation, as aforementioned, there was a requirement for discussions about having a third party to assess elections. So HB 955 is very simple, and it talks about perhaps a third party only needs to be involved if there is a contested election within the board of directors. If there is a unanimous vote for all of the members for the board of directors, then there is no need to hire a third party to assess the ballot count. There's only a need to assess a ballot count if the number of candidates exceed the number of contested seats. That is all that this bill HB 955 does, ladies and gentlemen. And with that, I will take any questions.
I wanted to have Ms. Glaudet speak as well, because she's listed here with your panel.
Oh, no questions? Oh.
Good afternoon, Chair and members of the committee. My name is Kim Glaudet. I'm a Maryland homeowner, and I'm here today because what is happening in my community should not be happening anywhere in the state. In my homeowners association, the board of directors has effectively surrendered its authority to the property management company. Homeowners like me have been left without a meaningful voice. We cannot vote on key matters in a way that feels fair or transparent. And the management company oversees the very elections that determine who governs our community. This creates serious conflict. The entity that benefits from maintaining control is also managing the election process. Meanwhile, many board members do not fully understand their own bylaws or their fiduciary duties to the homeowners they serve. The result is frustration, distrust, and a growing belief among residents that the system is stacked against us. Homeownership is supposed to come with rights, not barriers. House Bill 955 is an important step towards restoring confidence in HOA governance by reinforcing the need for truly independent election oversight where appropriate. Maryland homeowners deserve transparency, we deserve accountability, and we deserve to know that our votes actually matter. I respectfully urge you to support House Bill 955 because in Maryland, no homeowner should ever feel powerless in their own community. Thank you for your time and consideration.
Thank you. Before I continue, are the three of you, okay, I know who Ms. Jackson is, but.
I just stood up there. I'll go back to my seat.
Oh, no, it's nothing like that. I mean, I just, the two of you, so usually when you're up, it's when you're called upon, but what are your names?
Demetria Whitley.
Oh, Rick Thompson.
Okay, neither of you are on our list. Did you sign up?
I signed up online.
Signed up online.
Within the time frame?
Mm-hmm.
Yeah.
I'm assuming you didn't, but you're sitting here and you're with Delegate Holmes. I will allow you to speak. You have 2 minutes, but you're not on our lists.
Oh, well, I followed the instructions and signed up online.
I'm sure you did, ma'am. It's just there's a certain time frame when the list is closed out, but please, 2 minutes each. Thank you.
Hi, my name is Demetria Whitley, and I'm here regarding HB 955 with the Homeowners Association. And I want to thank Delegate Holmes for all his hard work through the years, trying to get these bills in place regarding these HOAs. I live in Prince George's County, and the HOA system is used as a cash cow. And there's nobody mandating what these board of directors and these management firms are doing. They are embezzling money, and they're not following the protocols regarding the election processes. They're putting their people on these boards without fair elections, even after the new law came into place on October the 1st. They still are doing what they want to do, and they're not having third-party, people that are not supposed to have anything involved in the elections. The management firms and the board of directors are the ones that's in contact with the people that's handling the elections, and the people handling the elections would not even talk to the homeowners. And then when we have meetings, the homeowners are not even allowed to speak or say anything, and nor are they following the protocols to have committee members. We really need to get these laws into effect. Like I said, they're using them as a cash cow. If any of you all need extra money, you can go join a HOA board and get all the money you want to get, because nobody is watching or doing anything. The Attorney General's office has been very aware of the things that are happening. Numerous people have filed complaints, but all they want to do is a mediation, and then the board of directors and the management firms are not held liable or made to come in for mediation. So therefore, nothing is being done about the illegal things that are transpiring. We really need you all to take this thing serious. As Mr. Holmes has his due diligence and studied these laws, and he's met with us numerous times, we need to get these laws into place unless you want to continue to have these people do illegal activities and continue stealing money. Thank you.
Thank you, Madam Chair and committee members. My name is Rick Thompson. I've been a member of the Kettering community for over 30 years. And last year, a bill was put in effect October 1st, 758, to make sure that the management companies would stay out of the elections for the homeowners and community associations. This bill has not worked. And 955 is a nice bill, has a good intent, but it doesn't go far enough. In Kettering, our management companies control the elections. Even though the bill passed October 1st, they make the slates, and the outside independent company reports only to them, not to the board, not to the community, but only to the management company. 2023, we had 4 board members that were removed from the board, and these people, a declaration was put forth that they could not be put on the board or could not run as a candidate for the next 5 years of 2028. But the management company is responsible for this. And like I said, 955 is a good start, but it needs to be amended. And I've asked Dr. Holmes, I could just read this as a way I feel that we could correct this problem to keep the management companies out of our elections. It is recommended that a nominating committee be comprised of at least 50 of the homeowners in the election, 50 of the homeowners to make up the nominating committee. This committee will be responsible for selecting the independent contractor. Independent contractor will report to the nominating committee and prepare an election report immediately after the annual report, which includes the total number of homeowners who voted and the number of votes each candidate received. This report should be mailed to each homeowner promptly. In preparation for the annual election, the nominating committee shall ascertain from the management company that each candidate is current on their dues. This is the only extent that the management company will be involved. And since I don't have time, I won't go forward. But thank you for the opportunity.
Thank you. Delegate Adams has a question.
Yeah, thank you, Chair. For the sponsor of the bill, I do. And it's going to be really fast.
Yes, sir, my good friend.
Really fast. So these elections, it's during a members meeting, right? So these are meetings in person, or what? Because I'm not seeing in here the requirement as to how the elections occur. So for example, the only thing that the bill does, it looks like it sets in place some rules if there are more people than the number of seats open. So
the requirements for how the elections take place are all described in the previous bill, as the gentleman suggested, came into effect on October 1st, which was Senate Bill 758. And that is in that how the elections take place is current language law. And the only thing that HB 955 does is take care of contested elections. But your answer to your question is in current law.
May I speak, sir? Oh, well, I wanted to tell you, Cheryl Kagan is making amendments to that.
Delegate Wyville?
Thank you, Madam Chair, for the bill sponsor as well. So there's a letter of opposition stating that this bill would prevent folks from being nominated during the meeting itself. So I'm assuming in practicality, if someone nominated someone at the meeting and then it created a contested election, then that election would take place later using this procedure?
Because of the way that our structure here, I have not been able to see any of the testimony for or against the legislation. So this is the first time you're hearing this. But the question that you're answering...
They state that the bill would discourage and perhaps prevent nominations from the floor at a meeting. So I'm assuming, I don't read that in here, but if there was a nomination from the floor which created a contested election, then that election would have to take place later using the procedures that are established here?
I'd have to take a look at that to see if some of what you're asking, again, with Delegate Adams' question, is current law in terms of what takes place with contested elections and if it has to be within the next 30 days following. I have to take a look at that. So I don't know. Perhaps Ms. Strawn may have an answer to that. I just don't recall.
But this bill wouldn't prevent a nomination from the floor at the meeting, would it?
No, this is only uncontested elections. This bill, HB 955, is uncontested elections.
But a nomination from the floor could create a
That would create a contested election, that is correct. And I don't know if that would require then another meeting or not.
Right.
I just don't recall.
Okay, thanks.
Yes, thank you. Was you, the young man that's on the end here, were you finished with what you was reading? Was you almost finished for your request? I just wanted to hear the last bit of it.
I was almost.
You was almost finished?
Yes. Oh, you want me to finish?
I wanted you to finish. I want to hear what the last part of it.
Like I said, the nominating committee, the independent contractor will report to the nominating committee, and they will submit reports to each homeowner properly. Then, in preparation for the annual election, the nominating committee should ascertain from the management company that each candidate is current on their dues. This is the only extent that the management company will be involved in the election. So after the election, the new board members should establish a new nominating committee for the ensuing year, which in 30 days after taking office. The new nominating committee shall select the independent contractor within 6 months after their appointment and notify all homeowners of their decision. The independent contractor can be rescinded by way of 10% in lieu of the 25% of the total homeowners by way of proxy or recall. And the reason I put that, Kettering only about 20% vote, so why put the 25% in to rescind the independent contractor? And I also recommend that the Consumer Affairs section of the Maryland State Attorney Office be involved and impose financial penalties on management companies that interfere with the homeowners' elections. Yeah, thank you.
Okay, thank you. And Delegate Holmes, will that be for the last bill, the Senate Bill SB 758 that was last year?
Senate Bill 758 was last year. That is correct.
That's correct.
Okay, and that would interfere in some of his recommendations?
The recommendations that he's making are additional recommendations. But to answer your question is, some of the things that he is suggesting would interfere, I think, would amend last year's SB 758, yes. Some of the things that the gentleman from Kettering is suggesting would put amendments, additional amendments onto last year's SB 758, that is correct.
Will any of that help this bill 955?
That's up to you guys.
Okay.
But like I said, House Bill 955 has one provision in it only relevant to contested elections.
Contested.
Contested elections, right.
Okay.
And I was trying to answer your question specifically in that the gentleman from Kettering's suggested amendments would be further amendments to HB 955, which, to your question, would amend further SB 758 from last year. Yes.
Okay. Can you two get together and try to figure this out? It would be helpful. Thank you.
Apparently, I got missed on the list. I signed up on Tuesday evening at 5:45, and.
What is your name?
My name's Sari McLeod.
You're not on our list, but.
Madam Chair, I'm on your list, Michelle Jackson again.
I haven't gotten to everybody yet. I still have names to call, but your name, ma'am, is not on the list. What is your name again?
Sari McLeod.
Okay. In the interest of the spirit of the speaker who, everyone takes time out of their busy schedule. You have 2 minutes. Please be concise.
Thank you. Distinguished members of the Economic Matters Committee, Madam Chairman. After spending the past 38 years in the condominium homeowner association management industry, now I'm a retired manager, and I've conducted hundreds of elections in the Baltimore, Washington, D.C. metropolitan areas, I was taken aback by this new legislation. The cost, most associations could not afford the electronic platforms for elections or hiring a third-party vendor. It was not in their budget that was pre-approved the year before. Not allowing the provisions of their governing documents to be followed, i.e., the secretary is supposed to count the votes and/or appoint inspectors of the election. Further strain placed on management companies and associations to provide information to the third-party vendor. The third-party vendor would require documents to conduct the election, such as homeowner listings, delinquent reports, bylaws, and copies of the notice. Confusion among homeowners about the election process. Since the law was enacted, I formed my own LLC to assist in the election processes, especially for smaller groups. For the period of October 1 through December 31, 2025, we assisted 49 associations with their elections, where 76%, or 39, were smaller associations with 100 units or less. 14, or 28% of those associations had to have second meetings as they did not reach their quorum requirement in the first meeting. In discussion with the associations and their curiosity about the new law, they felt their hands were tied because they could not go around and collect proxies, which would have allowed them to have their meetings the first time. Additionally, they were upset how the definition of an independent party was written when they knew their governing documents allowed the secretary to count votes. Typically, however, when the secretary is on the ballot,
if you could summarize, that would be.
Okay. When the secretary is on the ballot, inspectors of election are chosen, so there's no illusion of fair election.
Thank you so much.
I am in support of the amendment to the bill, along with clarifying the definition of the independent party, exempt very small associations to reduce the election-related expenses, and clarify a misrepresentation of the law regarding proxy holders.
Thank you so
very
much. What is your last name again?
MC capital L-E-O-D.
Okay, yeah, you're not on here. All right. We will now, let's see. Okay, we will now go back to the favorable with amendments with Cynthia Kent, Michelle Jackson, Sheila Daniels Henriquez. She's not here, correct? Sheila, not here?
Ms. Jackson, go ahead.
There's one more favorable. I received a request to give testimony for this bill.
What is your name?
Stephen Lapham. I'm president of the Charm.
You received a notice from whom?
From this committee to give testimony on two bills. I have a copy of that email with me.
All right.
And I submitted both written and official testimony. I'm on the list. Yes.
Oh. Yeah, I'm going by favorable, favorable with amendment, and unfavorable.
Thank you for, sorry.
You may begin, 2 minutes.
Yes. Good evening again, Madam Chair and members of the committee. Thank you for the opportunity to testify. Again, my name is Michelle Jackson. I'm a unit owner at the Elmont Condominium in Baltimore. I'm here in strong support of HB 995, which clarifies when independent election requirements apply in condominiums and homeowner association. This clarification is important, but it also highlights a larger issue. Election integrity in common ownership communities is inconsistent and often vulnerable to conflicts of interest. Elections determine who controls budgets, contracts, major decisions that directly affect homeowners' financial and housing stability. For these elections to be legitimate, they must be transparent, impartial, free from influence by those already in power. And for that reason, I respectfully urge the committee to strengthen the bill with one key improvement: require all elections, contested or uncontested, to be conducted by a qualified independent third party. And to ensure true independence, the third party must have no personal or business relationship with board members, the property management company, the property managers, or their attorneys. These amendments will ensure that every election is fair, conflict-free, and trusted by homeowners. They will reduce disputes, increase transparency, strengthen confidence in community governance across Maryland. I urge the committee to support HB 955 and adopt these critical protections. And from my personal experience for being in a condo for 4 years and gone through 3 elections, the property management company has taken over the elections, and I've witnessed them firsthand where they did some improprieties where my unit, we filed complaints, and there's also an article with the Baltimore Sun regarding the Elmont. There's been a lot of disparities, and we have no trust and no confidence in the property management company, and I will address that with the next bill. Thank you.
Good evening, members of the committee, Chair, Vice Chair. Again, my name is Cynthia Hitken. I am a member of the Maryland LAC of the Community Associations Institute. I'm here with 3 ladies today that probably have a combined experience in management of maybe 90 years. Myself, I am an attorney of 40 years and plus doing community association work. There's 7,500 community associations in the state of Maryland. There are 36,200 volunteers, which is probably an average of about 5 volunteers per association. Most boards you have to have a minimum of 3 board members. What we found when this law was enacted was that it was a one-size-fits-all, and therefore it was affecting very, very small associations. We have some that are 4 units, 12 units, 25 units, and they have very, very small budgets. They may also have a very small core of volunteers, and therefore they have to go to an independent party and pay. We knew of one association that had to pay $750 when they had an uncontested election. 2 positions open, 2 candidates, should have been a vote by acclamation. Instead, they had to put $750 out. That was not in their budget. This is something we brought to Delegate Holmes and to Senator Kagan, and we have consensus on this issue about uncontested versus contested elections, because only about 10% based on surveys that we've done with the LAC and with the members, only about 10% are contested elections. I don't discount any of the stories you're hearing here, but I do discount that this is an endemic problem in the industry. I do discount that this is a solution that applies to all. I urge you to read our written testimony that talks about the amendments that are necessary so that we can exempt small associations and we can clarify some of the points in the law. And I thank Delegate Holmes and Senator Kagan for working with us. And I thank this committee for your attention.
Thank you, ma'am, for your testimony. I don't see any questions for you. We will now move on to the unfavorables, Thomas Allen and Stephen Lapham.
It's been a long day, hasn't it? Yeah. It's wonderful to see Delegate Holmes, who's led many good reforms over the years, plus serving on commissions in Prince George's County and Montgomery County, where I live. It's just quite impressive. Good afternoon. My name is Stephen Sellers Lapham, and I'm president of the nonprofit civic organization CHARM Maryland. CHARM stands for the Common Ownership Community Homeowners, CH, advocating for reform, and we're working on reform in Maryland. Thank you, Chair, Vice Chair, and committee members for your diligent work and hanging in this long afternoon. We favor bills that could improve access to fair and affordable housing for all Marylanders for years to come. You can see our advocacy webpage where we've actually taken a position on 19 bills that are under consideration right now. So this is a little bit ironic because we have a newsletter that came out a few months ago that is strongly in support of last year's election bill, H. Bill 758. We think that's a good bill, and I think there is some confusion widely that third party means you have to hire an independent contractor. You don't have to. The association members can form their own election committee and run the election themselves. It does not have to be a cost. It's very interesting to hear about small associations. So I think over the next few years, there will be work to do as we get elections and how they happen worked out in this rather 250-year-old building where this was all hammered out originally. So here's our official position. CHARM Maryland, in furtherance of our vision and mission, strongly opposes HB 955, real property condominiums, homeowner associations, elections. This bill would discourage and perhaps prevent nominations from the floor, which cannot be anticipated until the meeting of the members occurs. It is not in line with democratic principles. I'll just relate my personal experience that the mischief and illegal activities that we've heard from are very real. And we want to really address and tackle these over the next few years. So I very much look forward to working with delegates, our organization does, and with the people who have spoken here, because we do want efficient elections and it don't have to be super expensive. And I really appreciate your time here. I had more that I wanted to say, but I'd be happy to answer any questions because there's a lot of confusion. I'm not a lawyer, but I worked with civic educators, and I'm very excited to see that property management companies will not.
Delegate Weibel has a question for you,
Yeah,
Mr.
not be involved in counting the ballots.
Just quickly, so your letter was what prompted my question to the bill sponsor earlier.
Thank you.
The bill doesn't necessarily, the way I read it, prevent nominations from the floor. If there was a nomination from the floor, the requirements of this bill would kick in, wouldn't it?
Yeah, my understanding is not real clear on that. So I think something does need to be clarified in the bill. But the possibility, as we read it, and several of us read this very carefully, that you won't, the members of the homeowners in the community need to form an election committee to say how this is going to happen, who's going to count the ballots, how's this going to be done carefully. If you haven't set that up, and then there's a nomination from the floor, you're kind of caught trying to create all of that organization suddenly. So yes, maybe there could be another meeting of the members and delay the vote and delay the count while you create your election committee. But it's a concern that this bill would not, could discourage. I mean, you know, oh, well, it's uncontested, so why have a nomination from the floor? We think
seems like that if you have the nomination from the floor, the requirements would kick in, but we can get counsel to clarify that. Thank you.
Okay. Oh, yeah.
Can I address
Thank you. No, ma'am. It's directed at who it's directed to. Thank you, Mr. Lapham, for your testimony. There are no further witnesses for this bill. That concludes the bill hearing on House Bill 955. Delegate Holmes will now move on to the final bill of the evening, 853, and when you are called upon, you can come to the panel to testify. Karen Strawn, Lisa May, Stephen Lapham.
Ladies and gentlemen, I first want to apologize to you. This one is not going to be as easy as the previous ones.
Think.
Oh, thank you, Madam Chair. My name is Marvin Holmes. This bill is HB 853, and this legislation, ladies and gentlemen, is a requirement for community managers to be licensed. What I want to start out by making a definitive definition of separation. I want to applaud Delegate Chi and Delegate Adams on their HB 433, which identifies property managers. And Madam Chair, if there is an opportunity later to add myself as a co-sponsor onto HB 433, I'm requesting that. But their bill, HB 433, was about property managers. This bill is about community managers. And they're two totally separate types of businesses and entities, totally separate. This bill is about community managers being licensed. And I just want to read very quickly about some of the types of licenses that we have in the state of Maryland. Occupations that need to be licensed: architects, barbers, certified interior designers, certified public accountants, cosmetologists, electricians, foresters, home improvements, heating, air conditioning, individual tax preparers, landscape architects, land surveyors, pilots, plumbers, professional engineers, real estate appraisals, real estate commission, second-hand precious metals, and stationary engineers. In order to be a community manager in the state of Maryland, ladies and gentlemen, in order to be a community manager in the state of Maryland, you need one thing: a business card that says you're a community manager. That's it. That's totally it. And what this piece of legislation is attempting to do is to change that. Persons that are community managers that are responsible for collecting hundreds of thousands of dollars of persons' money, in my opinion, need to have a license. There are other states that already have this, so we are not unique. Maryland would not be unique in having community managers being licensed. Alaska, Connecticut, Florida, Georgia, Illinois, Nevada, Virginia, and California to a lesser extent. But we would not be unique in having community managers licensed. I think, ladies and gentlemen, in this bill 853, I have laid out very specifically and succinctly how the community managers need to take their licensure, the training that they need to take, the license structure that they need to take. It's all written out in the bill very specifically. Like my grandfather used to tell me when I was a little boy, you need to be more specific with your specificity, boy. In this bill, 853, I've made it very specific on how the licensing structure should be taken care of. And I am requesting, if you don't mind, Madam Chair, that HB 853 be enacted so that we do have licensure for property managers. And because of the time, Madam Chair, I do have several other pages that I was going to go through, but I will not, Madam Chair.
I will just remind everyone, even the legislators have a time limit. So
That's okay.
Thank you for not doing that.
Nice. Oh, my turn? Sure. As I said before, my name is Stephen Sellers Lapham, and I'm president of the nonprofit organization Charm Maryland. So Charm Maryland strongly supports HB 853, Real Property Regulation of Common Ownership Community Managers. This bill establishes a state licensing program in the Maryland Department of Labor requiring licensing of all common ownership community property managers. Boards and homeowners rely heavily upon property management companies to help associations comply with state laws that govern COCs and for collecting and managing association funds in a fiscally responsible manner. This important licensing program will ensure that property managers meet certain minimum standards and have the experience, education, and knowledge to provide the required services. Currently, there are no such requirements or professional standards for COC property managers. This bill aims to protect the interests of Maryland individual homeowners living in COCs and to promote their financial stability. That's the end of our official position statement. In the seconds remaining, I want to state our appreciation for the efforts of the first sponsor of this bill, Delegate Marvin E. Holmes, Jr. on my left, who over many years has studied the problems that COC homeowners face, resulting in some bills that could reform the system for the better, all the while himself serving on various commissions. This bill is one of several before the House this year that, while not solving all of the problems that individual homeowners face, we can shine a light into the future, illuminating a path forward towards securing fair and affordable housing in the state of Maryland. Thank you.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Karen Strawn. I'm with the Consumer Protection Division in the Office of the Attorney General. I'm not going to repeat what's been said. We do think this is an important bill. One of the reasons it's important is that we have taken action against property managers for not following the laws and for not doing their due diligence and making sure that they are properly handling funds. There's the story that everyone has heard from years ago about Legacy that stole millions. We took an action against a company recently that was over $1 million against this company because they were taking late fees that were in violation of the laws. In addition, that very same company, when they had the action taken against them, withdrew improperly something like $250,000 from the account for legal fees. And before the association was able to close out the account and prevent them from doing that, and they have not paid that money back. Property managers need to be licensed and they need to be involved in training and things like that to ensure that they are taking best practice actions on behalf of associations. And for that reason, we ask for a favorable report for this bill.
Thank you for your testimony. I do not see any questions for you two. Thank you very much. Is Lisa May here? Okay. We will now move on to our virtual favorable, Tara Coleman. Oh, she's going to be written, right? Okay. Is Eileen Britt with us? Okay, our virtual Eileen Britt has left. We'll now move on to our favorable with amendment. We have Kim Glaudet, Michelle Jackson.
Chair and members of the committee, my name is Kim Glaudet, and I'm a homeowner in the Maryland Common Ownership community. I submit this written testimony in support of the intent of House Bill 853, increased oversight and accountability for common ownership community managers is long overdue and necessary to protect Maryland homeowners. However, based on my lived experience, I respectfully urge the committee to strengthen several provisions of the bill to ensure that homeowners' financial interests are fully protected. At present, my community's property management company maintains our HOA funds in accounts held under the management company's name at a financial institution located outside the state of Maryland. In October 2025, I formally requested an independent audit of our HOA finances
To date, homeowners have not received the request audit or sufficient financial transparency. Meanwhile, our community continues to fall into visible disrepair. HOA fees have increased annually, yet key community amenities remain in need of repair and are not fully usable by the homeowners who fund them. This situation has raised serious concerns among residents regarding whether community funds are being managed and applied for the proper benefit of the community. While HB 0853 is an important step forward, I respectfully recommend the following amendments. Require that all financial accounts be held strictly in the name of the common ownership community. Require direct oversight by the elected board treasurer for any management company activity involving community funds. Prohibit management companies from exercising unilateral dominion or control over community funds. Prohibit management companies from conducting official meetings of the community or its governing body. Remove waiver authority provided in Section 6. Eliminate the registration fee imposed on common ownership communities in Section 7. Thank you for your time and thoughtful consideration of these recommendations.
All right. Good evening, Madam Chair and members of the committee. Thank you for the opportunity to testify again. My name is Michelle Jackson. I'm a unit owner at the Elmont Condo in Baltimore, Maryland. I strongly support this legislation, creating the State Board of Common Owner Community Managers. Maryland's Common Ownership Communities house hundreds of thousands of residents, and the quality of community management directly affects our financial stability and housing security. Licensing community managers is an essential first step, but licensing alone is not enough. To ensure real accountability, I urge the committee to strengthen the bill with several key amendments. First, the board must have the authority to impose fines and penalties for violations. Without enforcement, bad actors face no deterrence. Second, require disclosure of all lawsuits filed against managers or management companies within the past 10 years. Patterns of litigation reveal risk homeowners deserve to know. Third, require disclosure of business relationships with vendors, attorneys, and law firms to prevent conflicts of interest that can harm communities. Fourth, prohibit management contracts from forcing associations to pay attorney fees or legal defense costs for lawsuits involving the management company. Finally, require the minimum $5 million insurance bond to protect communities from fraud, embezzlement, and negligence. This bill strengthens with these amendments will bring long overdue transparency, professionalism, consumer protection to Maryland common ownership communities. I urge its passage. And also thank you so much, Delegate Holmes, because I'm new to the Homeowners Association community, and I was very pleased to see that we had an elected official that was making sure that homeowners and HOAs concerns were addressed. Mm-hmm. And I want to concur with my fellow homeowners associations, because with my building we are incurring the same issues.
Thank you very much. Seeing no questions for you ladies, thank you for your testimony this evening. We'll now move on to the unfavorables. Brenda Wakefield.
That's okay, Oh, thank you, Madam Chair, Vice Chair, and the committee. My name is Brenda Wakefield. I serve as Secretary of the Community Association Institute's Maryland Legislative Action Committee. I am here with several colleagues to express our opposition to House Bill 853 that proposes that any individual providing management services must hold a full or limited license requiring examinations, background checks, mandated education, and fees determined by board regulations. So over 50 management companies are in the state of Maryland, and many of them are minority-owned, women-owned small businesses, and I'm one of them. So the fiscal note for House Bill 273, the prior version of this bill, projected that licensing fees would need to be at least $850 every 2 years to support board operations. So that figure may appear modest, but for context, I want to share with you that I manage 36 units across 3 associations, averaging $550 per month per association, or approximately $19,800 annually. Most management contracts limit fee increases to 3% per year. So I can't adjust management fees to account for increased expenses, and I can't absorb these costs. As a CAI certified manager, I already invest in training for ethics, governance, finance, areas directly addressed by the bill. So should House Bill 853 pass, the costs of this education would effectively double overnight. This legislation would adversely impact my clients, the homeowners, by reducing access to affordable management services in favor of larger firms with higher fees. In a legislative session focused on affordability, introducing additional costs undermines efforts to keep association dues manageable. For small business owners such as myself, this legislation imposes significant barriers to continued operations. Self-regulation has proved effective. I respectfully request you issue House Bill 853 an unfavorable report. Thank you very much. And I would like to say we did submit written testimony that directly addresses many of the points that were made. So thank you for letting
Thank you
me
for
be
that,
here.
Ms. Wakefield. I see no questions for you. Thank you for your testimony this evening. There are no further witnesses for this bill. That concludes the bill hearing on House Bill 853 and concludes the bill hearings for today. We are adjourned.